Good morning.
All right. Good morning, everybody. It's a good turnout we have here today. Been an exciting time in our industry, to say the least. Our thoughts are with everybody that's with the recent flooding down in San Antonio and a lot of rain in Houston. So our thoughts with not only them, but then everybody around the world with the recent events. So our thoughts are and prayers are generally for everybody's safety there. I'd like to start with intros around the room, like we normally do. I'm John George, the attorney co-chair on the Broker Lawyer Committee.
Brian Watts, attorney.
Rach Rizal, attorney.
S. J. Swanson, attorney.
Ron Walker, I serve as a broker member here and co-chair.
Christy Tatum Jansen, broker member.
Mary Minor, broker.
Tony Malley, attorney.
Diane McCoy, broker.
Melissa Haley, broker.
All right, and we have Lee York, who will be back here in a minute. And then
We have Amy and Darlene. Are they online?
let's see.
Amy can't make it today.
Okay.
And I saw Darlene.
Okay, and we have Darlene Fairchild on Zoom. Welcome there. And as we go around the room here, if you can introduce yourself as a guest, and if you haven't signed in, please make sure you sign in if you come in. And if you have any public comment on non-agenda items, please note that as well.
I'm Tracy Schwartz, broker.
Candy Cook, broker.
Erica McPhail, broker. Kirsten Crawford, broker.
Tom Holland, lawyer.
Lori Connor, attorney with Franklin Trail.
Chelsea Buckholz, Executive Director for TREC. And John, I just have to tell you that one of my talking points I keep using here lately is Google, John George, YouTube. 19 seconds, it'll appear.
Thank you.
Thanks for doing that.
Brittany Ramirez, Assistant General Counsel for TREC.
Nasa Burgess, Deputy Executive Director for TREC.
And Abby Lee, general counsel for TREC.
All right. And is Brittany's first meeting with us today as the counsel? Lori introduced herself.
Sorry.
Is Commissioner Renee on
No,
online?
not today.
Okay.
Well, of course, as I mentioned, a lot has happened in the last 6 months. You know, we left off our last meeting with some new contractual language that, of course, is on top of everybody's mind. And we're going to dive into that today. I've seen a lot of good in the industry, seen a little bit of bad, but a lot of people caring and paying attention to these contracts. And I think what has happened, at least definitely in the last 6 months, has highlighted the importance of what we do on this committee. You know, we sometimes joke that commas and periods matter, and ifs and thens, and how we phrase things can really have an impact not only on understanding, but the industry itself and how the industry is practiced. So it highlights, and I know everybody on this committee appreciates the magnitude of what we do. And as we go through this today, I know we have a lot of passion on this, and I think we have and we always do, give it the weight it deserves. Before we jump into the agenda items today, I do want to recognize and thank the outgoing commissioners. You know, we have new commissioners with us, but Barbara Russell and Jason Hargraves have left, and I want to give a particular thank you to Chair Scott Kessler. Scott was a champion of this committee. He attended virtually every meeting. He gave input. He was very active and involved. So if you're listening, Chair Kessler, we very much appreciate that. We have two new incoming commissioners, J.B. Goodwin and Christy Davis are the new commissioners that have been announced. And Mark Woodruff has been now the new chair of the commission. So we're excited to be able to work with the new commissioners, and we have one more meeting left for a few on this committee. So we'll wait till our last meeting there, but things are evolving like they always do. And we'll go and jump into the first item of business here of the public comment on non-agenda items. Do we have anybody for a non-agenda item public comment? All right. Seeing none, we'll jump right into the next agenda item number 3. which is a report on the 2025 legislative session. Who is the lucky one that gets to highlight that today?
I can start it out. This is something that our government and strategic communications director, Summer Mandel, put together. It's a list of bills that we thought would be of interest to this committee. Really only one that has either a direct impact, one bill that has a direct impact to our contract forms. That's the first one here, Senate Bill 2349. I do have a few extra copies if anyone needs another copy of this. Yeah. The rest are not anything that require any express changes, but really are there just for your information. And I know there's going to be discussion about anyone else. The Senate Bill 1968. I'm happy to answer any questions to the extent there are any.
And I'll highlight a few of the changes that were made. I'm not sure if these are in order of the sheet, but going through House Bill 2468. And this is revises the requirements related to the Public Improvement District notice, the PID notice, as we often refer to it. And it limits termination right. We have like the water district notice, mud notice, that if you don't provide it at the time you execute the contract, the buyer can have an out essentially all the way through closing. The similar termination right was tied to failure to provide the public improvement district notice. And instead of being all the way through closing, it was a 7-day right after you received the notice. This modifies the language slightly to say, it keeps it at the 7-day termination right, but said that only comes out, you only get that termination right if the municipality has filed has filed the proper certificate in the county records. The municipality or the county has filed the required certificate. So I know we have a lot of concern that we're hamstrung on this committee that we can't change Texas law. Right? Texas law is what it is. As much as we want to change some of the requirements of the mud notice and the PID notice, we're stuck. But this is one of those that at least the proper documents will have to be filed by these organizations. And I hope that at least next legislative session, maybe they look at the mud notice, the water district notice as well, because there's some confusion on whether the proper documentation is filed there. But this is, I think, a step in the right direction. And it helps provide more notice and disclosure and limits rights unless things are properly filed.
Do we know, does anybody remember who carried this bill? If they get reelected, we ought to be talking to them.
I will look really quick.
Before, if we could just a note for a year and a half from now.
Real quick on there is one bill that impacts our forms that are in here today. That is 2349. This is Senate Bill 2349. It's new language regarding the flood disclosure notice and temporary leases. This one will go into effect September 1st, 2025. And it exempts leases that are a term of 30 days or less, or leases that are 90 days or less and tied to a sale contract from having to provide the flood disclosure notice. And I think most in the industry, boots on the ground, thought it was silly in leaseback situations using our TREC forms. Why does a buyer have to provide a flood notice to the seller who owned the property right then? And so you'll see in our draft forms here that language is struck out now that there's no longer a requirement to provide it.
I did want to bring up, we're ready to look at it yet. It are not required. It is not, will not, or shall not. I don't think that ultimately changes probably what we should do by removing this, because it doesn't make sense to leave it in there, because it ties to the requirement in 92.0135, which is the statute that's being changed. But there is nothing stopping a seller providing a buyer with a notice related to the lease, even though likely they have provided it, in conjunction with the sale. But to be picky about words like we are, it's not, we're not mandated to remove it from our form that we just added it to in the last legislative session, but,
And I think that's a good discussion point, and it's from the buy side to the sell side, which the law, and let's pocket that. So I think when we go through the rest of the forms, we can bring that up and discuss that there. But that is a valid point on whether disclosure still should be at least highlighted in the contracts, if nothing else. Senate Bill 2550 modifies certain items for disclosures or removes some disclosure requirements when a sale only includes groundwater or surface water rights. And it modifies or amends several code sections in the natural resource code and the property code, and then the water code that says you don't have to provide the notice to purchaser regarding coastal property or annexation, the PID notice or the MUD notice in situations where the sale only involves sale of groundwater or surface water rights. So it doesn't directly impact our forms. Our forms are broad in terms of the notice itself in paragraph 7E4, the addendum for property located seaward of the Gulf Intercoastal Waterway. Nothing in this language changes it. It just removes the requirement to provide the notice in that limited situation. Senate Bill 17 is a bill regarding the acquisition of real estate by certain aliens and foreign entities. This is an interesting read, and it's almost dives into some reasoning that the legislature looked at on why they want to limit or prohibit transactions to various countries, including China, Russia, Iran, and North Korea. I don't think there's anything we need to address on our committee today, but just to acknowledge that that is out there. One bill that I'll wait to dive into when it's appropriate, that I think it's going to have an impact on a discussion we need to have today, is Senate Bill 1968. I believe I have several different concerns we need to address in terms of our potential changes to our forms. Senate Bill 1968 does several things for the governance of TREC, like it now would require associated brokers to be tied to their broker if they're getting paid by a broker and if they have a continuing relationship with them. And I'm paraphrasing the rules, but if that's the case, then you would have to make a filing with TREC. So if a consumer looks up who's this associate broker working with, they'll be able to find that broker. And there's some other rules surrounding that. Then there's also requirements now that effectively we've been saying generally that it's repealed subagency. And subagency was really just a definition in one part of the code. You know, if you look at the statutes and the rules, there's very little that actually dealt with subagency outside a particular statute in the IBS language. Now it's removed that and effectively said there's no subagency in Texas. And instead it said you can open up a home and show it without representing either party. In the past, you could represent a buyer or a seller, and that may give rise to then a subagency situation of representing a seller in cases where arguably it didn't make sense, right, of how to do it. And the problem that's coming up with this is if you open up a home, there's restrictions on what you can do if you're not representing either side. And the biggest one is you can't give any advice or opinions. You can confirm square footage, you can confirm paint color, some specific details, but you can't give any advice or opinions. Once you do that, that's a real estate brokerage activity that then will give rise to representation. And as soon as you are representing a party, then there's a new requirement in Texas law that you must have a written buyer's rep signed by that buyer. And there's two trigger points for that buyer's rep. It's one, before you tour a home, when you're representing them. So we're not in the situation where you're just opening the door and not giving any advice or opinions. Where you're giving advice or opinions. If you're showing a home, you have to have a written buyer's rep in place. And then the second trigger, if you never show a home, somebody's out of town, out of state, or just doesn't look at one, The second trigger is before you actually submit an offer on behalf of that buyer. And similar to the rules that the industry as a whole has been working in now, this has specific requirements that must be met in that buyer's rep. And when we get to the contracts today, and we don't have any proposed language, but a discussion point needs to have, I think we need to have on, does this then give rise to a need for us to look at and go back on our longstanding policy of not having representation agreements? And because of these requirements and such, there's, it's something that is going to be hotly debated, I believe. And there's good arguments on both sides. And I don't have a real firm opinion because I'm still digesting what's going forward on that. But I would like to solicit everybody's opinion and thoughts on that, knowing this is new and this is something to
Just one
think
quick
about.
question. Abby, has the governor signed this bill yet? So
So I believe it's already law though, because it was signed, it was sent to the governor on May 22nd. And I believe that's before the 10-day rule.
That was day 0, we learned out. We
Is
learned, so that.
Oh, so
it
that's
actually
triggered it.
Veto period.
Okay. So under Texas law, if something's sent to the governor before a certain date, after an expiration of time, it will become law whether he signs it or not. And so this was sent to the governor on May 22nd, and with the calculation of dates, he needs to sign it for it to become law. And so if he doesn't sign it, then it will not be. And I checked yesterday and he had not signed it yet. Is that still the?
Right.
Okay.
I heard he was going to Denton and he's signing in Denton on Monday.
Yes.
Because I know people are going. So.
So this is something that we won't be able to resolve today. We have a lot of business to do today. It's something I think like we did with the commission language before the lawsuit, the lawsuits or the issues were final. I would just like to get a temperature if you want to give one. But we had the opportunity with our next meeting before the commission meets to further expand on this topic and to if we want to, at the end of today, look at even a potential subcommittee to a working group to look at it and dive into it a little bit deeper. Because there are a lot of nuances to it. It's been a longstanding policy that we don't draft buyer rep or listing agreements. But I have some rules to highlight of some past history, at least on the listing agreement side, where the legislature has said, if you promulgate a listing agreement, here's some requirements about it. So it's at least been a thought there. I would like to reserve that to the end because we do have a lot of other business to get to today. Ron, any?
no, I think it's fine. Get into it.
And this would be effective January 1.
Correct. This is not like most bills that would be a September 1st effective date. This, if it was signed by the governor, it would be a January 1 effective date. And that would allow us time, think about a form, right? A form will take time to work its way through. We would need to take action at the next meeting to be able to have it in line, to be able to be in place before January 1st. And it would be no small task if we choose to take it on. Right? This would be a big task to do. But it definitely deserves discussion and all of our collective thoughts on that. So those are all the areas of the particular bills that are passed that I had to go over. Does anybody else have any comments on the legislation?
Just a question, if it's appropriate, and I don't want to put General Counsel for Texas Realtors on the spot, but would we at any point ask for anything that's going on regarding this particular bill and any action that Texas Realtors is taking that might affect what we conjunctively do?
I would say yes and no. We always want input. And this bill was backed by Texas Realtors that went through. It was part of the bill that also fixes TRELA, the things that need to be changed in there. And so they will have definitely insight and stuff to be able to inform what we do. And I anticipate changes on their forms as well. I will say, I want to keep in mind that not everybody is a member of Texas
Right, that's
Realtors.
what I was just gonna say.
And what the concern that raises in my mind is this is a requirement that is universal across the board now to every license holder. And I don't want to jump out too far ahead of thoughts, but I have a lot of fears of people just pulling forms offline. And in Googling or ChatGPT or whatever it might be, or taking inappropriately Texas Realtors forms when they're not Texas Realtors.
Exactly.
But I know there's discussion on a lot of different things, even on those topics that are happening that may impact our decision as well. So yes, absolutely. And Lori, I know you're behind Diane there, but we will be, with your guidance on that. And when we get into it, maybe if you give thoughts on what Texas Realtors is looking at doing to it in light of that, that'd be great. Okay, so we'll jump into the next agenda item with the BLC working groups. The two main working groups I believe we have to go through today is the compensation and the disclosure working group. Both, I believe, will take significant amount of time to jump in there. And Ron, being a member of both, I believe, do you have a preference on which one you like to address?
No, I guess we can just do it as it appears in the forms. I guess you can take the disclosure issues first. So I think that's the page 9 of the material. So I think Brian Sledge may be online. Yes, okay. He may be able to chime in if necessary as well. So if we take actually what's on page 12 of the materials, the water notice first. This one you've seen. So there were, the committee met and then went through the water notice. It's essentially the same form as was presented to you in the fall, but I think there were a number of good changes in there that went through, and the working group really did a good job of going line by line, and with Brian's help, taking out some language that may have been a little bit confusing at first. So, for example, you'll see under definitions, we shortened the definitions, but took out what was really commentary and put it below as a note. So you have the definitions clearly stated in a short, concise way, with some additional sort of comments out there that might be helpful to the reader out there, since this is an issue that we're assuming that a lot of people are not generally familiar with.
And Ron, if I recall, the groundwater itself at the very beginning is not defined in Texas law elsewhere. So one of the things we had to do was come up with our definition to use. Right.
Exactly. So I think that with Brian's help, we were able to focus on the traditional definitions, the ones that were used in case law, various things like that. So I think these definitions are pretty solid and commonly used out there. So that's the reason why we adopted these. And I think, again, these are probably the ones that are used more in terms of both the regulatory side and in the industry itself providing water. And then, of course, we went through the questions there beginning in number 2. The rest of that is essentially the same, although there are a few changes there to make things a little more clear. And we went through all those various changes. I don't know if you want to go into all the details there, but substantially everything is essentially the same, other than just some words.
And I have a few things to put on the table of maybe some clarifications or changes if whenever you're ready for those. Just to highlight, I thought that the form was put together very well. Was not an easy task, I know, especially from where we started. And Brian, thank you again for your help with pulling this together and pushing this through. Some small things here that I have is that it's a reason we don't have a definition of surface water. And surface water comes up through there, and is, if we're looking at the types of different water, seem to be potentially a gap. And we say surface water elsewhere in the form. I don't know if that's something we would look at.
It's in the title.
Yeah. If something we consider adding a surface water, the definition of surface water.
I don't have. Good, Brian.
Nope.
Oh.
Okay, we'll see, make sure, Brian, once you get connected and can hear us, let us know. We're discussing the disclosure form now. So, we'll circle back. So Brian, as soon as you hear us, let us know, please. But I thought that might be
Hey,
something to
Ron,
add.
can you hear me?
Yes, sir. We can hear you now.
I'm sorry, I got kicked out of the Teams meeting right when you started on this agenda item, and I had to call in.
We're just saying how horrible this is, and we just threw it out. So we're done. No, I'm not sure where you jumped out there, but Brian, thank you for all your work on this and pushing it through. And I know Ron and the rest of the team, and you put in a lot of effort on it. And so it looks really great. And I just have a few nitpicky things that I'm bringing up about potential additions or clarifications in it right now. And the first one we brought up was, is there a need, and should we add a definition of surface water to the document?
I thought we had some, hold on 1 minute, let me catch up here on the materials.
We have surface water rights that are defined, but we don't have a definition of surface water in there. So
I don't think there was a reason why it was left on, other than we just didn't about it.
Well, we did talk about it, and the reason we didn't add it is because, you know, there is this, again, look, if you want to look at 3B is where surface water rights is defined, which it actually requires a certificate of adjudication and amendment to the certificate of adjudication or permit. So it's a thing, you know, the surface water rights are a defined thing by the TCEQ. I mean, and I guess we could talk about surface water doesn't have rights, but it's not, what's relevant is the rights. And so that's why we're really not talking about just surface water, even in the title. We're talking about surface water rights, which are a defined term, again, by another agency. So we did go around about that.
We define groundwater, but not groundwater rights. It just,
Well, groundwater is not defined by statute, and so we defined it.
Groundwater is defined. Water.
Let me ask this question first too. Are we looking at pushing this through today?
if that's the will of the committee, I think so. I think that would be our recommendation to do that from the task force.
And Brian, would you happen to have handy definition of surface water rights that you could share that might fit if we were to entertain it? Or excuse me, surface water. My maybe it was previous draft, or maybe that long one that was originally presented by you and Charles Porter. Might have had one.
I can look. I don't see it.
Yeah,
Yeah,
I'm
this
just
is kinda long.
looking through the addendum.
One of these, I have a question. Thinking of the user of the form,
yes.
Yeah.
if there's not a definition of surface water added, what confusion is there? Wherein lies the problem? Not thinking about attorneys, thinking about the average user of the form.
Are you saying they're gonna wanna be told what surface water is?
No,
I don't
they
think,
care.
I don't think
All
we
they're
need it.
Dealing with is the rights, and the rights are defined. This is a form about rights.
Whereas the water well issue and the groundwater is a separate one that is truly impacting kind of the laser focus, right?
I just don't think
water on
the
your-
average user is gonna say, what is surface water?
I don't think the average user is gonna get this form at all.
That's
Is the answer groundwater is privately owned. Surface water is owned by the state, and people may have rights to use the surface.
But are they gonna ask the question?
Well, surface water is, Brian, correct me if I'm wrong, I'm reading from another source here. It's water that's located above ground and includes rivers, lakes, bays, ponds, wetlands, marshes, canals, estuaries, and reservoirs. So it's just everything that's above ground, but it doesn't necessarily give you rights to those. So for example, you can impede a river or lake that's generally open.
Yeah, I mean, I'm not opposed to adding it. I'm just not sure that
It helps.
Yeah, and I'm just SJ's point,
I think the
is
form's
we have the
gonna be
definition of
overwhelming
what
for them.
matters there.
Yeah.
Okay, Diane?
If we consider the very first line of this form that is in bold, this notice is a disclosure of seller's knowledge about groundwater and surface water on the property. So to Lee's consumer point, this is an addendum to the contract. And if the seller says, I don't know what surface water is and what my rights are, do we owe it to them then, to your point,
It's not an addendum.
to define
It's not
it?
an addendum.
Not an addendum. Neither is.
It's a notice.
Well, at the bottom, am I not seeing track number 60-0?
Yeah, it's our form, but it's not an addendum.
Yeah, notices are not part of the contract. Addendums are, but not notices.
And even so, it is going to be signed by the seller?
Yes.
So if it says it's the seller's knowledge, do we owe it to them to define that? It's a question, since we did take the time to define the others.
And let me just take that question to the next, because I will highlight several of my other potential concerns, I think, too. How is this going to be implemented, right? It's not an addendum, it is a notice. Is it, I think, to Diane's point, if it's a required notice, we put it in the contract, that affects its operating the same concern as an addendum. It's
So that's
required to be
the
out there.
second part of, if you go to any of the contract forms and you go down to paragraph 7, the last paragraph, either 7K or F or something along there. So you go on page 19, for example, you'll see paragraph 7. That would be what our recommendation is, to add that into paragraph 7. That would be the trigger of delivering the form.
And so, and this will operate with termination rights attached to it if it's not provided. And
Right.
so it does, I think Diane's point, even though it's not technically an addendum, is still the same point, because it's a required document that has substantial rights tied to it.
Yeah. I don't mind, actually.
Hold on. This may be used. Again, I'm going to be the may and shall police. This may be used, and it may not be used.
From a practical application standpoint, the realtors are going to be in a position of having to educate the customer, required or not. And the ability of a customer to say, I do have the certificate, is vastly different from them saying, I can legally define that I have the rights. That's a whole different ballgame I'm equipped to do. But yes, I have the certificate. Will be a cleaner slate.
Ron, or
Yes, sir.
There's also,
John?
sorry.
Sorry.
Go ahead, Brian.
I think I'm trying to go through here and see how the term's used in every spot. But I think if we went back up to our definition section at the beginning of the water notice, and we kind of restructured this to simplify what a water course was. But I think the solution here may be that as simple as saying that adding a definition between groundwater district and water well that says surface water means water in a water course. And then we define water course right 2 down. But I want to make sure we don't have any use. No, I'll let that sink in for 1 second, but I'm just trying to go through and make sure that works in all instances here.
Well, before we maybe spend too much time to go on a definition, if we let that sink in while we go through the others and then circle back around and see if we need to, because if we decide not to put a definition in, then spending the time to try to draft one could be time not well spent.
Okay.
The next one I had with water course, From my understanding, it's a natural, I'm throwing out there, do we need to add natural in front of water course? I mean, looking at the case law and it seems to be when they talk about water course, it being a natural water course. And one case in particular that I cite to a lot is the Jones versus Zerfrost, which is a San Antonio Court of Appeals case, number 04-14-000083. This out of January 7, 2015. It defines a natural water course is considered to have bed, banks, and a permanent source of water supply, although it is not essential that the water flow all the time, which essentially matches the definition that's in here, except for the use of the word natural that's in there. So, Brian, do you have any insight on that, of whether that's a key difference from your perspective or not?
Whether natural is?
Yeah, whether add natural to water course, if there's a distinction there, because a water course to me could be other things, right? In where the law, at least that I've seen, is discussed as a natural water.
It doesn't have to be natural. For purposes of this form, it doesn't have to be natural. For example, if you had an irrigation canal coming off of a natural stream that's transporting state water through the irrigation canal that's hand dug or machine dug, that's still the same water we're wanting to talk about on this form.
Okay.
Yay, rice farmers.
And there are thousands of examples of what I just said.
Okay, and so with the form itself, we're doing in the broader context, and know as a public, as we're talking about this, there could be applications that more narrowly look at natural water courses versus a general water course. But I thought that too, there might be some distinction there that we need to make it broader. So any thoughts on that issue?
Well, but not putting natural makes it broader.
Correct.
Putting natural.
Yeah, so I've raised it, but I'm not pushing the.
You know, and again, the thing to remember, just as a point of information for everybody, the whole point of disclosure notices is to bring the issue to the attention of the buyer, to the parties, so that then they can go and do further investigation of the information they have about whether they want to proceed or not.
And don't practice law, license holders. This is a lot of stuff, a lot of minutia, as you can see, a lot of time has been spent on this committee getting ready, and a lot of practice in this area. And this is tricky, but we're bringing it to light so that discussion can be started and be had with the appropriate professionals.
And to that point, the more definitions, the less agents have to look things up and try to explain for the consumer.
Well, they shouldn't be trying to explain.
Well, they shouldn't.
They don't know.
But that's why, look at all the definitions we have. And the more definitions, more information that we can provide to the license holder in answer to the consumer, the safer we're making it for the license holder so that they don't overstep their bounds.
Yep, it helps get things on the table, and the script needs to be had of this is here, but I can't advise you. I can't tell you about your legal rights, but at least get some of it there to start the conversation and be a tool in the toolbox for them.
But I mean, it has also been the position of this committee, which I think is a good one, is that superfluous information does not need to be included in anything. That's actually one of the things we did in our committee, was remove some stuff, as Ron started off in the description, that's superfluous information is confusing to agents and consumers. So,
and we're going out on a new limb with this type of notice to begin with, right? For the disclosures outside of what was already in the contract. So that's in the back of our minds there for sure. Looking at 2B, in number 3, we in 2B, it sets out, is the seller aware of one or more water wells on the property? And I'm concerned there may be a little gap here in that wells that may be in use but may not be in use but have not been capped, plugged, or abandoned. So we have the number of water wells known as sellers X, number of water wells that are currently in use, or this number. And then it says the next one, number of wells that are known cellar that are not currently in use and have been capped, covered, plugged, or abandoned. And so I think there's a gap there of ones that aren't in use, but haven't been properly capped, fall within there.
So you want to change the and to or?
No, he wants to turn number 3, B3, into B4. Create a new B3 that says the number of wells known to seller that are not currently in use, but have not been capped, covered, plugged, or abandoned.
I don't have wasn't recommended, I saw the gap. And on that one, it adds more words and makes it longer.
Yeah, I think you could calculate it mathematically if you know what 1, 2, and 3 are.
No, there's a whole, no, his point is there's a whole category that's not being talked
Right.
about.
Why do we even need 3? I mean, it's like we're just trying to do math. I mean, if you know how many wells there are and you know how many you're using, then there's this many left that you're not using.
That's a fair point. I see you at least saying, do we even need that element there? Because we're saying it's this many and this many are in use.
Yeah, because it's going to be one of those, right?
Well,
Right.
the ones not in use,
Right, or
have
going to,
any of them been kept?
or covered, plugged, or abandoned.
I mean, if we keep 3, I think we have to address what you're saying because that's legit. I just don't know that we need it.
I would be fine with taking it out because it's by math. There's this many and this many are in use.
Why would,
Ron or Brian, thoughts on, or anybody else thoughts on that?
I think that 3 is necessary because, but I think you could change it to be wells that are not currently in use, comma, including capped, uncapped, covered, uncovered.
That's interesting.
Capping. I mean, some folks may consider that an abandoned well isn't a real well, but we want to know that those are there because things happen with those. You know, people pour stuff down them. We've all seen the videos of live children and animals getting stuck in them. But I do see the gap that you're talking about.
I do like that.
Maybe it's just not currently used, including capped, uncapped, covered, plugged, or abandoned wells.
So
Would
everybody,
it always follow, Brian, that 1 must equal 2 plus 3?
Yes.
Then you don't need 3. And I'll just tell you, there are going to be people that fill out this form and they get their arithmetic.
but wouldn't you rather know
Yeah,
that there's some capped wells
Yes.
yes.
than not? And the answer is yes. Thank you.
I like the use
And
of
then
the word
just
un-
delete the that are not currently used. Tell me how many capped wells there are.
Well, wouldn't you also like to know that there's wells that are not in use?
That are not capped.
Sure, math doesn't
Yeah.
work.
I mean, I just looked at a place the other day and the real estate agent said, yeah, they're not in use. And I actually asked, are they capped? Anyone go in and fill it? I don't know. They're just not in use.
It's probably what the
That
seller
was on
says when they ask
250
them.
acres in Walder.
I mean, that's either a plus or a minus, depending on what place is and what you need to know.
So you want to, if we're going to do something like this, we would say the number of water wells known to the seller that are not currently in use and have been capped and have a line, covered a line, plugged a line, and then abandoned a line.
let me throw out a suggestion that may bridge the gap here. What if the first one, the number of total wells, water wells known to the seller is blank, of which blank are in use and blank are not? And then just add number 2 being what's been capped.
But why don't you just
covered,
strike,
plug, or abandoned?
why don't you just strike 1?
I was kind of thinking what it was, just strike 1.
I like what John said. Would you say it again? So keep the number of wells.
I like that.
That's
Y'all suggested too, but the number of wells, water wells known to seller is blank, of which blank are in use and blank aren't,
I like
in the
that
proper
better.
terminology.
More information.
If you get rid of 1, saw Brian,
Mr. Chairman,
his problem, they can't count. You don't even, 1 doesn't have to equal 2 plus 3.
Yeah, I kind of leaning over there because it's a little, and then because you have one that still needs to add 1 + 2 = 3 with what I stated. I like that.
Say it again, what you're liking?
What Tony said.
Getting rid of one, because then there's not even a math issue.
Okay, if we strike one,
That's still,
You-
that doesn't add up totally. You have to add in something.
no, because you're still getting the number in use and the number not in use.
No, that are capped,
Well, then we break out the other one to what's been capped, right?
capped or not capped, yes.
Yeah, you can make number 2 like what, John is saying.
Yes, which is the current number 3 would be number 2, and it would say, not currently used, those that are capped, those that are not capped.
Can we, maybe we put it on the screen, Ron?
Okay. Let me get here.
Well, Ron's doing that, the kind of a global thing for everybody to think about. In the other seller's disclosure notice, there's the yes, no, or unknown boxes, or you put Y, YN, unknown. In this form, it adds a little length. We say seller may write unknown or leave blank if unknown. I think we may be able to shorten it by putting that same thing of yes, no, or unknown in each spot with the check boxes.
Except for ones that need numbers.
Well, the question would tee up whether it's yes, no, or unknown. So it wouldn't change any.
You're just gonna add an unknown box.
And remove
It would be,
this sentence right there, so the one I have circled, because right now we write it out multiple times on seller.
yeah,
Seller may write unknown.
you do it up top, cover the whole page.
Or no, it'd be each time it appears, because that appears multiple times. So yes, no, unknown. Just add an unknown checkbox
With the
there.
explanation, that seller may write unknown or leave
Oh,
it blank.
yeah, we can look at
Like,
that.
pull that to the top in the instruction.
So you want to strike one.
Okay.
Aren't you here, Brian?
We had that discussion, and we ultimately came to the conclusion that if they're either aware or they're not aware. If they're not aware, I don't know what the difference between being not aware and unknown is.
Well, no, and I'm not making that distinction. My distinction is just shortening the form to match how we typically do it of yes, no, unknown, instead of having it written out several times in here that you write in unknown. Just make it a box to shorten it. It's more not substantive. It's just.
Well, on this one, number 2B, why would you need an unknown? You're either aware of this or you're not. It's the same as the seller's disclosure notice. That's the same question.
Right. But the
Yeah,
box
we copied it from other parts of the current form.
It doesn't match the other language.
I'll pull it up. I was raised it while you were pulling that up. Let's get everybody thinking about that. If you look at the seller's disclosure notice in the meantime. Well, actually, Ron has it up.
That it's fine with yes or no.
We can go away from that.
Okay, so Ron has, we're looking at 2B here. So if we strike number 1, and then did we break number 3 into 2?
So the question here is, under number 3, do you want to break it up into subparts?
Yes.
Or just have it, the ones that have been capped?
No.
Can I
No.
chime in on that, sir?
Yeah, go ahead, Brian.
Eliminating B1 is fine. I would amend B3, unless we want to put a bunch of definitions in there to try to describe to everybody what a capped, a covered, a plugged, or an abandoned well is, which will take a lot of language, I'll promise you. I would just say the number of, on what will now be B2, the number of water wells known to the seller that are not currently in use, comma, including capped, covered, I would insert the word open, plugged, or abandoned wells.
Well, but that kind of makes sense.
It does, but it also doesn't, so if the ones that are this,
It doesn't
it doesn't tell
distinguish
you what's not.
between the ones that are and aren't.
Yeah, I
Mhm.
think we need,
But it makes
Yeah.
them,
Mr. Chair,
it
you're
makes
trying to
them
get them to
aware
say that,
of what you
just to say how
said.
many that are not in use as well.
correct.
I mean, I like that.
Yeah, I want all 3. I want to know what's in use. I want to know what's not in use and not covered, et cetera, and what is not in use and is covered, capped, blah, blah.
You say number 3, the number of wells that are not currently in use is blank. Of that number, blank have been capped, covered, plugged, or abandoned.
Yes, we've been talking about that. Yes.
That sounds great.
Did you catch that, Ron?
Yeah, it did, but
I still think we need
See,
Chairman George's
it's gonna be the same number.
gap issue covered, and I think
It'll
the
be the same
solution
number
to it is.
if they're not in use.
If a well is not in use, is it possible to have a well that's not in use that is not been capped?
But we're
Correct.
talking,
Yeah.
Yes.
We want
So,
to know.
wait a second.
That is the problem.
Hold on.
Yes.
Hold on. Brian's suggesting adding open to this list.
No.
Well, why
I know
not?
he is. That's,
Let's
A
type
lot of
something
people
out.
don't-
It is
But-
one.
Let's type out the options. Let's type out what Brian is saying, and then let's type out so let's look at what SJ is saying.
Sledge or what?
but open is
Watts.
opposite of capped.
Because
The
he liked
other
what you said
option.
too, both Brian's, I think.
The other option.
Okay.
This is the Brian rule.
So what do you want to do?
Number three.
Let's have Brian Watts describe his
Okay,
thought, and let's get that
number
down on
three.
paper to look at.
Keep number
Fine,
three.
Brian.
The number of water wells known to seller that are not currently in use is blank, period.
Okay. I'm gonna,
Check a Word document, maybe.
Out.
yeah, I'm gonna go to old document here.
And you do not have the word open in your definition, Brian. This is a lot of words. Brian, you do not have the word open in yours, right?
So.
The number of water wells known to seller that are not currently in use is blank,
But after that, most of it's natural.
period.
Oh, yeah.
Of that number,
It's all the two more little issues.
comma, blank, have been capped, covered, plugged, or abandoned, period.
So what about the?
Period after abandoned.
What about the open one?
No, because open is the opposite of that. And this is,
Open, the only reason I was suggesting open was because Chairman George had suggested that there was a gap there. I mean, you're really not supposed to have an open well out there. You're supposed to either cap it or cover it by law.
What if we add open to the first sentence? The number of water wells that are open and not currently in use.
no,
But then it's,
that's
Yeah,
different.
sorry.
That's different. That takes it out of that definition.
Not currently in use is not the same as.
Well, the next sentence.
That are open and not currently.
Oh, I see what you're saying. Okay, yeah, you're right.
So it's not, couldn't be of that number. I mean, if you really want my vote, I think this is good. I can live with it, but I think it would be better to add on to it what you originally said. Of that number, X have been capped, covered, plugged, or abandoned, and X have not. But, and yes, that should be mathing.
Okay. All right, help me here.
Fine.
Is the thing that we really care about is, hey, we're worried that there are unopened wells.
No,
that Jessica Mc-
what we want to do is tell buyers what's out there. To do their own research. That's what we want to tell them. It's not just about danger, it's about the benefits of wells. A well that hasn't been capped might be able to be reworked, or it might just be not being used because it's expensive to run a generator to pull the water up.
It doesn't just do that if the math isn't matching up. If we say they're or not in use and two have been capped, it says you need to go figure it out.
That's right.
Latra, I feel that same way. And Brian, the issue that I brought up originally, in my mind, is addressed with this language here because it necessarily, there's not a gap anymore. It's just, it's math that the buyer can do.
It is.
What
but
if you added
If
that?
the seller is disclosing, then I like the seller to be the one disclosing.
I
and
like
not
that
the
one.
math. That's what I like.
We do
the
have
best.
to count.
I want them to disclose, X are open.
Look, the thing.
Well, and actually, I wouldn't say open, I would just say are not capped, covered, plugged and abandoned, okay? Because the definition of open is
Oh,
We should do this.
It's, you have to define it, and I don't wanna define it. Are you following me?
Yeah, I am.
I'm gonna actually
Yeah.
spell it out again.
I think this is what we should do.
I think this changed. Oh my God.
I think or not is logical, but I think for disclosure purposes, and if I'm litigating this, I would like that part of the clause to say, and X are not covered, blah, 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 because that is super clear and the seller put it out there. And of course, our goal is to avoid litigation, and I think this would help avoid litigation because it would be clearer.
So
I mean,
Sledge, he's,
Beautiful.
we've been having, you need to readmit him. It looks like he got dropped again.
You dropped him again?
well, already hung up on us.
He does that.
We get more done after you've dropped.
I don't see him now. There's no BS unless it's a longer lived.
19 more.
Is that what you like?
And
Yes.
I like it.
I like that. Brian, if you're
I
back
like
with us, you pick up?
Yeah, sorry, I've joined in, back on where I can see what y'all typed. I think that's fine.
So we're gonna
Thank
keep,
you,
I
Brian.
think that's actually better.
and we're gonna get rid
Because
of,
you could have a well that's not currently in use, but it's got a pump down there, it's got electrical down there.
yes.
You know, it's ready to go if you did want to use it, or there's that whole other class of stuff. No, this one's been capped, covered, plugged, or abandoned.
So logistically, we're keeping B1. We're deleting the
Well,
existing B2 and B3.
I still think we have to ask that question separately, which is, do we delete
current
B1 or not? Let me go back. Because I think, I'm not sure B1 serves any purpose now that you have.
No, it does.
Why?
It does. Again, the seller needs to disclose in his own handwriting.
Yeah, but you
everything.
have,
We have math,
I know, but
okay?
Wait a minute, let-
two and three add up to one.
Yeah,
So why do you need one?
Confirmation.
because I want the seller to say it himself, herself.
Well, I think what,
ABC.
to Brian Watts's point is that the math doesn't always match up.
And that would be a good thing to know. That is one of the reasons I want them to do it, because if the math doesn't add up, then that puts me on notice. I need to do some more, hey, what the heck?
I think there is value in doing forms that minimize the opportunity to make mistakes.
So let's see what it looks like when we put it in.
Well, I don't know how that,
You want me to do the whole paragraph?
Or no, it's just the water well and
okay. So you're
well,
proposing,
the other new language that we have.
Yeah, you want me to do the whole, that's what I was asking.
Yeah, I think so, so we can see it together. And I promise the other few things I have in here are not this in depth, so.
I'm gonna write that down.
Make a note of that.
Do you have suggested language for your other point? Or
Yes, yes, I do.
Throw it out.
thank you for that.
See where I'm at here.
When you introduce a problem,
I
always
Have a
introduce
solution.
a solution.
did for paragraph 12, so I got that. I didn't want
Mr.
to.
Chairman, while he's cutting and pasting, I did go through, and I think it's a worthy addition. In my world, it's like everybody knows this, but everybody's not going to know that as in the non-water geek world. To add the definition for surface water means water in a water course. Well, I mean,
I agree
I
with,
think
Go ahead,
you'll
Linda.
get questions on it, and the reason we so carefully defined water course was to describe the water that we're talking about, which is surface water. And I could, there's three types of water in the world: when it falls out of the sky and hits your pasture. It's called diffuse surface water. It's going across the top of your field or your grass. It hasn't percolated down into the ground to become groundwater yet. It hasn't hit a water course yet to become the type of surface water we're talking about, which is state water.
All right.
So I think it would be helpful to state that.
Yeah, I think, Brian, I don't see the problem of adding a general definition of surface water if that's helpful to anybody. I was going to recommend that what we do in the notice at the top, where we says this notice is a disclosure of a seller's knowledge about groundwater and surface water. We have the words rights there. I think we do that because really what we're talking about is the rights there. I don't have a problem adding a definition of surface water to there because I think it's just a general definition. But it's up to everybody else what they want to do.
If we add it,
Ask one question, Brian, real quick. It's where did you pull that definition from, Brian? Brian Sledge?
Where did I pull it from?
Yes, yeah. It says as far as the.
I pulled it for purposes of this form for the type of water that we're trying to get as addressed on this form. I mean, we could go through and I hate to.
So
it could be a nasty little rabbit trail to go down, but you know what we're really talking about on this form is state water. Do you have a right to state water? And that's water in a water course, but I don't think it's very descriptive to the average person trying to implement this. I think it's in our world, it's in the vernacular, in the groundwater and the water law world, people talk about groundwater and surface water. And we're talking about surface water as state water. There's this other category of stuff that I just think would complicate the forms to go in and try to talk about diffused water being the sheet of water that's going across the surface before it hits either the water course or goes down into the ground and becomes groundwater. And I'm just trying not to confuse that issue. For purposes of this form, which is what the first sentence of our definition say, for purposes of this form, the following definitions with notes apply. Surface water means water in a water course.
Yeah, I think maybe we pause on the definition so we can move forward to the other things, and over lunch look at that closer. And Brian's pulling up, Brian Watts is pulling up definitions in the statutes, and that'll allow us more time to work on it.
It's essentially, it's a subset of state water, right, Brian Sledge?
SJ is next after.
The case law and the statutes are not going to be helpful in this, Deborah. We've tried to, for lack of a better word, dumb it down where it's easy to implement. We're only talking about water in a water course, and we could get rid of the term surface water and put water in a water course in all instances. But we're just trying to differentiate two things: water in a water course, which we're calling surface water for purposes of this form, these forms, and groundwater.
okay, I'm going to argue with that because the whole premise for this was to make disclosures about water. Okay. And I think it is fine to have plain vanilla surface water. I don't think it even needs to be defined, but if it is, and whether it is or whether it is not, I think in 3, where we actually have the information, I think we leave A, which is there a water course? I think we add a B. Is there surface water, or is seller aware of surface water? And we make BC, which is the certificate of adjudication, which is the actual surface water rights, official, legal. Okay. And then we make CD, which asks if any of those rights have been assigned already. So I think it is completely fine to say, is there surface water on this property? And the seller says, yeah or no.
Surface water by necessity is in a water course, right? So that kind of is subsumed in.
Because of the definition in this form. So yes, but who says that this is the right definition other than us who came up with it in the committee?
Yeah, but
Okay. And maybe with the help of the group, we are coming up with a better deal.
And maybe, do you want to work on that with me during lunch and on the definition to see if we do that? So we can get the others going, then we can work on that.
Sure.
Um,
I mean, if we're gonna, my point is, if we're gonna define it, then let's use it. Otherwise, it's again, just.
let's maybe do that. That way we can move forward with this part and then we can figure out if we can come up with a better solution.
Well, it's fresh in everybody's mind because I just asked that we poll the brokers to add, and they're all educators, they're all Trek instructors.
Yeah, absolutely.
If they feel a definition of surface water is important in this situation, and you can just do with what you want.
Yeah, absolutely. If you want to give your thoughts.
I am in favor of a definition of surface water, ladies.
It doesn't matter to me. Surface water is up there. I mean, I don't think we need a definition.
So I don't have a strong opinion either way on that one. I think it adds more to the form, and I think it almost complicates it more. And then if we're talking about adding potentially a yes or no, is there surface water? I don't think that, let's talk about the typical consumer. People don't read forms. We know that. And they're going to take a stock tank that has no connection to a water course and call it surface water. And they've already defined that surface water is not, I mean, to what extent do we get more and more complicated over what is and what isn't, and then they fill out the form wrong, disclosing it wrong? I'm just seeing how that could get people down a lot of other rabbit holes by getting too complicated.
Lee?
I think that the majority of owners, especially ones that aren't working with a license holder, are gonna go, I don't understand any of it, and just say unknown and move on. And a lot of them truly don't know because they're heirs. The people who know about the well that was put in back in the 40s, those people are dead. So I think it's just gonna, I think a lot of people are just gonna say unknown, so I don't know that it matters.
True for a lot of people, but I think there's a lot of people that do know.
Melissa?
I like the idea of having the definition. I like the idea of having the definition just because I think that the consumers, like to your
Yeah.
point, may not know.
Yeah.
And they may be like, I don't know, I just inherited this. What does all this mean? And whether they read it or not, they have the opportunity to read it and to educate themselves before they fill out the form.
Well, and to SJ's point, there are people who do know, and the ones who do know understand.
Right.
Help me. Is there surface water? There's surface water that is not in a water course. Is that correct?
Yes.
Okay.
Correct.
And disclosures do we need to make with respect to surface water that is not in a water course that is of importance for disclosure purposes?
Now you're like into
No.
training.
Yeah.
None.
I mean,
So why don't we just limit it to water courses and strike surface water?
Which is
Which
kind
is
of what is in there now. Right? That's,
But
On the title.
like,
Not in the title.
Not in the
the
title.
information related to surface water and water courses. Why don't we just say water course?
well, in surface water rights, adding that rights thing that Ron had mentioned.
In the opening paragraph, but it is in the title.
Yeah,
And it's in number 3, information related to surface water.
it's
Water
everywhere.
course.
It needs to be
We
in
can
that
add rights to
very,
everywhere.
it needs to be in that very.
But how would you even know what your
paragraph.
rights are with surface water if you don't know what your surface water is?
Yes, sir.
That's why you're gonna, as Lee says, a whole bunch of them are gonna say, I don't know.
I think Lee's right about that, but.
I got one.
If Lee's right about that, then we only need a form with one sentence that says you know anything about your water. They're all gonna check on.
And I think this is one where it's hard to do as
Might have
a
beyond
committee
this.
as a whole, where, and if we come up with a proposal during lunch, or I know we want to get this form out, so kicking it back to subcommittee is also an option, or the working
You
group,
can
but
just
I
take
think we.
what we brought you and be thankful.
Okay, comments and periods. But no, we're gonna make it better. So let's go back to let's go back. You start there. We're all gonna make it better.
Brian has.
Brian Sledge.
Cut him off.
Yeah, I just, before we go off to lunch, which I'm not going off to you with, I just think because of the example, and I couldn't tell whose voice went with which body, but the most common thing is going to be a stock tank that's not on a surface water course. And somebody's going to think that's surface water. And I just think a real simple fix is to say surface water is on a water course. And then, because our water course definition says, hey, this doesn't include stock ponds and wildlife ponds and other water, unless it's on a water course. I just think it's a simple solution for everything we've talked about, but it's just my 2 cents.
Right, and that, again, the most important thing about surface water rights is they are defined by some other government agency and certified.
They actually are not. If it were that simple, we could just use that solution, but they're not.
They are in this form as we have it in the definition we came up with. How about that? For the purposes of this form.
So let's circle back. Let's circle back around. I think we talked that one through until we have language to put on the table to actually look at. We'll go in a little bit of a circle there. This is a new language for 2B that Ron has on the screen. To be or not to be?
Yay.
I would vote eliminating 1.
I would not. I think that's good.
You could do like an IRS form and say 1 must equal 2 plus 3.
I don't know if that will help.
And they'll still be wrong.
I like it.
I like it.
I don't,
Ron, that's what we do.
the number of water, I can't say that good anymore. B3, the number of water wells known as so that are not currently in use
I
is
had to read it
blank.
twice.
And of that number, let's just say it's 4, and of that number, 2 wells have been capped, covered, plugged, or abandoned, and 2 wells are not. How do you not abandon a well?
Have not.
You just don't use it. Like on our farm, we have, again, that was a real example. We do not use a particular well because it costs too much to pull.
If it's not abandoned, it's in use, which would be in number 2.
I'm talking about the contradiction, but yeah.
No,
between
it's not in use.
Hang on a second. Look at the contradiction between I and double I. They're both abandoned. So which one's not? The abandoned doesn't need to be in both sentences.
A well can
It's not.
be not in use. But
He couldn't say the not.
We're just
Is that better?
duplicating language with 1 and 2. This one with not.
I just
They're
underlined
2
it.
different things. I like the underline. Is that a?
But if it's not abandoned, it's in use.
What's abandoned?
He's right. I mean, 3, with the 2 eyes, if it's not abandoned, then it's in use.
Well, no, they're not,
No,
if you're not actively
it's not.
pulling water out of it, is
No.
what I'm understanding, and you're not actively using the water and pulling and pumping.
In there, and that
Don't
would
bring that up again.
That was that. If you add the word open to number little 1,
Okay.
then it does pick them all up. But otherwise,
We have a well that is not in use. It used to be in use. We could put it in use again later. We might have to do something to it. But at this very moment, it is not capped. We've done nothing to close it down. It is theoretically a usable well, but we are not using it because it is too expensive to use.
So you've abandoned it.
No, we have not. Absolutely not. We have not pulled any of the equipment off of
No,
it.
that's different than
This is
abandoned.
why lawyers make money on this, and it goes down to the minutia. This is disclosure.
It is not abandoned.
I think he's bringing a good point, though.
It's not being used today.
Well, clearly I've made the example of how the average user is going to misinterpret it.
Well, I think the argument is good with regard to the word abandoned, because I think the word abandoned is going to raise that question.
Yeah.
I'm not using it, therefore I've abandoned it.
I don't think that is, no. Well, so, okay, some people, yes. Again,
You're
please,
going to work with it at lunch.
Yeah,
but some people will not
Well,
look at it that
what
way.
if we struck the word abandoned?
Where's Brian?
Brian,
On
it
this.
does the word abandon add anything to this
Yes.
question?
It does.
It does.
I think it belongs there, but doesn't belong on 3-2.
Me too.
I think it has to match.
I can't believe we're in agreement.
Tulip line.
Here, I think that may be a good point. If we struck the word abandon here.
But I don't want you to do that. It's got a meaning.
Okay, so we know it's not in use.
Okay, this does not apply to residential, 99% of the time. This is mostly.
Well, I thought we were talking about farm and ranch, and while I don't have your litigation experience, I have sold some land.
No, I know, and it will sometimes, but I do
don't
think you're
have
right
litigation
about
experience.
the errors, but, there are gonna be some errors, but
Okay, let's maybe have this here, and since we're coming back to talk about this form again, maybe we digest that, right? And Brian Sledge, do you have any final thoughts on the abandoned language, whether have it or not, before we move to the next thing?
Our goal in the water world for this question is just to try to get people to include everything. How many things are out there? You've got your wells that are working. What other wells do you know of? So it's more of a, tell us everything that's not currently used, including any of these types of things. And so it's not that we're really wanting the seller to have to go and differentiate which type of well they might have covered and abandoned, capped and abandoned, plugged. It's just that we want to know how many of any types of wells that are out there might be on the property that aren't in use right now. So I'm less concerned about the person filling out this form having to differentiate those items as we broke them out here as I would be not in use, comma, including A, B, C, or D,
Well, I like that. Good.
Brian Watts.
I like the idea of removing the word abandoned. And here's the, you look at the words capped, covered, and plugged. Those are things that you can verify as a physical matter. Abandoned includes an element of intent, whether I ever intend to use it again or not. If you eliminate the word abandoned in both I and double I, that gives us the information of whether it's been physically covered up and closed out or not. So that gives you an easy answer as to how it's being, what the physical characteristic of the well is.
that's exactly why we want it in there. If it's not physically covered up or capped, but it's not being used and someone intended to abandon it or hasn't, that's why we want it in there, because we want to know about it.
Well, what he's recommending, SJ, what he's recommending is taking this out here and here, because now we know that we're only talking about wells that are not in use that are out there.
And they've either been cap covered or
They
plugged,
haven't.
or they have not.
It's active or inactive. We've done something to it, period, or
Exactly.
they'll figure it out.
And at a minimum, the disclosure that Sledge wants is that you now know how many wells are there. Go check it out, see if it was abandoned by not use, abandoned by not maintained, abandoned by grass grown, or abandoned because PVC broke at the top.
You go figure out why.
I like that.
Okay, fine.
Brian, is there a need for the word abandoned? I just want to make sure.
I'm sorry, can you ask that again?
Is there a need for the word abandoned out there?
Abandoned well is a defined term in law under the Occupations Code and under the water well drillers rules at TDLR.
And
I'd like to have it. It means a well that's not in use, but it has certain conditions on it, which is, and I don't think we're expecting every real estate transaction to go learn all that. We're just trying to include all of the terms that might apply to a well that's not in use, so that
Okay.
folks do check it out, could include it.
What
What if you put or abandoned here?
But if you put abandoned in, and as Brian Sledge just explained that it's a legal defined term, then you almost have to put the darn definition of abandoned at the top in definitions.
Well, he just did that by adding it up there.
What if you talk about not in use or abandoned?
What is abandoned if it's actually now, if it's a real,
Let's define it.
If the consumer doesn't know, it's not in use or abandoned, so it covers both. And they may not know what abandoned means, but I know I'm not using it. And so it
If it's
To me,
abandoned,
it-
it's not currently in use, so you don't need or abandoned.
it removes the mistakes, it provides
There are some
disclosure,
that are
and
currently used that are not abandoned, so you do need them both, Brian, that's the point. Again, like the well that we're not using because it's too expensive to run at this moment, it's not abandoned, but it's not currently in use.
I think it's redundant because
Not.
any well that is abandoned is not currently in use.
He's correct. The word, if I understand Brian Sledge correctly, abandoned has restrictions, means not in use with restrictions. And Brian Watts is
Yeah,
correct.
you can't take
that-
out
That the word
not
not in
currently
use
in use.
covers that. But I don't know if it's beneficial to have the word abandoned there, even though it's a little repetitive.
Actually, I do think it is.
But Brian Sledge, if you think it's worth leaving there,
He did.
I'm just pulling up for quick things here from the Texas Groundwater Protection Committee, FAQs. An abandoned well is defined as a water well that is not in use. And then it says a well is in use if, and then there's a 5-point definition to it. Which it gets complicated, right? This is why we have the form to begin with. If we go too far into it, having in use, you're not. Well, I'm actually.
You're liking arguing.
I'm arguing for that, but I don't know. Sure, what everybody else. To me, it's not that the way the consumers are using this little distinction we're talking about here. I think is going to be in that little 5% rule.
yeah.
Right? We're trying to get this right, but at the same time, it's.
Check unknown.
How do we be proper within the law and at the same time get our point across? And by leaving abandoned in there, does that then just fit within the actual law? Because it may be, even though what this says right here, right? An abandoned water well is defined as well not in use. That say, well, we don't need that language. But I don't think we have enough on our facts today to know the 5 other parts of this definition that cites to another USC code provision and all this stuff that we can make an informed decision on whether that matters or not. So by leaving it in, we cover our bases on that.
I think the word abandoned is a term of art. And we're trying to create a form that the average agent can use. And it's simple as it's not currently in use.
I agree with you that it's a little bit repetitive, but it doesn't hurt.
Whatever.
Can I just remind what we said earlier? I think we said earlier, or maybe it was just in my head, but we want to push this form out today. So that's the goal. And we're going to be back. We are going to be back because the legislature's making us come back in July. And so if the commission had something to say about it, is that timing right?
Yeah, our meetings before.
I'm not ready.
Good.
In Ron, in 3, with capped, covered, or plugged.
Or plugged, yeah, I need to add those two.
Capped, covered,
Or plugged. Okay. Everybody good with that?
You read it again. Yes.
We have consensus.
All right. Why do we have consensus? Well, I'll jump into my next thing I wanted to bring up was
Thanks, John.
in number 3 in several places. Well, it's all in number 3 in the subsections. We talk about adjacent to the property. And I've had adjacent to be a vague term. Does that mean it has to be touching the property? Does that mean right next to the property? Does that mean a mile away from the property?
I think we asked
we had-
Webster's dictionary about
Yeah,
that.
we had a lot of discussion about that.
So, or what's
They're
I
on
thought that meant
purpose.
touching the property adjacent to.
Contiguous.
so I went and looked up some case law that it's
It's
not necessarily though in every context. And I recently handled a Trek complaint where the person was alleging the flooding was adjacent to the property. And it was not right on it, but further away. And so the common understanding of it. And so it doesn't necessarily have to be contiguous in certain contexts. So I raised it, not having done that. I just put that out there. And then maybe it doesn't matter if it's contiguous or somebody thinks the gate's further away and it's all subsumed, and maybe okay. It sounds like y'all look at these.
We did.
We didn't look at it like you do. We looked at it.
Is adjacent means close to or near, while contiguous is touching or
Yeah.
screening.
I can do that.
So you don't have to touch, right, and you can still be adjacent.
And so where does that line fall of adjacent? Is that a mile, or is it'd have to be dependent upon the circumstances, and where does that?
I think
Where does that
the
rise?
word became, that we were focused in on, there could be some strips or whatever that sort of make it non-contiguous, right? And out of concern for that, we went with a little broader term in terms of adjacent.
I have no problem with adjacent.
But this reminded me of something, that we didn't do, and I don't know that we normally do on the notices, but I think that this form would benefit from the consultant attorney before signing this.
It has it at the bottom.
Language.
And notices to buyer and seller at the bottom in 3.
It's not on the page with the signatures.
It's paragraph 5.
It's 5.
It's not, okay, well, make it bolder. Let's do it like we have done on the other.
Full Swanton law.
Yeah, full on. And I'd also put on there that, I put the whole thing, it says track rules prohibit real estate brokers and sales agents from giving legal advice.
I was debating whether to bring this one up or not, but since it's brought up now, that
Okay.
it's consultant attorneys in 2 places out here. It doesn't follow the format that we typically
Yeah.
use in the other places that we did. So by combining the 2 at the end and having the standard language that we use in the other forms could be helpful, satisfy that purpose, and have it in bold. Because we have it in notice in 3, and then we also have it at the end. Notices 3 and then in 5.
And if somebody read it more recently, they can remind me, but I think it's
All
also
right, I need
good
to-
to have
I
a
need to
notice
be-
that the real estate brokers and sales agents shouldn't be getting.
Okay, I need to be a little more precise for the minute so we know what we're striking and keeping. So,
It's underneath paragraph 3 where it says notices to buyer and seller.
I think that's fine, leave them alone, but add in the,
wait, hold on a second. I want,
And the notices to buyer and seller, number 3 and number 5.
What SJ is saying is consultant attorney before signing direct rules prohibit real estate brokers and sales agents from giving legal advice,
read this.
which is in the contract. Yes.
So-
Read this form carefully.
So we have it both in,
Bold.
see the section.
I know, I agree, it's there.
I was just showing everybody. So we have it right here in 3, the consultant attorney there, and we also have consultant down here. And so we did what SJ is suggesting of having the bold and the standard language we use right at the bottom. Is that what you're?
Add one more, leave it
Yeah.
there,
Leave
add
so
one
3
more. Yeah, do it in bold. And
Leaving it-
say,
3 and 5 are saying different things, which is if you intend to convey or reserve, you should call an attorney. This one's more generic of this whole form.
so leave all the consults, but
I would.
What
Yeah.
SJ is saying is additional statements telling brokers and agents
Not
don't
use
give
it.
legal.
This one.
yeah.
Well, no, yes, it's that. No, it's not telling them, it's telling the user of the form to consult an attorney and not to be consulting for legal advice for licensees.
Yep.
I agree.
Is what I'm,
Okay, I got it.
you got it?
Okay, so this is what I have so far recorded in the minutes, that at the top of the form, we're going to add rights after the word surface water, that term.
Yes.
Then we're going to make the changes in 2B that we discussed before. And then we're going to add this disclosure, this consult attorney language down at the bottom. That's what I have so far.
Do we have consult an attorney before signing on any of our other disclosure forms though?
No.
No, and we only have one other, we have the main, because that is statutory language and we have followed the statute exactly.
Okay.
On this particular one, I'm
We're
more than
making this up.
anything, it's so legal
Yeah,
in nature.
yeah.
I don't mind
yeah. I'm
Okay,
okay
so
with that. I was just
telling them multiple
the,
times.
keeping us on track.
and you're going to work on something during lunch?
Yeah, I think with we may not end up going there, but surface water definition, but the asterisk on
That's
whether
right,
we
so we're
do
going
that
to
or not.
hold that
I would
until
hold
after
that.
lunch.
Because I think that putting rights in there It's solved my issue,
Me too.
but it's something to look at. I think.
Somebody feels strongly they should let it.
Consultant.
Because we have other opinions that think that it should be.
Yeah.
On which one? On
defined.
the minerals? Okay, thank you. Thank you.
The other work group was compensation.
Compensation,
Yeah.
Okay, wait. Oh, we haven't finished with this.
okay, I was about to ask somebody get us,
No.
Right. I was right there with you. I was right there with you.
I tried.
Page 11, right?
No,
They're going to,
Page.
I think the committee's not gonna let Brian Sledge back into the
Fine.
meeting room again. Anyway, so the trigger for the form I want to bring up in the, if you just look at any of the contract forms, but you can look at the unimproved document form, which now be new paragraph 7F. So it goes about groundwater and surface water rights. I'm going to
Page
pull that up.
19 in the material.
Yes.
Want to make sure that everyone understands, and if we need to make any conforming changes there based on what we just did, that we take a quick look at that. Pull it up.
Okay, a minute. Thank you.
The key point for our discussion at the last working group meeting was A through E. I'm sorry, box number 3. So what would happen is that you have to have one of those reasons that
To not do it.
to not do. I'm sorry, all 5 of those have to be satisfied. I'm sorry.
Yeah. No, and.
So
It's an and. So no wells, no water course, on or adjacent, no adjudication certificate, permit, blah, blah, blah. No groundwater rights have been severed that we know about. And it only gets water from municipality or district or.
The only plug is not, in the parenthetical on 3A.
Yeah, I was gonna say, does 3A need to match the rest of the stuff? Active, capped, or
Well,
abandoned?
abandoned has been taken out. See, that's
That's what
exactly
I'm
why I was
saying.
in there. So if you people.
Well, no, actually, we can leave abandoned.
Put it back in.
Well, then you need to add.
Or you could just, because it's a parenthetical, you could just simply say active or not in use. That would be the broader
There
term.
you go.
I'm thinking
So
video.
if we just simply
Although
say
I think it's
active, or you could say in use or not in use, if that would be the.
There you
better
go.
Would that just be sellers not aware of a water well in the property?
In use or not in use. That's pretty basic.
Let's take out the parenthetical.
Right. Because somebody, if this is true, then they're not gonna go even look for it.
Right. Yeah.
Simple, like it.
Mhm.
Way to go,
So-
Ron.
What are we doing?
Just take out the
In
parenthetical.
use or not in use.
No, I'm hearing 2 things.
No,
SJ's
no,
saying,
we're gonna do in use or not in use.
and then I'm hearing,
No. So Later and I were talking about something different, of taking out parenthetical altogether, because in use or not in use is just surplusage of they're not aware of a well
Well,
on the property.
I agree that it is technically surplusage, but as I just said, this is not the form that they're gonna be, they're not gonna go to the form if they're not aware of a well. All right, and I think it ought to be simpler, and I think the in use or not in use, because I think somebody's gonna say, well, there's only I know of a well, I don't know of a well that's working. And then they're not gonna talk about it because they're not gonna go to the form because they think a well that's not in use doesn't have to be disclosed. So I want, in this case, the parenthetical, instead of say active, capped, or abandoned, to say in use or not in use.
I can see the argument for that side. Anybody have thoughts on that? What we're talking about whether we need the parenthetical or not, about is seller aware of a water well on the property. SJ's concern is the if we don't put in use or not in use, people will assume that, well, if it's not in use, I don't have to, it's not really a water well that would require disclosure. So I'm okay because of that exception.
So what the parenthetical would say exactly what?
In use or not in use.
I like it.
All right.
Thank you.
In E and 3, it ends with a colon. Is it clear what is to follow?
Yes.
D. Just a question.
Receives water only from the following
What's
municipalities.
gonna follow is gonna say consultant attorney. Again,
Yeah, I think it has a colon and a.
Okay. Fix that little typo. Okay.
Yeah. So yes, it's clear what needs to be filled in, but there was is that a frowny? It is a backwards frowny.
Period instead of a colon?
Backwards frowny. Got it. No, it's a colon.
It needs
Because
a
everybody
happy
knows
it's a happy.
All right.
receives from the following, just colon.
I bet we will have a lively set of comments on this form for our next meeting for discussion.
Well, we have another disclosure memo when they came.
Okay.
We'll see what the next one does.
All right. So then with regard to that same committee, if we go to,
Like, does everyone agree to this? Is that a good time to do that?
well, I mean, if we're going to make changes by adding a surface water definition, then I think we should hold off on voting. But if we want to make that decision now, then we could,
I think we ought to vote on the
But-
contract changes. I don't think that's gonna change.
oh, I see what you're saying. But we got to have the form before we submit our changes.
Yeah, I think we wait for,
I just mean
I feel good
approve
that
in
we're-
this room, we agree to this.
I would like to look at the
Okay, fine.
definitions in case.
Okay. And then, so if we go up to the seller's disclosure notice draft, you'll see there on page 11.
Mhm.
So these are the things, the items, and we simply just asked Abby to insert these directly in from the sunset report. So these dropped right in there as they came across from the sunset committee. Sunset Commission, excuse me.
I have a lot of concerns about these from multiple angles. I pulled the definition of conservation easement. I think would need to be tightened up a little bit. We don't define what type of insurance that's in there. A private road, I pulled the definition from there's a definition of what a private road is in the law. There's, if anybody doesn't know what a 500-gallon tank looks like, I printed a picture so everybody can have an idea of what we're talking about here.
John.
To have in your mind what we're in, and I have the larger concern over a lot of the details still about us legislating from an administrative committee.
Can I address that?
Requiring.
We had a mind meld and I had some pushback to this in our discussions. And we discussed, and Brian Sledge also assisted us with this. I was giving pushback to the Sunset staff, who I'm sure will see this at some point. It is considered law. Okay, these are mostly legislators on the committee. And it was advised to us by our lobbyist committee person that we treat it as law and deal with it like that and don't give any pushback and follow what they sent us. So that is what we did. And, like the only things we changed to make it just a little tiny bit more legible as regards to the insurance is to break up insurance and then windstorm. But if you don't have in front of you and remember from a couple of meetings back, but this was the sunset report, which is basically the instructions to us, which we dealt with as if it was the statute. So the rest of this form is from the property code section 5.008, word for word. And then the new items are essentially word for word, but the best words that we were just mandated by Sunset. So that informs a lot of why it looks like it does. We didn't go out and make new additional instructions that we didn't receive.
In for the technical side of the nature of the recommendations that were made, and so everybody generally understands. I don't want to butcher this, so help me if I make a mistake here. Is they were it was not staff. What's the term of art that I'm looking for? Staff recommendations or
Management action.
management,
Sensitive Advisory Commission.
which is not the equivalent of the legislature saying X, Y, Z in a statute. So it's not the direct equivalent of it. It's something that I think a lot of us would love to make a lot of changes to these forms. And I share the concerns of the members that submitted, the representatives that submitted these things. And I have my own that I have a long list for. In this committee in general, for various different concerns, has elected not to go that next step, to add those things in. And if we ever did, I have my list that I think needs to be disclosed as well. So it's not to degrade the nature or the importance of the recommendations that have been made by the representatives. It's the taking a lot of different factors into account.
So the difference that we made is in that term management action. So that is a direction that the commission has the authority to order to the real estate commission to take this management action.
Okay.
So if it's considered a management action, which is, I think, coming into this committee, then the real estate commission itself could take this form and include those management actions in there. And it's actually coming to us because this is not really our form. This is right out of the statute. So that was the reason why we were doing this as a matter of, I guess, courtesy, for lack of a better word, for proper review.
I think it's strong.
I do think that you can play a little bit with the definitions, because I think that the management action direction by the commission, Sunset Commission, to the real estate commission is get this in there in a good way, right? I don't think it's necessarily specific to the language used by the Sunset Commission. So, for example, if you wanted to clarify insurance, you could say, to the extent, is it covered by the following type of insurance? And then a checkbox or whatever. Or are you aware that it's not covered, I guess would be the best way to say it, by any of the following types of insurance, the windstorm, the whatever else. Well, again, it's just a management action. It doesn't have to be all comprehensive. I think the intent of that insurance, my personal view, is that that's casualty loss insurance, typical residential casualty loss insurance. I don't think it's anything special other than your typical residential, if there is any more such thing, a typical residential policy, right? But anyway, that's, I think, those intent. So I don't necessarily mind it having a little bit vague, because the intention is just pose the question and then let them answer the question. We have some vagueness in other things in the statute as well. So
Yeah, and following on to that vagueness, and also I want to just call it simplicity. Again, the legislature has created essentially this form for us. I mean, they created the language for this, and they have looked at it every session for 20 years, at least, if not more. I think that's true with maybe one exception, one session. But it is, I don't want to say dumbed down, but it is dumbed down on purpose, because this is mandatory for a seller, whether they even know a real estate professional or not. This is a true consumer form. So again, that is part of what went into our thoughts about keeping the language that the Sunset Commission, and Senator Middleton, Senator Paxton, Representatives Kitzman, and the public member really worked hard on and sent to us. I mean, there's flood insurance too. We could ask about flood insurance, but we didn't. We broke it down. Is it covered by insurance? Which was asked, we were told to do. is it covered by windstorm, which was a specific one? And has the seller been unable to cover, insure the property?
The form does cover flood insurance in another section,
Yeah.
but that being, I think that's the whole question. I don't mind playing with the language here at all. We just thought we would drop it in here or have Abby drop it in here and then chew on the language here as a committee of the whole.
I really think if somebody needs to have some serious heartburn about it, and then they're gonna probably have to get over it because it's a management action. I don't think we ought to go with all, I have a list too. I don't think we get to go into our personal pet peeve list on this.
Yeah, and it's a management action though, if we look at the technical side of it, it's not required, right? It's a suggestion at the end, as strong of a suggestion as it might be. I want to make sure that the lines are clear, that we don't have to. Now, if we think it's a good idea, it gives us the vehicle to, right?
Well, that's not our decision.
Right.
That's the commission's decision.
Right.
So the commission has to make the decision of whether it wants to move forward in that management action or not, and then account back to the Sunset Commission. So
and that's where I'm diving into
we're presuming that the
minutia.
real estate commission does want to make these changes, and then here's the good language to use if it chooses to do so. If the real estate commission chooses not to do so, that's fine.
And again, I really pushed this issue quite a bit. The information we received back is, there is an auditor's office of the Sunset staff that will report back whether we complied or not. And
I think we talked
results in bad things.
It all deserves to be walked through, right? And this is where I want to make sure in these distinctions that Ron is raising now on how do we look at it, right? And so it going through in each one of these in detail, I have pulled statutes. I have looked at, if we phrase it this way, can it be confusing to some, at the end of the day, get the wrong impression or not be complete? There definitely is not a lack of looking at this individually and as a whole in having that decision at the end of what we do. And I just gave my open and like the last one, right? We have a lot to go over with these. And so they give the initial opinion there, but having that distinction of being the commission's decision at the end of the day, to have them, that's an important one of how that comes up in the nature of that directive. So I just want to make sure that's clear and understood of that. If there's no short shifting of the thought and thinking and analysis of this,
I think
a lot of time.
My thought would be that if the commission, our recommendation is, commissioners, if you find in your wisdom that you need to do this as a management action, then here's the proper way to do, or here's a good way to do it. Not necessarily the proper way, but here's a good way to do it.
It complies with the management action.
If they choose not to, then they report back to the Sunset Commission. Now, I think what you're expressing is, has the Sunset Commission sort of avoided the legislature in changing the form by taking this action?
Right.
Yes.
They have to account to the legislature for that.
And that's the important, that's a very important distinction here, and that helps, right? Because then it removes it from this committee's decision to the commission's decision at the end. And I appreciate that distinction on that, right? And so then it's up to us to have the best language possible that then gets sent up. And
this is interesting, but it's not any different than every contract we do. It always has to be approved by the commission.
That's right.
We don't make those decisions.
That's right. But what he's talking about is this isn't the whole legislature doing regular plain vanilla legislation. But what everybody needs to remember is this is a legislative committee. The Sunset Committee is a legislative committee, and I made that face too, that it was.
But this is not our fault. This is not.
Yeah. This is not, it's a legislative committee, and they have the authority to do what they do in the Sunset Committee, the commission. So
what we're doing is the same.
My vote would be, let's go ahead.
I want to just say this too, respectfully to everybody, but if you really feel so strongly about something and you want to be a part of it, then get on the subcommittee, because it is frustrating to have spent, I don't know how many hours we spent on this. And then to come in and it seemed like it didn't matter. So.
Well, and it definitely didn't matter. Look, outside, I'm not even on the subcommittee, and I dove into a lot, and I was giving my opening remarks upon that to then dive into it. And
Suggestion is,
so there's no
get on the
disrespect meant
committee.
there, but
If you want to be in on the sausage making, get on the sausage making
Well,
committee.
it wasn't so much that as much as we brought this, what we decided to do was to take the language in simple form that came from the management actions and to drop it down in there and then bring it back to the committee to see what to do next. And that's really fine. I mean, I don't know if there's a time limit on these management actions, Abby. Is there?
There's not, SJ, I mean, yes and no. At some point, I can't remember the timing, SJ mentioned the SAO will look and see, kind of look for a progress report on whether these changes have been
I
made.
didn't like that down.
But it's not like it has to be done by fall or something like that.
So that was one of the things is that, is this something that we want to delve into? And then do we want to toss this up just as is, or do we want to get into this thing a little deeper or defer and maybe get into a little deeper as well?
I think this is the appropriate time and place to get into the details of it, because it's, and again, no disrespect to the subcommittee, to give my opening remarks on it, and I have things to highlight that is just something to consider, right? It's the recommendation coming here, and I think it's all the committee members on any subcommittee to give the comment and look at the work. So there's no disrespect whatsoever there. So I think we go through that now. That's what we're looking at. And Brian,
This is just a question as to procedure. I personally feel that we should conform as closely as possible to 5.008 form, but I understand what we're doing here. If I were this broker lawyer committee, which is an advisory committee, I would say this is language that we believe would satisfy the recommendations of the Sunset Committee. We express no opinions as to whether it is proper or not, and leave that to the commission. Is it possible for us to do something like that?
I wouldn't say the last part. I don't think we say we don't have an opinion.
Well, we make
have
no
an
recommendation. I make
We
no
do recommend this. We do recommend, I mean, the committee.
if we do, I would think some of us at the end, that's the way to, what the Sunset has asked us to do, to comply with that, even though as a whole, we may have different opinions on what needs to be in the 588 form, for lack of a better term, right? The statutory form. And there's no surprise that if you go back to our meetings since I've been on this committee for 8-9 years, however long it's been, we've always had that position. This isn't new. This isn't changing because somebody brought something to us. We have always held that position that we don't change this form. And so that's the reason for the pushback, of more than, I say pushback, of the hesitation of we have this outside of the legislature action in a different way. And I understand what Ron brought up, the distinction, right? The law is important of what it does, and it being the commissioner's decision.
Or can we get instructions from Trek as to whether they want that language put into this one?
Well,
I like what you said the
we
first
had
time.
the discussion in the subcommittee working group that was like, do we even want to touch this form? We had that discussion and we were basically told, look, they said it needs to be here, so it needs to be here. It was almost like the Sunset Commission was just giving us a directive and we didn't have a choice and we had to put it in here.
Well,
even though it's not in the statute.
And there's multiple different types of sunset direction, right? And so that's why we dive into certain things have to be done out of sunset. This was a keep forgetting the term of art, the management recommendation, which is it's its own category of type of mandate.
Okay.
And that means it doesn't necessarily have to be done. It's a strong recommendation, I would venture to say, but it's not an absolute requirement. But And that may go to, at the end, if we, as a committee as a whole, decide we do want to recommend this, right? Then we wouldn't include the language that Ron said. But what we've been asked to is to, and I agree with Ron, of providing the language that then is taken up by the commission that has the authority. But we don't necessarily want to recommend it. Our language in our minutes and our direction to the commission matter. And so we would say, if you're going to do it, here it is. But we make no recommendation whether to do it or not at the end, or that yet very eloquent language in what he said. And that's just being technically right. And we don't have a lot of those types of situations come up here. And again, it goes back to, that's just always been our longstanding policy as a committee. That's not black and white. It doesn't have to stay that way. But it's not because, we're not saying that just because these recommendations came in. It's just something that we would go against, something we did for a long time. But by doing what Brian said, it accomplishes both purposes and stays within what this committee is intended and required.
Could I make one other suggestion? In the form, down at the bottom underneath the signatures, it says this form was prepared by TREC in accordance with Texas Property Code Section 5.008B. Add and recommendation of Texas Sunset Commission.
If it's going to be accurate, you need something to that effect.
And I think that's language that's added. That's not something we would need to. We can recommend
It doesn't make
that
that
change
not
later.
true. It doesn't make that not true. Okay, it is.
And I don't know if we need to get stuck on that, because I think with that, if the commission says do it, by adding something like that wouldn't be substantive of the form itself to change. Would that be accurate?
So you're talking about the little footer.
Yeah, a little footer.
Yeah. I'm not sure how involved the committee itself has been in those, but we could, in the actual text of those, but we could certainly look at that.
Before we jump into the language, not to invite it, but just provide the opportunity if anything you'd like to add to the comments or.
No, I appreciate this discussion and what everyone's thoughts are about it. These are management actions. This is sort of a political situation as well, where the Sunset Advisory Commission has directed TREC to do something. So I think it does, if this committee would elect not, to provide something, which is certainly, an option, that may not matter ultimately as to what the commission decides to do for political reasons.
They're either they would turn around and direct us to do it, or just.
I don't think the
tell us to
commission
jump in a lake.
can or would direct necessarily. They can provide suggestions, but I don't think we can, for lack of a better word, demand it. Yeah.
I didn't say demand, I said direct.
Yeah.
But.
Yeah.
I think Ron hit the middle
Yes.
on that
Yeah.
with his analysis.
I have another comment, John, that I just want to throw out there before you get into all of your things. I'm certain that you have found all the things that we found too about that led into our discussions and our decisions about what to bring back as the subcommittee, like the definition of conservation easement, which I know, there's things out there, there's multiple things out there, but I really want to stress that we really did do a lot of hard work and full surveys, and again, I want to thank Brian Sledge for hanging with us on all of this. So we had his input too, not only about the Sunset Commission, but about how to present this. So.
Okay.
And I very much appreciate the work, and if for everybody that's online too, the amount of time put in on these subcommittees, it dwarfs the amount of time that's actually in the meetings. And when you add up all the work that individually all the members here do, and then meeting formally as a subcommittee in between. And so we wouldn't be able to have these meetings and get things done if that didn't happen. And so what they bring with us today has been thought out, and what we're doing here is tweaking and discussing as the full committee and voting on it. So the stuff I have is, I think you'll find relatively small at the end of the day.
Tell us what you found.
So looking at the definition of conservation easement, which I found in chapter 183 of the Natural Resources Code, 183.001. I just was wondering, when we have a parenthetical here about permanent or for a period of years on there, the period of years, I know there's meaning for leasing, or I'm not sure somebody, the layman will understand period of years, right, of the time. Looking at the definition, which almost follows exactly what you have, but it says a non-possessory interest of a holder in real property that imposes limitations or affirmed obligations designed to, and then it has the virtually everything that you've listed here.
Okay, so
I didn't know what for that period of years.
Well, one of the things that we did catch is that these conservation easements can be either state or federal. So we wanted to be somewhat, I guess, private, yeah. And then, so we wanted to be somewhat generic in the definition. But I think they're all, if I recall correctly, they all essentially say almost the same stuff, slightly word differences. So in terms of an easement, if you want to add non-possessory interest, I guess you could, but I don't know if that adds anything to the average reader. In terms of,
No, I think John's trying to change the very phrase "period of years."
Yeah, or just removing the parenthetical. Why do we need the
Specified term.
I have a question.
I don't mind removing that.
I do.
Can there be a conservation easement that's for less than a year?
Yes.
Yeah.
Okay.
Yeah.
But the whole thing
That
that
answers-
John's bringing up is most conservation easements are permanent. Okay, but some that we are all aware of, we on the committee, are for less than forever. Okay.
Yeah.
And those are important to be disclosed also.
Yeah, I mean, I think
That's
any of them should be disclosed. I just had never heard of one that
Most
was.
conservation easements
than
are
a year.
long-term.
Well, that's not what it means. A period of years means a number of years, and maybe a number of years is better English.
But they
Like,
can,
I get that.
they can almost be terminated at will after certain notice. Okay,
sometimes.
because, for example, the federal ones, if they're wanting to protect a certain habitat, then they give a tax break for you to be able to do it. If you decide you're not going to do it anymore, then you lose your tax break.
I mean, I'm just thinking conservation easement. I've either got one or I don't. So,
What difference does it make if it's 1 year, 2 years, 6 months?
Right. It just needs to be disclosed, and then the buyer can go and do their
So what's
investigation.
the purpose of
and if
this?
you mark yes, you have to give an explanation down there. So,
or that parenthetical, having that in there or not?
Because we want to make sure that somebody, frankly, it was added to make sure that somebody who has one that is not permanent discloses it. It can be either, and frankly, the same piece of property might have multiple.
But I guess what they're saying is if it's a disclosure that there is an easement, wouldn't that prompt you to say, hey,
yeah.
what kind of easement you got on it?
Well, I mean, if you mark Y, if you say yes, you got to give an explanation down there. But I also think when I read that, I think if there's a conservation easement that is less than 1 year, it looks like I don't have to
I see
disclose
what you're
that.
saying. Okay.
And I think you should.
Okay,
So,
for any period of time. How about that? A permanent or for any,
okay, but
period
then
of
why do
time.
you need,
because there are some that are not permanent, and most are permanent, and the general user of,
I know, but if you just say conservation easement, that means all of them, whether it's a day or
yes,
permanent.
but most of conservation easements are permanent, and most people, even in this space,
Yeah.
professionals think they're permanent, and some of them are not.
But does it
I
matter?
mean, I just don't think it matters in this.
If we didn't have,
I'm okay
Let's ask
with
brothers
eliminating
real quick.
it. Let's just okay with it.
Do you think it can, the confusion, so the point brought up is having a parenthetical may cause confusion with the consumers using the form or the license holders understanding it. And by removing it, it doesn't necessarily wouldn't, well, let me see, what are your thoughts on the parenthetical part?
I think it's
As it is now.
pointless, but I don't
now
care.
it's part of
They
their
have one,
temporary.
they have one.
It's-
I didn't know what a conservation easement was until just now, so I don't really have an opinion.
Tony?
I completely understand where SJ's coming from, but for the point of just disclosure, letting you know if you have an easement or not, I don't think it matters if it's a long or short one. You're just letting us know you got one.
If there is one.
Yeah, they have one.
Yeah, if you just remove it,
It's
then
just
it just says
So we're
easement
removing
on the property.
When drafting a form, kudos to Ron. One of the joys I've had on being on this committee is seeing the value of using fewer words.
Amen.
And I think fewer words the better, especially in a disclosure form. I don't want to die on this hill, but the question is, are you aware of a conservation easement? What's a conservation easement? It's an easement that restricts the use of the property for certain purposes. I don't think you need the parenthetical, but
Does it bother you if it's there? Does it hurt you if it's there?
Well, I think the polling we went around, there's more that are thinking it's not needed on there of coming around. So,
Can I say?
I understand there's are different opinions on it, but it seems like the thrust that we're going with, it's not necessary for our understanding or disclosure purposes that aren't that far. So I would suggest, with the understanding that it's not there's no one best way to do it, but I think generally everybody's in agreement on that.
That's not true. That's just not true.
We can,
You want to just vote?
You know, and can I say, one of the reasons we have different people on this committee is because some people know things about certain things that people don't. Diane has a whole world of knowledge I am not up to date on the day-to-day business of residential. But, you know, even just now and being on the committee, she just said she didn't know anything about this. So maybe the people who do deal with this.
those that don't know are just as much of a blessing as those that do.
Absolutely.
And so, because then it helps us on who we're trying
My
to get
point
this in
is,
front of. And so
it might be a good
let's-
idea to ask people.
let's
who
take
deal
this
with it.
to a vote real quick so we can move. So for the parenthetical of the easement, all in favor of removing it?
What's off of there?
Say
Aye.
on keeping it
I'll join.
Yes.
I'll join you.
to. Okay.
Yes.
I don't know if we need to record.
I do want that recorded.
So it was Diane, Ron, and SJ4. And then do we have, Darlene?
Y'all are all wrong.
Happen to be on the committee.
It's not the first time we've all been wrong, is
I
it?
think you're okay. You're okay.
This wasn't like the 6th, 7th, and the next one we're about to get to after this. So, Darlene, what was that?
I don't have an opinion. I don't know enough about it.
She's-
So-
Oh, come
Abstain,
on.
one abstain. So.
I'm gonna,
Diane voted. Did you say that?
I'm convinced.
SJ brought her the team.
Okay. And that's, again, not everything's going to be exactly
the way I like
the
it.
way we all like it. And the next one's going to be more contingent. So this gets us moving forward on that.
I might just quit.
I don't have any other, the conservation easement thing, I don't think we need to go to the full one.
Okay.
It just, the fact that you highlighted that there's federal in addition to state, that even makes me more convinced that it needs, what she did was great on that. So, on the insurance, broke it out. I just went and looked at the
Yeah.
types of this arrays, like homeowners, fire, flood, wind, hail, and then specialized.
General liability.
Exactly. Now,
Accidents.
remember, the form is given only in, for one unit dwellings, right? So I think the impression is that this is probably the property homeowner insurance that we typically have. I think that this is what it's referring to.
And flood insurance is already covered. There's a
Flood
whole
insurance is covered.
section about flood.
I kind of like it the way it is,
Mhm.
because if they mark yes, then they're gonna have to go down and explain and say what kind of insurance it is. So I think it's beautiful in its simplicity.
So if it's a LLC owned rent house being sold as single family, you want me to go disclose primary, excess, all the CGL policies, everything on that house? Fire as well, I gotta disclose it all.
It's
If the
kind of a drag,
answer
but I think you
to
did,
any of the
yeah.
above is yes, explain.
Well,
Yeah.
what does that do for the buyer? What does it matter? And don't go to the next ones yet, like it's uninsured, you can't get it insured. I get all those. Just this one. What difference does it make to the
Well,
buyer?
Okay,
Well,
have you ever
you'll
pulled
have
the
to ask
Clue
their
report?
attorney because I don't know.
Okay.
Have you ever pulled a Clue report?
What?
Clue.
Yeah.
No.
That's a reason. It's all the insurance companies share claims. So if, I've been a habitual claim maker, or if my house, even before I owned it, had a bunch of claims, they sort it both ways, by the owner and by the address.
Is that addressed later with this house is not insurable? Or is there any reason that you wouldn't find this house to be insured?
What's the harm of being a little, because the
They told
type
us
of insurance is somewhat limited and beyond what, because Tony brought up examples that would be included that really aren't relevant to disclosure, and there's such limited amount.
Right.
Would it hurt to make it a little more
Well,
narrow?
Tony just raised a question, and Lee also said it, is that if we say, yes, I am presently covered by insurance on the property, which is the majority of them, then I have to describe what I have. Is that what we want?
Instead of just
In other words, should you flip it, that the property is not covered by any insurance?
And then say,
Again,
well,
and then have this specific.
Like the way it is.
These
I
are
was just saying the
exactly-
Sunset Commission.
and y'all aren't looking at this right now, and this is exactly what,
We don't have to follow that. We're recommending the language.
We have
I know,
put that
but it
forward.
informs the
Yeah,
discussion
right.
and nobody's
We should-
looking at it.
We should try to ascertain the intent
Right.
of that to be able to draft it properly. I don't know.
So may I read this?
Well, they're present at the hearing, so.
Yeah, so I think this was Senator Middleton's recommendation. I believe he is from the Galveston area, so I think it was related to
We know
storm,
Middleton.
those kind of issues. And windstorm is included specifically, but I think that is the angle, most likely.
So again, I was under the impression that we were talking about basic property insurance, casualty insurance to the damage to the property. But I wasn't worried about the question too much until that discussion.
I mean, I'm in
That makes me like it
judging
more.
people's experience in it. I haven't been a broker. I've only bought and sold over 70 houses myself.
Give a personal use case for flood in particular. I'm in Galveston County myself, and I have a very close friend that my property fits in the same situation, but it didn't arise with me. A very small portion of his property is within the floodplain that would, make the rates go way up. But two different insurance companies gave him one that included it in there and one that did not include it within the floodplain. Drastically different rates, or whether it's available at all. For mine, I was able to get it, but it falls within the same category. And that's something that I would want to know if I couldn't get it, to your point. And to me, we're dealing mostly with the homeowners insurance, the flood and windstorm, right? As the three big categories. And by having it, maybe rephrasing it or something, does it get the thrust of the concern, the flood, 'cause that would be a concern to me too, in there in a way that, and if it's not, well, tell me why. Oh, I just didn't want to get it. Or it was not available, right?
If it's Sarah Middleton, if y'all may or may not know this, but if you have which been recently changed on the FEMA grandfather plans, if you have a certain type of insurance, I could see where you'd want to disclose it, because you have to adopt, like if you're at the beach, Galveston, you have to adopt the seller's policy if you want to maintain that same grandfathered status of $900 a month instead of going to private insurance of $8,000 a month. So you absolutely need to know who their insurance person is, so you can contact them and sub your name in so you can maintain your FEMA grandfathered locations in Galveston.
I like it the way it is. I think there's a lot of.
We were just talking, it seemed like in the hearing, the issue they were trying to address is insurability. Can a buyer get insurance on their property? And whether or not a seller has insurance on the property would inform that. So I do think it's for these hurricane areas, windstorm areas, but it seems like there's an issue in being able to get insurance.
Jefferson, Chambers, and Galveston also have county regulations now that if you've already had multiple claims, that you can no longer get insurance unless you build your house up another 3 or 4 feet on the slab. There's all those new nuances.
Yeah.
So that makes sense. I just don't know that, do you have insurance line really?
Does that help?
Yeah.
That's, Chelsea, I think that's sort of what I was getting the sense of what we're really looking for. So could we maybe just have one simple question of, or a statement, seller is unable to obtain or has been denied insurance on the property?
Again, may I
Then you can
read
come next.
this?
Or hold on one second, Chelsea.
I'm good.
No, okay, go ahead, Mr. I'll make sure.
I really want y'all to understand what we have been tasked with. Direct Trek to add language to its seller's disclosure form to provide a prospective buyer with information on whether the property is presently covered by insurance, comma, including windstorm insurance, comma, and whether the current seller has been unable to insure the property for any reason, period. I don't think we get to skip that.
Well, we're not
We're
talking about hitting that last parenthetical. And I mean, I know we're on an open session, but that doesn't mean the legislatures actually know all the
whether it's covered or
nuances
not.
and how to write it. I mean, I don't know, it doesn't mean they know everything.
Well, and again, we're here to recommend language, right? And so taking what they want, you want this, here's a way to implement it that to the intent. So we're not bound, I think, by the exact words.
Right.
I think we're bound by the concepts. They said, do these 3 things, 1, 2, 3. And the first one is it covered by insurance? The second, is it windstorm? And third, is it not insured?
And
Unable to be insured.
let's, I think, talk through this alternative, because at the end, it may satisfy your concerns, right? Because it may subsume exactly what they said there. And if not, we don't have to go down there, but I think we're on a path that may do both.
So we're proposing one sentence that says, let me just copy this so I don't have
Put it
to.
all back in the same sentence. Because we took it out of the sentence to make it easier. It is one sentence.
I like it the way it is.
This,
I do too. It was
Okay, so
confusing
what we were-
otherwise.
Who were you recommending this?
Tony, you have some
Do you have an idea?
coherent thoughts on this?
On rephrasing, this property is presently covered by insurance, that would, is that what the one you're talking about? Steve?
Right.
Exactly.
I think it's way too generic. I'm for getting the intent of their directive, mandate, management, whatever they think they know, but they didn't bother to write. They just gave a directive for us to go fix. I think it needs to be, the property is presently covered by insurance. I liked what Brian said, to be honest, on the end down there. Like, look, is there any reason why this is not? Which would be the third parenthetical of what, or after the last comma of what SJ read to us. Is there any reason why this thing can't be insured? Or you've been notified, something to that effect, instead of just carte blanche insurance.
Whether the current seller has been unable to insure the property for any reason.
And have another new thought to throw in
Well,
after Chris.
I think there's 2 things. There are some homeowners that do not have insurance by choice, but it's not because it's uninsurable. It's because they just choose not to pay the money and the house is paid off and they don't have a mortgage company.
Right.
That is one totally different situation than uninsurability, whether for whatever reason they can't, or it's too expensive, or the roof can't get insurance. And so I would rather, if I'm a consumer and we have to, if they mark yes to any of these and then provide more information, saying that the property is currently not covered by insurance and them explaining why it's not. Is it personal choice or is it because of something else?
Yeah. And Galveston has a lot of self-insured now.
And can I add in here too, if a home is unoccupied, the insurance by law is, they've notified their insurance company, it terminates in 60 days. I think it's 60, it may even be 30.
But if
now.
it's
I
not
think it's-
covered,
but-
once again.
Okay, and here's the reason why it's important to know that I expect Senator Middleton cared about. The contract sets out that if there is some kind of a disaster and damage to the home during the term of the contract, that the seller, the choices, they're gonna repair, da, da, da. So it would be good to know if I'm gonna buy this house that's might be befallen by a disaster here in hurricane season, that this house I'm just in love with is gonna be totaled, there's gonna be no insurance to cover it. That would be good information to know. I believe that's part of it.
Can I just check yes if I only have fire insurance and defeat the entire
Well,
Thunder Middleton?
That goes to my solution that I was going to throw on the table of combining
I don't have flood,
the
that's fine.
insurance with the
Well,
two.
gotta put it on flood insurance already in the form, and then if there's wind insurance and.
But what if
Yeah.
they were combined? Because my concern is, flood, right? That's a big one. And fire, maybe, I'm not sure, they can deny fire cover, but let's say you're in Bastrop. I'm not sure because I don't know that level. But if we had the property is presently covered by the following types of insurance, blank with a checkbox, right? And then you can checkbox. And then the thing I'm hesitating back in my mind saying other, because other goes into your bigger concern. But breaking it out a little bit further than just insurance will provide, I think, the detail because as for any property that's out there that is in a company that's hired that has all this GL stuff, that's not really what's meant for that. But if we want that other, maybe it
Yeah, more than,
does.
last time I looked on their prisoners, more than, and I know everybody's not thinking, well, Senator Middleton's district includes Ball River Peninsula, I think, but most of Ball River Peninsula is 60% not personally owned. So you're gonna have LLCs and CGLs and all that other stuff. It's just not, I want to effectuate what we now believe he is thinking he wants.
Um,
Well, let me point out again, we already have in the statutory portion of the form, flood insurance. Is there present flood insurance? So it would be redundant. And the reason we have, this follows in the whole number 9. If the answer is yes, please explain. So if you have insurance of any kind, you're asked to explain and you're going to explain it. And I hate to make a list that's illustrative and leave something out. I don't want to have to redo this form, which is, again, statutory plus super statutory, if there's a new kind of insurance. Let somebody answer the question themselves in their own word. So they're going to already have checked flood. They're going to say they have insurance, and they may write it again. They may say casualty and insurance.
Well, we are kind of listing, we have flood and windstorm separate. So if you have flood and windstorm, if you're a buyer, what else do you need to know?
Well, that's why,
Okay, what else do you need to know?
Middleton's
that's
an
good.
attorney.
that's a good
And
point.
he's a little
I think that
Probably a friend of yours, because you probably have it
was,
very strong.
Hold on. Hold on. Let Ron jump in.
what if we just added the word here, because I think this is here, right? And so if you just add the word casualty insurance in here, which matches up with our forms as well. And I think what we can do is to simply say, property is personally covered by casualty insurance. Hold on. Then there can be an explanation of what that is. And really no explanation is necessary
It's your limit.
because it is casualty insurance, because we're already covering windstorm and we're otherwise requiring covering uninsurability here.
We note the strong, but let's get thoughts around the table here for the others in terms of boots on the ground, right? Again, going on to we're in the legal side of minds and a little political here. What about boots on the ground stuff? Let's circle back to that.
I think boots on the ground, we don't know about all the different kinds of insurance that could be on the property. And the way it is presently, every kind of insurance they've got or been denied getting is going to be listed down here in that section, which is helpful to a buyer, because if you've got some other kind of insurance, right, other than just like basic home, like our house on acreage, we have additional coverage for this whole fence issue because people kept driving through the fence, right? I think the buyer's going to want to know that maybe we had that. I mean, why did we get that insurance? Well, because we had that problem, right? I mean, I think this satisfies all that.
Well, and even if we put casualty, regardless if it's marked yes, they still have to spell it all out in addition. So
Right.
even if we had check boxes, even if we had casualty, if it's yes on any of them, they still have to write in the notes.
Can we put
property is presently covered by insurance, and then say like, list all of them below or something. I mean, I know that it says if you write yes, you have to describe, but maybe we just tell them, please list it all. List everything you've got. I don't know. Somehow word that into like, write them all in here.
Everybody's opinions on the table.
Yeah, I like the use of the word casualty, and to the point with the S, it usually has either describe, attach, or explain. So we have to pick one of those words to go after the if yes.
No, that's already there.
It's on the bottom.
It
If
says
the answer to
explain.
any of the above is yes,
Yeah.
explain,
Okay, so it's already.
attach additional sheets if
The
necessary.
explanation
Use
that,
the word.
the explanation that the average homeowner is going to give in response to that is, yes, I have insurance.
Exactly.
Okay, that's all he's going to say.
That's why I was like, no, list the types of insurance you have.
Yeah, so
List the
please
policies
list
you have.
below, or I'm fine with that.
Any further thoughts?
No, I just think the intent is to find out there's something wrong with this property, that it can't get insurance, and just generically saying, got any insurance, doesn't serve that purpose for the buyer or for the intent. But so I'm not for that sentence being that generic.
Mary, as I come back around, it's going to be everybody's opinion.
This is totally out of my league, I'm gonna tell you on this, but I do believe that, I like the way it's been worded and just leave it rather than, it's too generic. I think we've gone into the weeds. on this.
When you say leave it as it is, leave it in this draft or what's on
there?
on the screen? Okay.
The first section of Bob's section.
I'm gonna make sure everybody gets heard.
First, the property is presently covered by insurance.
Yeah.
No, she's talking about how we presented it, not
How it's presented.
Yeah.
you don't want to limit it to
Right.
casualty, is
You
what you're saying.
prefer this way here. is what
Right,
you're
you
saying.
don't want to limit it to casualty.
I don't want to limit it to casualty, but I like list the types of insurance below. Is it covered by any kind of insurance? I don't care what kind, and list them all. And if they have to write flood insurance and windstorm again, they can. I don't really care.
Yeah. But
Yeah, that's what I
Insurance
like.
covers everything automatically, and if we're looking at who's reading the form from the consumer standpoint, they do talk about my house is covered by insurance. They have to list them out below. I don't mind putting list all below.
Mhm.
That can help a consumer incredibly. But just leave it insurance. Please list all below, and then they'll write them all out.
Mhm.
Ron?
I'm not going to put my policy number in there, obviously.
Coverage, any exclusions, any addendums? Like, do I give you-
Yeah.
So I think you need the word types.
Yeah.
The more you disclose, that's on you.
I'm liking that more and more as we're going around. That's true.
I'm actually fine with list all the types below. But what I was saying earlier about Senator Middleton was he is a legislator and he is an attorney. And the statutory construction is what I was talking about, not some personal friendship. Statutory construction, as long as they let us still use it, it actually states that we are to interpret something that the legislator says is that they know what they're saying. They know what words mean, and we are to use the common meaning of words and to take them at their word that that's what they meant, unless they say something different again. And that is the statutory construction. And this is not a statute, but it is semi a statute. So my point is, especially a lawyer that is a legislature knows what the words mean. And this is what he sent us. So that's why I want to use it. I'm okay with adding the list, all types.
Teacher?
I think the rest of the statutory form is simplistic in nature for the purpose. Yes, whatever this is might be present. I want to shift the due diligence to the buyer for the buyer to do their own research. It does the same in its current form. I've got insurance. You go figure out what's right for you.
Yeah, and I'll go both ways on this. I mean, I probably don't like us going outside the boundaries of 5.008. That's me personally. Something that concerns me is not only is this form used as a tool to assist buyers in learning about property, but sometimes it's used as a sword in lawsuits where somebody says, you didn't do this, or you didn't tell me all the insurance that was on the property, and so therefore I'm going to use that to terminate the contract. Mm-hmm. And who is that former Mavericks player that they've had the big long lawsuit I can't remember.
By not attaching the form.
But because you didn't attach a form and there's value in keeping the form as simplistic as possible. I guess a statement of the property is presently covered by insurance is a simple thing. It doesn't necessarily provide any information as to the type of insurance. If we are to keep that sentence as suggested, I don't know that I'd want to say list the type of insurance below. I'll bet you 50% at least of the sellers wouldn't know how to fill that in. You know, what type of insurance do I have? I mean, I want to make this, whatever we do, make it as simple as possible. So I don't care about, I mean, I don't like the whole idea of it, but if we're going to do it, then the property is presently covered by insurance.
Let me get Darlene's, Darlene, if you wanted to add anything as well, I want to make sure everybody's opinions get heard here. And then you don't have to add anything, but just wanted to give you the opportunity. Feel free to pipe in. We'll
I think
jump in. Go
that
ahead.
a Joe Schmo homeowner, even if they don't understand any, they'll be like, I have homeowners insurance. They're gonna write something in. They know they have insurance, or they know they don't, right? And they may not know the difference between all the different kinds, but they'll at least write in, I have homeowners.
Or they'll write in the name.
And I agree with you.
Yeah, or they'll write in, I have Geico, or whatever.
Because like when I have the beach house, I had no idea about windstorm and extra insurance that was not covered by the condo and this insurance. And I mean, I have 7 policies. Yeah, I have insurance.
probably
I'm not going to tell you what
lady
they
asked
are. They're in a drawer.
That's just me.
You know?
Nobody can say that we don't talk everything through.
Right.
And the Sunset Committee and everybody that these management recommendations, I hope you realize, we really
Yes, I
care
have
at the end of the day, trying to do right. And so my mind shifted 3 different times as we just went around.
All great points.
It really did. And I can see the good points on every which way. And that's the challenge of drafting a statewide form.
Yep.
And so, and with consumers from every level of intelligence, and it's difficult. So
what do we go back to, just as it was? I'd rather as it was than list something.
Sounds like.
And I'm just gonna give you a couple of them, agree with that, figure out later whether it was a no harm, no foul.
And Brian had a really good point. If you missed on that list, all of them,
Yep,
that's a sword.
yeah, I don't like the list.
That just made me change
That
my
was,
mind.
that was a great point.
Okay, we're back.
I said
kinda-
something for you, SJ.
What?
did you hear everything?
You won it.
You left it alone.
You won.
I said I agreed with that, list the types. So,
So until Brian said what he said. It was a great
yeah,
point.
American.
Yeah.
Or,
We're leaving it like it was.
yay.
Okay, so I think, is everybody okay with that?
Yes.
I think, I'm glad we got everybody's opinions on the table, so we got back to what y'all. had
Okay,
recommended.
so we're not
That's good.
making any changes to
I don't,
any of the,
well,
That was only one issue.
I just want to
wasn't
ask a question.
it? Here he goes.
We got 5 more sentences.
No. Private road's fine. I get the point of the definitions. And so a private road adjoining for which seller is financially responsible for maintaining. I do have a concern of will they understand what a private road is, right? Whether it's city maintained or not, does an HOA's roads behind a gate?
I don't know, we just
private?
been using it for 30 years, I don't know.
And so it's whether
know
they're
if
aware
they're-
or not. And they put their aware and they explain.
If it's a public road, they're not going to have response.
Yeah,
Well, what if it's not a
they
joint?
know if they're
Or-
financially
here's-
responsible.
Or how would they know?
so the key word there, I think, is seller. So that answers the HOA question. So that would not have to be disclosed.
And I didn't have a better recommendation for
Brian.
Oh.
I didn't have a better, I just was thinking in my mind, as a practicing this, I was thinking in wanting to be right, what is a private road? And really thinking about where that fell. And I know I'm in, that little small sliver that looks at the minutia and stuff like that, but I just wanted to raise that, and it sounds like that was thought, and the answer on the conservation easement answers my question on that. The other one, I didn't know if we had any additional insight maybe from the hearings on the 500-gallon tanks, because pulling the provisions of the statutes, the thresholds to where certain things apply are much higher than it's over 1,000 gallons, I believe, have somewhere. But and that's why I went in and go, let me see exactly what a 500-gallon tank is. And it may just because this is the common tank that's on all the properties, and so that's the threshold we're setting.
Show and tell, baby.
And this has a self-containment system on it. Not all of them do. That's the picture that I pulled up. But so I think that's justification is maybe just the common use one and not tied to anything. But I wanted to ask to see. If
Right. We didn't have any direction because of the sort of the vagueness of the direction from the management action. So if I believe correctly, the focus was just on above ground storage tanks, but we broadened that out to include any underground storage tanks on the property.
Why would you do that if you're supposed to take what they know as gospel? And why would you add something extra?
I thought we
Okay,
had-
let's go to the
Part of,
It was already a
part of that
question.
was because of trying to distinguish between different types of tanks.
Yeah, there's a lot.
So
of
we
them.
just simply said, tell us what tanks you have out there.
Makes sense.
And then we asked the specific question. That was the reason for it.
And it was not tied to any particular type of tank, right? In terms of petroleum storage or water storage, or I mean, would a rain harvesting system potentially fall if you have a 500 over a 500-gallon?
You'll have propane, you'll have diesel, you'll have gas, and you'll have water. Probably there's more even out there. Oil for heavy equipment.
And I'm okay with it as it's written. I just wanted to talk through a little bit of the.
Just grammatically, you shouldn't say which, it should be that. That holds 500 gallons or more.
Okay.
Oh, and that actually does have the petroleum language, sorry, or other chemicals.
Right.
Yeah. Okay. And that would exclude water, water not being a chemical.
Yeah, so that language there came from the management recommendation.
I actually like that disclosure. Issues I've had with prior ones.
That's the public member, Mr. Austin's recommendation.
If we are expanding past it. Good one. So farm and ranch contracts, I say the one thing I want to bring up on that is 7H of our contracts at farm and ranch address underground tanks already. And so if we're putting it in here, I think it's okay, but I want to raise it because farm and ranch, we have that built in because a lot of time you're not required to get a seller's disclosure in a farm and ranch sale.
Correct.
Right. And then we also said, well, it could be repetitive in the farm and ranch sale that does use the seller's disclosure, but those are at two different times. Those were given or drafted, I should say. So we thought
it was okay. 2 is better than none.
That's it for that language, right? Or is there any additional?
So the only change we're going to make is to the grammatical changes that we're just dealing with the 500-gallon tanks. We're not making any other changes to the seller's disclosure notice.
Correct.
That Abby crafted, and we should applaud her for doing because she.
Thank you, Amber.
And do we want to then, it's 11:40, I'm not sure if lunch is here yet, but do we want to craft the language? It is, okay. Do we want to craft the language for the minutes or discuss what Brian has suggested in terms of when we send this form up, how we send that?
Yeah, so are you, well, I guess for the seller's disclosure, we can address that issue.
I think maybe we knock that out, then break the line.
Knock it out.
So if we want to or not. And Brian, it's your thought if you want to restate the earlier words you had for suggestion about when we send this up to the commission.
It would simply be, the committee has been informed that the Texas Sunset Commission has recommended additional disclosures for the seller's disclosure notice. While we have, while historically the form has been a form strictly in compliance with section 5.008, these additional disclosures may be added if desired by the commission. However, the committee does not express any opinion one way or the other. That's what I would say.
And we can talk about
It's a
whether we'll make
commission
it or not.
decision. If the decision is made to add the language recommended by the Sunset Committee, we recommend this language.
And that goes a little, if there's enough strong feeling against having that language, I think we can look at taking this vote, whether it's recommended or not. And I like the language that Brian just drafted, because we're not taking a firm position that I feel might open the door a little bit more to a long-standing policy that I thought there was good reason for. At the same time, we're complying with what was asked of us to do, and we definitely gave it.
Showing respect to the
The commission, to the representatives that sent it to us, and I think nobody can say we didn't talk it through. But does anybody have any strong
I
opinion
second
on
what
it?
Brian said.
Yes, let's vote. Yes.
Yeah, and I don't know if we need to vote in light of that, but that's.
You don't have to take a vote off everything.
Okay.
That's fine.
All right. Well, with that, at 11:43, we'll break for lunch and come back at 12:10, 12:15, 30 minutes for lunch. Yeah, we'll do 12:15. 21, and we left off over lunch. Esther and I were going to discuss a definition of surface water and propose something to the group. In our discussion and looking at the possible definitions, we decided that it's probably best not to recommend a definition of it, because it is, for two reasons. One, not necessarily black and white in a way that would make sense with an actual true legal definition. And two, the purpose of the form, having it tied to disclosure of their rights to surface water, is already defined in a way that if we add right to the top, we think would accomplish the intended purpose of the form without providing more confusion in general. So that was our lunchtime little powwow that we had. And so with that, I think we're ready to look at voting on that form to push it through, or agreeing. If everybody's in agreement, I don't think we have to go. But any thoughts from where we left off?
So on the water rights form and the changes to the contract.
So we have the one form we already have in the minutes, which is giving disclosure for the such disclosure in the overall one.
Right, we have it in the minutes, but we didn't vote.
Okay, I think we're all in agreement on that one, so we have to. And I'm not sure we have to on this other water disclosure form as well. So, but I bring it up in light of us not recommending a surface water definition. Does anybody have any further thoughts they want to throw out before we go on, or does anybody feel like we need to have a vote on that, or consensus? Okay, with general consensus, we'll have that in the minutes and push that forward. Next up, Ron, am I forgetting any outstanding business from before?
No, just on the compensation question, we can defer to there. Well,
okay. And I think that may be our next stop from the working groups.
Okay.
I will hand the floor back over to you. We have the working group for compensation that worked on this issue on paragraph 12 and others.
So after some discussion, we decided that we would punt back to the whole committee as a whole, because we did not have consensus on any changes that we should actually take in paragraph 12. That part of the reasons was that we really hadn't lived with the changes in paragraph 12 very long. And so we weren't ready to recommend any changes. But secondly, there simply wasn't consensus about what to do in interchanging. So we've said this is something that the committee as a whole should actually take up. And so we punted our work back up here. So.
Okay. And there has been a lot happening in our industry in the understanding or misunderstanding of the language that we have. I think if we're honest with ourselves, we would look at it and say there, rightfully or wrongfully, there's a lot of confusion, and we may think it's just an education issue, and I have strong opinions on that. And education definitely is key. At the same time, myself personally, I hear a lot of confusion that people, even with education, may still be tripped up. And I view it from the lens of, can we do better? I know there's still a concept of, do we need it in there at all? Right? There's still a thought, and some people still want more. And if we look at the comments we'll go through later, that's a big part of, the spectrum is still there that we've had from the beginning. And I'm trying to think of the best way to tackle this, and when appropriate, I have some suggested language that I would like to see a slight tweak to paragraph 12, to leave it in, but to tweak it. And I have that language, and I don't want to, throw that out there as the foundation. Over, Ron, I would defer to you as leading subcommittee and your thoughts on how you'd like to lead the discussion on that. But those are my general thoughts on that.
Yeah, so I think we had pretty much varied on leave it alone. I think myself included, one of the issues is let's just come up with a good concession paragraph and just leave it like that. So the whole issue that I think the confusion lies in the fact that the industry is still offering compensation to cooperating brokers, whereas if you can imagine that if the industry didn't do that any longer, then it simply would be negotiated as a concession in the contract forms or something that you see in the commercial forms published by TR. Those would be what we think would be a good result either way. But moving the industry away from offering compensation between brokers is a whole different question.
And what we have now is the dual system to tee up for those that are listening to this part of the meeting. We have seller contributions, and then we have separately the cooperative compensation. And there's a discussion point, and I know some of our visitors here have very strong opinions on that aren't back from lunch, on what is the nature of the seller contribution. And there's some confusion out there on, is this a direct payment for the expense versus something that's a contribution to the overall amount that is used by the buyer to pay the expenses that they have incurred separately. So that's on the table. And so we have the distinction between cooperative, which is broker to broker, the contribution, which is seller to buyer. And then even within that, we have what's the nature of the contribution from seller to buyer. And how do we make it more clear? And the points that I would like for us to discuss today is the language of paragraph 12 that we're seeing and maybe potential tweaks to it. I would like to revisit, there's recommendations and thoughts out there if we're moving page 10 still. Everybody's thoughts on that, and then see where we land. Is as far as before we get to suggestions and next steps, I think this is a good opportunity if anybody has comments on what they're seeing out there and confusion that we can add with the brokers, especially boots on the ground, what the confusion you're seeing from your point of view.
I'm not seeing that much of a change. They're still calling us and asking what we're cooperating with. I mean, they're not, I don't see a lot of the change. They pick up the phone or they're texting saying, is there compensation or whatever? You know what I'm saying? They're not even looking at 12 in a lot of my cases. Now they do when I tell them the seller's asking you to put the offer in paragraph 12, but they're first calling.
Most of the confusion that I hear in our market on paragraph 12 is labeled as paragraph 12 confusion, but the root of it is they don't understand the options that are available now. And we're not gonna fix that with the contract. I think what is here is pretty clear, and we haven't lived with it very long. So I'd like to hear your suggestion before I actually just, poo-poo it. But I'm very nervous about making a change to it so quickly. And I think that the industry is moving away from co-broker compensation, but it's gonna take some time, and maybe our form's just a little ahead of the game.
And I shared that concern about changing. I'll go to Melissa and then Christy. And I just sent in the recommended change yesterday, or what I proposed, what I was thinking could be a tweak, just recognizing the disputes out there. But it is early still. And I think the language is admittedly a little confusing. That could be tweaked. That's where I ended up where I did.
I agree that I don't want to make any changes yet because I think that'll just make it worse. Really and truly, I think that will make it worse. But I also think that you're right, that we're probably ahead of our time because there is definitely a general consensus that we might be heading that direction. And it's just a process where at some point there won't be as much, if any, listing agreements where there is cooperative compensation. And I will also say that I think it's important when we're training on it, because it is an education issue, a lot of it, is that you can't just do a contracts training and say, we're going to learn the 1-to-4 family, because you can't understand it unless you also train on the TXR listing agreement, right? Like that is so important. And the problem is that not everybody uses the TXR listing agreement, right? And so
it might lead to this other discussion we
right,
gotta have.
exactly. And so, but they have to understand what the choices are over here to understand how to appropriately fill out the form over here. And that, I think, is where the problem lies, because as an instructor, when I teach on the 1-to-4 family and I pull up the TXR listing agreement and I just say, look, your brokerage may have a different listing agreement. I don't know what you're using. All I can speak to is this one, because for me personally, I am a realtor member. But what if you're not, and you're missing some piece of the puzzle when you don't have the listing information? And I think that that's really hard. And the other thing that I think is important to note is that some agents are not coming and take the training, and they're just freaking out because they want to make sure that they're paid, regardless of if that's what's the best for the consumer or not, or whatever, however all that, they're like, you know what, I'll just put it in 12 and I'll put it on this other form and I'll put it on the last page of the contract. And it's just everywhere because somebody somewhere is going to say that one of these is right. And that is where it becomes problematic. So
I agree with that too.
So everything that Lee and Melissa said, the agents that do consistent, regular business and have had attend training and stay plugged in and knowledgeable as a real estate agent should be in their business when conducting a business are not having a problem with it.
Absolutely.
It's those other morons.
It is the ones that do one transaction every 6 months. They have no idea what's going on in the industry. They don't go and attend training. Brokerages that aren't providing the training and taking their broker's license seriously, and not stepping on anyone's toes, but we know that they exist. And we're doing a lot of the education when we get in the offers and having to help educate those agents on what the proper way is. Melissa's absolutely correct. They're just putting compensation in everywhere. And I'm going to say this as kindly as I can. If you read the forms, instead of treating it like a fill-in-the-blank document, to me, the language is very clear. If you read the disclosure on page 10, it is very clear. And if you cannot read the statements and understand what they mean, there may be a bigger issue as to why you are holding a license and why you should be representing someone. Like I said, I'm saying that in the kindest way I know how to. While I also think when it comes to them understanding paragraph 12, they're not looking at how things are indented. So it's very clear, once again, how it's structured, what falls under what. I am very interested, though, John, to see what your proposed language is. But I also think it's very soon. And I do believe that we are moving towards less cooperative compensation, because I can already see the trend that a large mass of sellers are moving towards making it completely negotiable in the contract. And I believe it is lovely the way we have it set up, and it's simplistic in what it is.
I'll agree with what the three of you have said. And I think it's a re-education. And I too would like to see what your comments are. I think it's too early to make anything major of a change. Realtors have gone through too much since August of last year with the form changes the Texas Realtors have. I've become more and more aware every time we read the emails that we get that the consumer the license holder doesn't know the difference between the trade association and the commission. We've got to educate them on that issue because they are so totally different. I think currently, if we made any change, I'd like to see in 12A1B where it says to be applied to brokerage fees that buyer has agreed to pay, that buyer has agreed to pay. We know what that means. Maybe we were too close to it all in crafting it, but I believe it means the buyer rep agreement. So maybe we need to be clearer for those who don't do as many transactions. Those that have been educated and do a lot don't have a problem with it, and they're grateful for it. Ultimately, down the line, I still like what Farm and Ranch has, because there we have the buyer and the seller signing off in the contract who pays what. But that's down the line, and it may be not that very same wording. But if we could have everything in one place, eventually, when this all shakes out, maybe in a couple of years. But I too agree that they just don't need another change. Clarification, maybe if that's an area in the wording in 12A1B, that might be. But aside from that, I'm happy. I'm not happy. I think we're okay with it.
I think the 2402 is gonna go away. I think we're just gonna go to paragraph 12. I think eventually all the brokers are the broker compensation.
If the listing agreements changed, sure.
Huh?
Yeah, it has to start with the listing agreement.
Right. And I think it's gonna happen because then the listing agreement's gonna change anyway, because if the law passes with some agency.
Sure,
So-
but we've got to remember there are 50,000 license holders out there that aren't realtors.
Yeah.
So we have to think of the overall license holder and these contracts and the consumer.
But a non-licensed, a non-realtor doesn't, unless this law passes, they don't have to have a buyer's rep agreement.
Well, I understand, I'm talking about the listing.
Doesn't mean they shouldn't.
compensation.
I know it shouldn't, but they don't.
Right, we could just
Yeah,
go with
Have to.
12.
Now, if the law goes through, we all have to, and that's.
Right, I think we're.
I want to
going
go back to something you said though, about what's in the farm and ranch contract and eventually having it. I think you gotta be prepared. That ain't happening. The Department of Justice does not want this stuff in the contract. And this body is gonna have to deal with that.
And
So.
I don't think that's on the table for today. Tony, any thoughts you want to?
I mean, I hadn't seen your suggested language, but I think I'm not in the trenches like these ladies have just explained what they're going on. I'm not probably the best one to ask how the feedback on 12B is. They would know a lot better than me.
Shift over to, I guess, Esther and then Title and Darlene as well. Though we got Esther, you want to jump in?
Nope, not yet.
Title?
My wife and I, from some weekends, we'll go out and just look at open houses in our neighborhood, just to see what's out there. And whenever I go, I uniformly talk to the agent showing the property. And I ask two questions. I say, number one, have you seen any effect on commissions? Are they lower as a result of the changes? And uniformly, they say, nah, yeah, we think they're just essentially been the same as they've been. And that's anecdotal. And then I say, so what do you think about how agents fill out the contracts with respect to commissions? And what I always hear is, I know how to do it, but boy, those other agents sure are stupid.
Everything.
Yeah, so, yes, and it's, I just sort of chuckle every time they do that because it's always the other agent that doesn't understand. But I do agree with the concept that we need a lot of education, but we have a whole lot of people out there that they're never going to be a thoroughbred and run a fast. So, you know, it's the poorly educated you will always have with you.
Yeah.
So to me, finding a simple solution, and I'm agreeing with what Diane says, having something where everything is all on one page so people can get it in their heads as to what are the total commissions being paid and who's paying them. Ultimate, I don't think we need to do it now because we don't know what DOJ is going to be doing. You know, I think it's an ever-changing landscape, but I do see something in the next year or two. This is something that we have to address to make it simpler and easier to understand. We have to live with the people that are filling out these forms and, you know, what are their abilities to do so? There are people who get confused. What can we do to make it simpler so that everyone can understand and do it the right way?
I think it's premature to make a change for all the reasons you guys have said. The producers are doing it. They know what they're doing. We're still running into agents that are writing their first contract since the change. We, on the title processing side, are seeing some very bad examples of what's actually happening. Most of the time what's getting confused is the sharing model being duplicated, you know, also in paragraph 12. And I hear a lot of commentary that we also have a gap in communication as far as any portion that would be paid to buyer broker compensation not contributed by seller. The portion the buyer has to pay because it's not present in the contracts, which means lenders can't work up their estimates correctly, and it's causing some right before closing problems. But I don't think we can fix that stuff now. I think it's incumbent on the agents to communicate to us and to the lenders that there's an additional differential that has to be paid.
Darlene?
I asked some of the closers in my office if they'd seen anything. I figured they hadn't because I would have heard about it. And so far, we've not gotten any feedback or had any issues. Knock on wood. I mean, that could change, obviously, but that was what I got back from my question. So.
Yeah, Ron? So I didn't want to prejudice, what's that? From the guest. So before the guest arrives, you know, I teed this up and I'll recircle my thoughts back around to tee up my suggestion. I am seeing, if we recall our history of where we ended up, where we are now. When we were discussing farm and ranch, which is more the full disclosure side, you know, for myself personally, I'm a big believer in freedom of contract. You should be able to contract the way you should, but it should be clear. As a 6-7 vote to continue that discussion, and we decided to stop it to go down this route. And then we decided what's the best thing we can do to end up on the route we did with paragraph 12. I agree that it's early, but at the same time, Diane, I think you said it really nice of if we can tweak it to make it more understandable without changing up the nature of it, without going too far, is where I ended up. I know John Holland had concerns on the nature of the actual contribution being made. I teed this up. We have an issue with paragraph 12, verse page 10. And we also had the issue of within paragraph 12, what's the actual nature of that, right? Whether it's being paid directly to the effectively the buyer's agent, or is it being paid to the buyer that, or contributed to the buyer that then pays them. Where I have been seeing in all the classes that I've been teaching out there and discussing this with amongst many different brokers and polling them is, I think they understand the concept quite clearly of paragraph 12 of the contribution. They may get confused on the differences between the two, but it's the language that is the buyer has agreed to pay that you pointed out. And one other one that I've seen as a common misunderstanding is the other expenses, other buyer's expenses in C. And even those that are attending these classes are the educated ones, the ones that care, that are engaging. that even with taking multiple classes, some of these agents I've taught multiple times over and over is a hard concept for them to grasp of that has free to pay. And I think the different levels of where people come from and their strengths, it's difficult. So that's where I was firmly, we had to see this play out. It's clear as it is in at least in my mind. But the language that I proposed, I want to get everybody's thoughts before I prejudice anybody on what I had. It is a tweak. It's not changing the language up, but considering those two main things that I see of that buyer has agreed to pay in subparagraph B, and the other in subparagraph C, I've made a change. And Ron, do you have that handy?
I was just making changes to it. No, I'm just.
And I vetted this by my wife, Erica, who's 20-year broker. She started monkeying with it and going back and forth, spent an hour and said, anything's going to be add more words. Or if I take something out, it's going to result back in that same confusion. And so I haven't had much input on this other than coming out of my.
So this is the number one up here is what's existing. So what you were proposing is striking B and C and adding this language.
So it's adding language, keeping the same language in B. So we're looking at this.
Is this paragraph 12?
This is paragraph 12A, 1B. So this is what exists right now. The following amount to be applied to broker fees that buyer has agreed to pay, right? And then it has the two options. And the language that I believe is confusing is that buyer has agreed to pay.
Yes.
And so I was trying to figure out how do I address that narrow issue. And so this is the language that I came up with of keeping it the same general structure and amount not to exceed blank of the sales price, check one box only, to be applied toward broker fees owed by buyer to buyer's broker, but in no event more than the amount buyer has agreed to pay under a separate written agreement with buyer's broker. And so it's a little, I wish I could shorten this part up, right in there in the middle, but I couldn't figure out a way to state it more simply that would be understandable. And so I admittedly, it's a little wordy, but
Well,
that's the best I could come up with.
And taking your wording, that's the part I have, what I highlighted here. I have this part right here.
Me too.
Because I think it encourages an amendment to the buyer brokerage agreement. Well, I'm going to get the full amount, I'm going to do this. So now I'm going in and amending things up. I thought, and plus it's a little bit different than your maximum amount, because I don't, so I think you can just simply stop there.
Yeah.
And that language is fine, and it's the amount to be applied by brokers. If they change the agreement, then they change it.
Because we didn't
I actually
specify
did
that.
by wax it off and keeps it short to.
Why couldn't you just say that buyers agreed to pay in the buyer's representation agreement and not even do that whole,
In a separate agreement.
And say buyer broker.
like the original language up top, and just say that the buyers agreed to pay in the buyer's representation agreement.
Yeah, I mean, you could, but I guess the question,
I'm thinking just for the sake of it, right?
There.
The amount to be applied to brokerage fees that buyer has agreed to pay under the buyer's representation agreement.
Or in a separate written agreement.
Or in a separate agreement, instead of that whole other extra verbiage.
So I think the confusion is the beginning part. That's the following amount to be applied to broker fees that buyer has agreed to pay. So it's
In a separate written agreement.
and then
I think if you say in a separate written agreement, they're gonna get confused about a written agreement with who.
Yeah.
That's why I
Say
said,
buyer broker agreement,
yeah,
Right.
then
Just
it's
focus on that.
specific.
Yes,
Well-
I agree with that.
But then you have the companies out there that are not paying the brokers. So you can't sit there and say they're gonna get 3% be paying to the brokers, because you've got companies out there that are not paying the brokers. It's
You gotta-
getting on the HUD and it's from the seller.
you have to have a
They-
buyer's representation agreement now.
Yeah,
So just say in the buyer's representation.
a brokerage. It's not a
Sure.
representation,
Well,
buyer broker.
Buyer-
True.
So
but I'm okay.
I'm just saying the word
understand what
that
you're
he
saying.
put in, okay, go up to what John put.
Right here, this is what John has right here. This is what,
Okay, the brokerage fees owned by the buyer to the buyer's broker. The question I have on that is you've got some brokerages, you're not paying the broker. The seller's paying the buyer and the buyer's paying off. So I don't know if that would confuse people.
Or would it just be NAs because it doesn't apply in that
Or
situation?
you wouldn't include anything, right? Or it wouldn't, the cap would come in if they're not actually paying anything. And this is all that buyer has agreed to pay confusion, right? Some people think that's the amount that buyer's agreeing, that the buyer's paying that amount that's listed in there.
Right, that doesn't change the fact that the seller's still paying the money to the buyer that the buyer is then using towards their broker's fees that are owed.
So I mean, even if you ended it, fees owed by the buyer, boom, but I'm just saying,
I think we have to delineate that as the brokerage fees here, or they'll get confused with C again.
Right.
yeah.
And look at
Because if you
C, so
close
these
with a
are
certain
my
company,
C
it's the
change.
same.
Okay,
Yeah, so down here, all we had was to other, an amount to C blank applied to other buyer's expenses. And the common misconception out there is buyer's expenses is a defined term in the next paragraph, A2. And we've included now in our language, the listing of broker fees buyer has agreed to pay within that definition. And so this is something that the intent we had was to split it out. We don't know what a court will say at the end, but definitely the intent when we drafted it is to distinguish it. We had a little caveat. We don't know how it ultimately will be interpreted, but we know what we've tried to do. So just making a little clarification applied to buyer's expenses other than brokerage fees to distinguish.
I like
that.
that.
I like that.
Yes.
Oh, I like C. I just have a question with the one you're saying paying the broker. Cause I don't know, I'm not a broker of that company. I don't know what their interpretation is. But if you look at HUD, when I've closed with
the
them,
question.
okay, when I've closed with,
Let's say, look, maybe see.
when I've closed with a company, I don't want to say companies, but when I closed with a company and they do not pay brokerages, they won't 1099, they do not pay brokerages. They give a credit over to the buyer
You're
and
talking about
Are you
cooperating.
talking about title
You're talking about
companies?
co-op. This is not
I'm so-
well, it
cooperating.
would be, that's what they fill out. They have to fill out paragraph 12. They don't
Not for
use a,
cooperation.
not for cooperation.
Buyer and
No,
seller.
this is between.
This is in the contract. This is
Between the buyer and the
Buyer
seller.
and seller.
It's
right.
just
That's what I'm just saying, the word broker, because he's saying paying the broker. And they
And
have
that's
made
not-
it very clear, we're not involved in this program.
And this is the
To be
buyer.
They wouldn't
applied
see
toward
that.
the brokerage fees by buyer to buyer's broker. I'm not reading that goes straight that is not broker to broker at all, the way John has that written.
Okay.
Right.
Yeah.
What are you teaching, Mary, by the way? out
No,
there?
no, there's just, they have a separate paper right now. And it goes on a separate paper and they are very clear
Yeah.
Like
that they are
Title
not.
company?
Huh?
This is a title company?
No, this is a big blue and white company that's a cloud base.
So they're just doing, the buyer is expecting in that, they need a buyer's rep still, right? Or if it's.
Yeah, they do the buyer's rep.
And then in the buyer's rep, if they're not
But if-
charging anything, don't have any fee, then they're limited by what is about to be Texas law, it looks like.
On the DA or the HUD, whatever, they say seller paying buyer and they give the buyer a credit. Then it's up to the buyer to reference their buyer's rep agreement to
Okay,
pay.
Finally understand what you're saying. And I don't think we should do this today,
Okay,
but
that's my question.
for those of you who will still be here in another 6 months, you might consider the language that we use in 7H related to the residential service contract. Because it says seller shall reimburse buyer at closing for the cost of, I will insert, buyer brokerage fees not to exceed X amount.
That's a great idea.
It is a brilliant
That's a
item.
great idea. It's a great idea, it really
I
is.
do think it's too soon, even if it is brilliant, I think it's too soon to make the change. I think we
Okay.
should give it 6
But
months.
that covers what I'm
Another
talking about.
6 months.
And it,
Everybody doing.
That's your out piece, right, Lee? That's your like.
Swan song.
My out pieces do not mess with the option period. That's my out piece. 5 PM, don't change it.
and why I held back so long, because with the thought of waiting, right? And whatever we do now, the earliest would be January, right? And then every time we kick, it goes back further and further. Those two issues that I raised, that the buyer has agreed to pay and other, I don't think the confusion is going to change because of the universal misunderstanding that I see amongst those that care and take the training, attend the training and do it. It seems to me that is a stumbling block that is insurmountable for some. For whatever reason, it's there. So that's why I went here, and I defer to the, the group thought on that. But if it's a tweak, even if the tweak's out there in comments so people can see it, right? The commission may not take action. We may not decide to do it, but even having something there that's proposed to get comments back on, or something at this point, I think would be helpful.
I do agree. Those two areas are the crux of the misunderstanding. And I think the changes need to happen fast. It's also going to show that Trek is paying attention to what's happening to the license holder field. And we're making a simple change to be clearer for them to explain to the consumer.
I like those. It doesn't change the way we have it structured. It just tweaks the language very slightly.
And I'm liking Ron chopping off the second half of that.
Me too.
That makes it simple.
So we're recommending then B and C be substituted accordingly, right?
The residential service contract.
Unless if we're gonna make the change, do you want to jump to the reimbursement?
But it can wait.
What do you mean the reimbursement?
Yeah, I still like what you said, Lee. Because that's so clear, the credit.
But that's a huge structural, I mean, that has to go out for public comment, right?
Seller shall pay
I think they'd understand it more.
Keep it simple.
I do.
To be reimbursed is what he's saying.
To be a reimbursement to buyers for brokerage fees owed by buyers.
I can tell you the reason why. I think the term reimbursement, reimbursement means that there's not a cooperative relationship for B. There's not a cooperative agreement between brokers. So until that goes away, the word reimbursement is not going to work.
This is payments by seller.
Correct. So what I'm saying is that, I know. Oh, I see what you're saying. Okay, never mind. You're right.
But doesn't reimbursement
one
mean it's
thing
already been
that-
paid?
And I'm gonna ask this question. One thing that I've seen the confusion being is they don't get the concept that this doesn't include compensation being paid by the listing broker to the other broker, to the buyer's broker. And they confuse the two, section 12 and page 10.
Well, I just think we should get through it.
I mean,
Page 2 and B.
Personally, I just think the easiest way is.
That's
Let's
more of
just-
a structural, that with education, I think is more fixable than
okay.
this, at least in my.
Let me throw this
Well, we got
out.
rid of
You can
page
shoot it
10.
down. But in this B, what if you add something like, do not include compensation to be paid to buyer's broker by the listing broker?
Or did
That will confuse them more.
I think it clarifies it. I just don't know that.
We're not talking about.
I don't think you want to add that because that won't always be the case. Because to Lee's point, the industry as a whole is leaning away from it.
12B would never be paid using compensation that the listing broker is giving.
Right.
Right.
This is money given by the seller, not by the listing broker. And the confusion I see, or one of the lots of confusion, but one of the confusions I see is they think 12B is part of the compensation being shared by the listing broker.
Correct.
I think you're right.
And
but
they're two different things.
Right.
Would
You're
there
right.
be something in 12B where you say, this ain't where you put what the listing broker's paying?
does that
I think you
belong
just
in the
confuse the other half.
Yeah,
Just
I
replace
don't,
it
I don't
with
like
the
it
other.
because I think we're heading to a place where that won't be happening as often.
I think
We
if
have
you
to
put
deal
the
with
buyer broker
today,
agreement in
okay.
there, you're good.
All the more reasons to have everything on one page.
I don't know how long it's gonna take.
Well, and it may never go all the way away, but
The title company could have a form that
Yeah, make-
you're the one who needs the information.
Let's
We know what we signed. We got it figured out.
Doesn't, I mean, This is fantastic and helpful, but we have to ask every time right now.
Yeah.
Let's bring up page 10. Let's go and throw the other iron in.
Hey, that's the third row.
Throw page 10 in the mix.
Somebody want to take up the first thoughts on?
Sure. I will. Well, I think it is fully understandable for, as Brian used this term, the thoroughbreds who read things. I'm fine taking it out if it makes it simplistic and people stop misusing it.
I'm going to ask title on this too in particular to weigh in because to tee it up for everybody, the amount in page 10 is informational only, period. It's not an enforceable agreement. It doesn't establish an enforceable agreement. You may argue it evidences one later, but it's not intended to establish a enforceable agreement. And at one point in the what is now becoming the distant past, we suggested taking this out. And the pitchforks came, we suggested because there was a difference. People were putting X amount in the contract and Y amount was in the MLS. And there was a conflict. And a lot of agents, license holders have the misunderstanding that page 10 controlled. And it didn't. It absolutely was the MLS that controlled. And if we look at it today, it's the same concern, but now we have separate written agreements, the 2402 and others that are establishing it. And if there's a conflict between the 2402 and the contract, the 2402 should control. This is informational only.
Yeah.
And so and I have an additional concern about the written agreement requirement that I'm talking myself out of bringing up too much unless when you get there. So we suggested taking this out. And the pitchforks came out and said, how are we going to know what the commission is? Proved our point. If we take it out now, that question is going to come up. How do we put the commission in? Or are people going to start using paragraph 12 more to put in what is cooperative compensation without an explanation or a place to put it elsewhere? Those are things, not easy answers, each one. I'm listening.
I have a question for the folks on the title side, because I see it where it's in 12 and it's here and it's on the 2402 and it's all the same number. And I'm like, for the love. So my question is, as a title professional, how many times is this information correct versus it doesn't match anyway, and it doesn't really matter that they put it in here because it was just another place where somebody stuck some numbers in a blank? Because I feel like that's what's happening.
This specific section here is probably correct 90% of the time.
Is it?
If we're doing the sharing model. Where I see it go sideways to the incorrect side is that they will also include it in paragraph 12.
Well, sure.
That's still only happening probably 20% of the time. And so I feel like to take this off now is going to be way too much too soon for everybody using the forms. I agree that at some point it's appropriate to take it out.
Yeah.
But we need to get everybody settled so that they just flat understand how to use the contract in its current form before we start making a bunch of other changes. Because we're not even 50% of the way of everybody understanding the form at all today.
That's a good point.
What if by the way, I'm good with just taking it out, but as a compromise, what if we took out the amount and we said any compensation between brokers is in a separate written agreement between those two brokers?
But, okay, and I haven't said anything, but I mean, if it's the buyer paying or the seller paying, it's not just between them, it's the seller and the buyer.
Yeah, but that's in paragraph 12. It's in paragraph 12 or separate written agreement. I said specifically between the brokers, because we're in this little broker information box. So any compensation between brokers is in a separate agreement.
I like that. And then they can't fill anything out and screw it up.
That's fantastic.
Sorry, second score.
There's separate amounts. If we look at the spectrum of removing it all the way over here, in the middle of leaving it in as it is, not doing anything, then leaving it in and adding more. And we kind of did that pendulum on the last time we looked at page 10, right? We took it out and then everybody pitchforks and we put it back in with the additional sentence. And so, I mean, those are really if we look at kind of starkly in boxes, the options. I agree with Leitra that this is, if we take it out now completely, it's a lot. I think it needs be done at the end, but I do fear it being overwhelming when it's still serving a purpose in the industry as well.
It just takes so long to trickle information to every single agent and every single brokerage that I feel like we also kind of run the risk of losing some credibility if we're constantly making changes. Yeah, they're very, they get frustrated when we're making little changes because this isn't the only thing they're doing in a
The people that
traditional.
don't know about it don't know about it yet because they haven't done anything. So we're talking about the same
Kind of a
thing.
little
What do they
window
have to take in
to,
their MCE
Well,
on it, or is that
what are the
true?
educators?
this disclosure, I think, appropriately goes in paragraph 8B, because we make a statement there that all obligations of the parties are, for brokerage fees, are in separate written agreements. So I think what you could do if you wanted to, is you could make a non-dollar disclosure there that would say each party, buyer pays his broker's fees and seller pays his broker's fees, or there's a cooperative agreement that exists between the brokers for their fees, and then don't go fill in paragraph 12 if you want to do that.
I like
I
having
wouldn't
the
do it there.
disclosure below the signatures. It's not a part of the agreement between, so.
I think they're used to seeing it.
Theoretically,
Yeah.
So if we're gonna, I think we kind of have to leave it there at least for a while.
Okay. I mean, I think
Yeah.
we do have other disclosures scattered throughout the contract. So
That they're not
The
really.
only thing I can
if we're going to
see
talk about brokerage fees in 8B, why not talk about brokerage fees?
is then agree, that's the seller and buyer agreement.
Okay.
As opposed to
Oh, yes,
brokerage.
please. Thank you.
So no, it says all obligations of the parties for paying their brokerage fees for obtaining such agreements.
Mary,
With
that
with the agency bill that most likely is gonna be signed, that most likely is gonna say everybody has to have a buyer's rep agreement. I mean, that's gonna be law.
All the way from that
everybody hold one.
Can't it, we can have that off, and can it go up under all the forms that a 2402 is added, or the rep agreement, because it's law.
It's a little,
I'm asking because it's law, it's gonna be law.
well,
That's
it's a
why I'm
little
asking.
distinguished. I'm seeing two separate things here. So you have the cooperative comp agreement, which is this, and then buyer rep is a separate agreement just with the buyer and their agent. So I'm not sure, I'm not seeing where this separate one over here, the buyer rep agreement, would be put up in the contract.
Well, because first of all, because I figured because it was law, they might want it attached. Legislation might want to say, did you really do it? Not just rely on us as brokers to say, all our people did.
And let me jump forward to what I'm thinking at the end, because this will be, I think, reserved to the end. We had a lot of comments to get through. I'm assuming everybody's read the comments, especially on paragraph 12. And everybody know out there, we've read them on 12 and are considering those as we're discussing it now. Yeah, but and there's a couple of, there's some, I like when we get unique ones. There are a couple of unique ones there. But my thought on Senate Bill 1968, there is going to be a big discussion. I think I talk myself each way out of this. And as much as I like our longstanding thing of not having any buyer representation or listing agreements, having a state mandated form that sets out, you have to have this, and this in your buyer's rep, and not having a readily available form that a broker, that we know how a lot of brokers operate, is available to them, to every broker, right? We have association forms, we have broker, creative forms. I think there's going to be a big gap there that brokers are going to pull forms offline or inappropriately go against the copyrights of the trade association forms. And my ultimate concern there is consumer protection. What are they going to be putting in those agreements?
I agree with that.
Yeah.
So I think we have to have a discussion on that. And I was going to suggest that we tee up a working group to look into that issue for us. And it's too much to go through in a meeting. There's so many concerns. It's not yet law. There's a lot to dive into and think about. And I have some thoughts on throughout there justifications that I think we go around the room and talk about, but tee that up. So to that, that separate issue of the buyer rep and this requirement and where it goes. And I think in general of having a private contract between parties is not generally a good idea to force to attach to an agreement, but it could be within that mix that goes into the work
I was just
to discuss.
thinking some way so title gets communicated. You know what I'm saying? If they're not using paragraph 12.
Well, they should be on the CDA.
And
I
Although
mean, there's a CDA.
I'm having problems with that lately
We
too.
ought to be talking to our lenders. I mean, this is about agents behaving.
Yeah, and communicating. They need to communicate. That's a huge part of our professionalism, is to be able to communicate among ourselves. Whether that's agent to agent asking if there's cooperation or not, or whatever that might
Letting
look
the
like.
lender know
or
what the
whether
buyer's
it's- yeah.
saying.
Yeah, us talking to a lender or us letting our title company know so that they can do what they need to do to make the transaction come to fruition, because that's what's right for the consumer. And
Not
our
me.
professionalism and our communication.
Committee, sorry,
That's fine.
not me on your committee,
Mhm.
for that group, but I
Like
think
your
it's a
number,
good
I should
idea.
change it.
I know you do.
Mhm.
But I think it's a great idea, and I presume that you, knowing you, you've probably already come up with sort of a drafty draft of what the subcommittee would look at.
I have
think
not
it's a
the
great
buyer's
idea.
rep. I have thought my concerns through a lot, and I'm really torn because I see a lot of issues with it. But I see where I keep going when I think about the issues. I think about our longstanding policy. The main objective of this committee, the main statutory thing that we're required to do is consumer protection. And I
Well,
just can't help but think about.
And provide forms for licensees to use. I mean, don't forget, that's kind of important too.
Licensees and
Yes,
to
right, but don't
remove,
leave the licensees that are not realtors out.
to remove controversy, to efficient transactions.
Mhm.
And it's all consumer-based, consumer-focused. And to me, as difficult of a challenge as I think it will be, we have to give it serious consideration and look at that it more than we can have.
If there's a statute that says it has to exist in some way, I think, even though it's not exactly, four corners, but it fits within our mandate. So I agree with you that it is time to look at it for sure, and probably time to pass one.
And if we look at the effective date of that, it's January, if it goes through, it'd be January 1st effective date. That would mean we would need to have something proposed by the next meeting.
Yeah.
That's why I wanted to, the celebration for outgoing members, and to have this next meeting to be able to go through this, because by all accounts, it's going to pass. It'll be signed by the governor. And so I think we need to have a full discussion on it, because that's going to be a big change. That will be a huge change from what we've done historically.
I think even if that doesn't pass, you still need to be looking at it. Because we may or may not have found that there's a requirement for us to provide a listing agreement. I mean, we've got to start treating buyers and sellers equally.
And that's some of the concerns that we're raising here. Why do we put buyers in a special class, right? Of having contributions on this side. And I think that some of the farm and ranch argument was a freedom of contract. Let each side be able to agree to pay whatever commission they want to the other. And the farm and ranch allows the buyer to pay the seller's fee, right? It's built in there. And I think that discussion is part of the bigger one. And there's not a requirement itself for a listing agreement. What I saw in there is that there's bounds put around it, right? And it's specific. It's 1101155 of the Texas occupation, 1101 of the Texas occupation code, right? And it has trailer, as everybody generally knows it. So in there, there's a recodification that happened in 2001/2003 when it became effective, but it put bounds around. If we were to promulgate a form, you have to have this in it, or you can't do this in it. And so at some point, there's a gap in the online legislative history. For a couple of decades online, you can't pull the records. It's in person. I understand we might have some in the back room somewhere that we can pull on these statutes, but it was a Vernon's revised statutes that he used to be in, and they're out there. But I want to go see what the original legislative intent was for listing agreements. What was discussed at that time about us specifically drafting a form? And there's nothing available here that's recodification, because it just was a change up of the numbers of the law, a reorganization of the law. It wasn't a fundamental change.
Right.
So if we bring that to the committee, see that, and look at it from both perspectives, the list side and the buy side.
But back to, one of the construction rules is the legislature is presumed to know what they were talking about. And if they used English words, they should mean the regular English meaning. So in the statute, even if we don't have the history, we know what they said.
Well, that's for listing agreements, and it doesn't say go draft one. It's not
Well, I'm talking about
required like buyer reps. Buyer reps is going to be an absolute requirement.
No, I know, but I was talking about the listing. We know, we've been given some instructions already, so we know that. And I agree with Lee that frankly, that ought to be looked at too. Although there's an urgency if there's a law coming down.
Sure.
On the buyer side.
And we can have that in the back of our thoughts on all this and enlighten what we do. And as we take steps to change the contracts, of having that in mind of let it give the seller some love, that's some as well, or acknowledge. I joke about that, but the thought is there that we should keep in mind as we're making these.
And, thinking back what Lee said now, that because I was looking at that other piece of paper I get from another brokerage, seller will contribute. That's exactly what the form says. Like you said, with the home warranty, you give a credit to the buyer.
Seller shall reimburse.
Right. The paper from that one brokerage is seller will contribute this to the buyer. It's a separate form.
So it's
I really
like
like
a
that.
paragraph 12 almost.
It's really not. It's a statement. Seller will contribute. They don't even use paragraph 12. They use their own form.
I think we've jumped on a couple of subjects here.
Yes,
so
we-
I'd
yeah,
like
yeah.
to do-
Go back to
Page 10,
Yes.
what did we decide?
Can I just ask a question on page 10? And that is the only page where there are no initials for buyer or seller. And I understand that it is just, it's a broker information page. But when we talk about the compensation, and that is an issue that is in the trenches, in that not all license holders are Texas Realtors members, so they don't have Texas Realtors 2402 available. Many brokerages refuse to use it. There's a lot of back and forth, so agents write transactions, sometimes with no assurance of if they're going to have broker-to-broker compensation. So my question would be, is if we leave the bottom of page 10 as it is, now or at some future point, is it appropriate to have a line for the listing broker and the buyer's broker and have an electronic or otherwise acknowledgement of what's there?
like the farm and ranch ratification of
He
fee.
keeps coming back to this.
And
He really wants that.
there is an argument for that, right? There's, but
The license holder wants, because when this law goes into effect and everybody has to have rep agreement, we still have that unknown. There's no longer publication on the MLS of compensation. You can't get a hold of a listing agent. We have to go ahead and write the transaction because we can't put our interests, meaning compensation, above that of the consumer, and we run the risk of not being paid. It may happen at some point, and there's nothing that gives any verification. Is that a place?
the key thing there, I think, is with the 2402 is designed, it's meant to be executed in advance to establish the agreement.
Should be.
And if there's a ratification that's outside the contract, in the situation you described of we can't get a hold of them and we need to submit the offer, there wouldn't have been an agreement made. So there's nothing to ratify yet. Right? So you need, a lot of are attaching the 2402 as an addenda and somehow trying to incorporate it in. But with just a ratification, it would have to be almost removed above the signature line to be an agreement between the brokers and the contract, which brings in a whole nother.
Well, it
host
would
of
be above the
issues.
signature line if we put it underneath paragraph, the bottom of page 10. There's room for signature lines there or initials or something.
I'm curious how that would actually help if the concern is that the agent isn't sure they're going to get paid. Just if they don't have confirmation of broker-to-broker compensation prior to submitting the offer, just putting it in an offer and still submitting it doesn't solve that issue.
That's not good.
Well,
And that's not
That's not good business. Have a
yes,
conversation with your buyer.
I think it would, because if it's part of the transaction and you've got the two brokerages acknowledging what their understanding of their compensation is on a separate page that has nothing to do with the buyer-seller piece, and at least have something that tells the title company and tells buyer, seller, and both agents, this is what the compensation is going to be broker to broker.
But it almost
Yeah,
sounds
but-
like you're leaving that open for them to negotiate as part of the contract and it's not preset between.
Well, it wouldn't be
Brokers.
because buyer and seller are part of that.
No, I'm not
Well-
talking about buyer seller. I'm saying that if we're putting anything about cooperating brokers, we have the 2402, not everyone can use it. I understand that. But if they can't come to an agreement or have some kind of written statement between each other prior to getting to the contract, it still sounds like they're trying to wait until the contract to secure their compensation from the other broker without even knowing. That just doesn't seem to
When the
fit.
offer is written anyway, somebody is putting that information on page 10.
But Diane, what would stop me from sending an offer
They
that
should
said,
have it.
I want this? And the buyer and the seller agreeing to all of the stuff that they agree to, and the other agent going, I'm not signing that. We're still under contract. It wouldn't, the
Yeah.
contract's the contract.
And I
And you're
think-
still protected from your buyer's rep agreement for
And
compensation.
the solution for
Yeah,
the
but the
buyer
buyer
would be
hasn't-
put it in 12, right? And if we
Right.
look at least the existing Texas Realtors listing agreement, which is a change from the historical one they've had, has the offsetting provision. If there's another broker involved on behalf of the buyer, then if 5A is used in the listing agreement, you don't collect the full X amount that you put up there. You have to deduct the amount that otherwise would have gone to that other agent, to the buyer's agent. So the seller's still protected in that sense of I'm not having to pay the full X if a broker's involved and it's not paid.
And the intent of the comment with the initials or signature was not to make it a negotiable back and forth, only an acknowledgement of what the understanding, as it is now. It's just that it doesn't mean anything because nobody's initialed it.
And I think that some of the forms out there, like the Unlock MLS forms here in Austin, has that addendum that confirms, on each side, and that the argument of having, again, I was Team Farm and Ranch too, and having that out there, if it's not built in and this confusion 12, having full disclosure somewhere, and there's still a big chunk that want that.
In the
And
future, there's somewhere.
Yep, and so I my heart's there as well in a degree. I have come around a lot to where we're at without having it in there, but I'm torn still. And Brian's still got more time on this committee too, and we might circle back around to that together. But I think now if we look at page 10, I don't know if we're at the point of going as far as adding a ratification as far as the discussion for today. And if we look at suggesting removing it, I'm not hearing a real good consensus on removing it at this point
Should I speak
either.
louder?
There's a few very strong voices on both sides of this issue, right? And so if we're looking at a bigger change, and if we look at bigger change, a buyer rep would be a big change of, going into that of giving this that little more time, making the clarification change to 12 and leaving everything else the same. It there well might be that cooperative compensation largely goes out. From stats that I'm hearing, I had a few clients that were just still hold on to cooperative compensation. But the same ones are realizing, and all the ones I see 90% plus, just in what I'm getting across my desk, have all gone to paragraph 12 because of the administrative issues, the broker liability issues, trying to keep track of the logistics of what's the term of all these 24-2s out there and locking them in. There's so many reasons a lot of people are shifting, or just confusion. I'm going to make it simple. If paragraph 12 could be simple, but that's just the data that I'm seeing. So it may end up going 20, cooperative goes largely out the window. Mary Lee.
And a lot of sellers are going to be on the listing agreement and having you use paragraph 12. I have a lot of sellers that will say, we will pay you, the listing agent. Yes, we'll look at all offers, but have a great day.
Yep.
And so that totally, they won't fill any of that out. I like taking it out, but that's.
We're gonna zigzag across the room. So we're gonna leave yesterday, and then Brian has a motion to make.
I think the confusion that we're seeing with paragraph 12 could be cleared up a little if we did something with page 10.
Correct.
Again, I'm all about removing it, but I did offer a compromise, and I'm I like my compromise, just making the statement. I just think I think we're going the wrong direction. I think we just keep adding words and giving more stuff to confuse them. Let's just back off, simplify it.
And we say to simplify
Well, like-
to in adding or
The more blanks we add, or the more blanks we have, the more confused they get. So I think on page 10, if we go with the compromise and just say it's in separate agreements, we can all move forward.
They don't fill anything out.
Yeah, I mean,
rewrite the disclosure.
take the blanks out. Just say,
Pursuant to a previous separate agreement, listing broker has agreed to pay other broker a fee. Is that what you're saying?
well,
May
you
have,
would just say
That's-
any compensation between brokers is listed in a separate written agreement between those brokers.
This amount is different from the seller contributions in paragraph 12.
Yeah.
I mean, because to me, that second line is.
Okay.
That's
That's,
like
you can
that.
add that.
We can
You
remove it all
add
the
that.
way yet.
But I
I think
think-
that's the stepping stone.
I think having the blanks is a lot of the confusion.
agree.
Mhm.
I
Yeah.
totally agree. That'd be a great win-win all the way around.
Yesterday was next.
Yes.
That's 3. Okay, we removed the broker fee from all the contracts except Farm and Ranch for a reason, over time. I think we need to keep front and center. We are coming back July 10th and 11th.
Mhm.
Y'all all better be there on the 10th. Goodbye. But on the 11th, so there is not a requirement, and even with timing, and I'm looking at dear Abby there's not a requirement that we push something out today. It's the same as July 11th. So I think whipping into a few, y'all have been all over the place in this last little segment here. I think this definitely is not a decision for today. It's fun to have a discussion, but I am 100% against having some kind of a ratification by the buyer and seller on this page. If it remains,
Buyer and the seller.
who else would ratify it? It'd be the
The
buyer and the
agent.
seller. No.
The two
I
agents.
think actually was the department was the agents, kind of like the ratification fee in the farm and ranch.
All right, that's not what I heard.
That's what I said.
Okay,
All right.
but to be clear, and again, and leading from that, whether it's true or not, there are unintended consequences of changing this contract. In an interpretation of the contract, the case law that is out there and whatnot, and I would not open that.
Well, you raised a good point with the next meeting, and all these suggestions and the other language could go back to the subcommittee. We can talk about it next time to have more time, and I'm figuring maybe Brian's motion will be something along the lines of pushing this forward.
Oh, is it my turn?
Yeah, your turn.
Yeah, I would, if everyone wants to put this over to July 11th, that's fine with me, and we can talk about it more. But I personally think we should should change paragraph 12 with the clarifications that you've done. Keep this disclosure the way it is, minimize changes. I will tell you, title companies do use this as information for preparing preliminary settlement statements. And it is a useful tool to have, and I don't think it needs to be changed. There was great angst when we tried to do it a few years ago. Let's, if we don't have to change it, if it's not doing anything, leave it the way it is. Paragraph 12 changes are good. They clarify things, but this isn't a part of the contract. If we're going to do anything, I might want to have a sentence that says we really, really, really mean that this is not a part of the contract.
Yeah.
But we don't need to do that. It speaks for itself.
I don't think we can, if you're going to a motion, I don't think we can do any approving until we go through these comments.
Yeah.
Right?
Yeah. And Leah's
I'll
good
just
point.
pull it over to.
Maybe short comments, but offered if you spent the time and energy and resources to come down here from our everybody that's in as a guest today. Do you want to add anything on this, this topic? Give you the opportunity.
Well, I have this. The only concern I have going back to your comment about the consumer, is transparency. So my concern is that if, while I have mixed feelings about paragraph 10, at the end of the day, somewhere, I think it's important to know that if there is a cooperative agreement between the listing brokerage and the buyer brokerage, that the buyer knows it's getting paid. And so how will the buyer know that that cooperative agreement exists if it's not somewhere?
Give them confidence that it's not in 12, so I need something out there in writing showing that the other side's acknowledged that.
Let me put it this way. I think that there are agents in practice that will go and get cooperative agreements without having communication with their buyers and just fill it out and roll with it. And that buyer at the end of the day, until they are, well, they probably wouldn't see it ever and realize what's being paid out.
But I can see the value of having it before as well. Anybody else?
Candy, real?
Lori, do you have any comments from? Oh, John, I didn't see John's hand. Go.
I'm extraordinarily concerned about this. I've been thinking about this for years because I'm a trial lawyer. And what's coming down, if this is not fixed, is you've got a restraint of trade in the contract right now and in Texas Realtors, where the buyers and the sellers are treated differently. If you're going to have a BAC, you need to have an LAC. That's a restraint of trade, and that's a choosing of one party over the other. And there's such a bias in favor of the buyer's agent. There's even a prejudice against the listing agents in these contracts. And I'm not trying to get the hostile here. I'm just saying I don't understand the difficulty of this. The other problem is that you have a broker-to-broker agreement, which is an inherent conflict of interest.
Thank you.
And it's an inherent conflict of interest because it is not discussed with the parties. And now we're saying, let's negotiate it before you even have a contract. Then you have buyer's agents calling listing agents and saying, oh, do you have BAC? They're not principals. They can't bind the client. It's not enforceable. But what you do is you give the listing agent liability and the statutory fraud for making misrepresentation that the client can then change their mind about. So why are we exposing everybody to this? The DOJ has already made the point that it needs to be decoupled. So let's just, and look, I'm gonna tell you a quick little story. This guy they bought a dog and the wife said, we need to cut the dog's tail off. So he goes out in the room, in the garage, she goes, like docking the dog's tail. And she hears the dog go, ow, and ow, ow. And she goes out there and she goes, what are you doing? He goes, I'm cutting the dog's tail off 1 inch at a time so it won't hurt so much. This argument that says, let's take 2 years. The truth is, out there on the battlefield, what's happening is these agents have no clue about any of the duties or about any of the obligations, about the conflicts of interest. Many of the brokers don't care. And what we need to do is remove discretion. Cut out a bunch of these fill in the blanks and you choose this and you choose that and you negotiate that and just make it simple. Just do paragraph 12.
Thank you.
Tell Texas Realtors to get rid of 2402. Don't ever engage in 2401 because then if you're not willing to do it, why would you even negotiate your client to do it when you're the fiduciary? I mean, there's just, what's out there right now is insane. And we have you cannot teach it. You cannot teach this. This is like one big giant Pringles commercial. Make what you want. We'll eat all you want, we'll make more.
In 12, real quick for the suggestion of get rid of co-op just altogether, get rid of cooperative compensation. And then I want to make sure I understand the concern between the 12 leaving 12 in, right, which is buyer side from what you're saying, and not, are you suggesting adding something for the seller on top of that?
I'm saying her idea is brilliant. The idea on the residential service contract.
I'm telling you, it is.
The reason that's brilliant, and I don't want to, I can talk to you about this privately, but
That's why you're here.
What we're hearing right now, ABOR, this is why I'm here. ABOR has put out a flow chart that says in the middle of it.
And let's, on the public one. So the flow chart, I got that. Oh, that's
it says buyer, seller pays directly to the seller, to the buyer's agent. I'm like, holy, they have no privity of contract. Now all of a sudden we're going to take the position they're a third party beneficiary to the contract, and why would they be an implied? Why would they be an implied third-party beneficiary. What is so special about buyer's agents over listing agents? What is so special about buyers over sellers? Why? The buyer's agents say things like this, and I teach this. I've taught this class 100 times. Okay, buyer's agents always say, well, the buyers don't have any money. Well, what about sellers that don't have any money? Have you ever heard of Open Door? They got plenty of money, and they're a buyer. You ever heard of Vanguard or every investor on the planet who says that they got more money than? Right.
So the reimbursement side too.
It needs to get simple. Decouple in paragraph 12 and Texas. Tell the realtors get out of the business.
And that's so, and John's actually thought that he put out there before was when I teed up at the beginning of you have the issue 10 and 12, and then within 12, one of the big issues is the actual nature of what's being done. Right? With the contractual language.
The title does use it, but that was before 12 came into play. So let's say you put 3 and 10 and 2 and 12, which controls? And they'll do it.
Well, it's not 10.
I understand it's not 10. So that means that you don't need 10.
And they're putting it in a lot of different places. And except in farm and ranch. And then it goes to the argument of the farm and ranch. But those are all good points on all the forms. I mean,
I'm sorry, I'm passionate about this. I've been about this for a year now.
No.
I think we agree with you. I keep thinking you're right at 20.
Yeah, I do. As a matter of fact, I do. For 10 years, I want to say something. As a matter of fact, I've been
seeing it all out there. He's out there with a lot of interactions with a lot, right? And so you get a lot that have a perspective within the broker when they're teaching classes and stuff. Across the board, that's on the attorney side. So great, right? We have the broker side and we have attorney side. And John come from the attorney side here of seeing it from a lot of different angles.
Texas Realtors is going to get sued. Write it down. If they don't mirror these contracts. And I know that's not.
That's not what we're doing here. But,
But Trek
as
can
a
lead the
side
way.
note,
Trek can lead the way.
there's only one trial lawyer going to be left on this committee, so maybe you ought to think about that.
Already suggested that.
Okay?
Yeah.
6 years to say what I wanted to say in 6 minutes.
We get to say it for 6 years again.
Yeah. No,
I
but
do want to say one thing though, that you said that I'm going to take issue with, just because, people give a lot of weight sometimes to what we say. The agents can bind their clients. So I disagree with you about that. There's case law all over the place.
actually, so we're going to get into that's going to lead into a discussion we have with the
Okay, there you
comment
go.
that was submitted for the court cases. We'll get to that.
John, are we going to ask our other guests?
Yeah, and so
Well, do we finish?
Lori, did you want to make
No.
No, we're going to move. So after this, we'll move back to the discussion on the committee and decide whether we're going to monkey with anything on 10, right? On page 10 today, or whether we look at it tomorrow. So no, we're wrapping up this conversation to move on, so we have the other business. And I appreciate the comments and the fire, John, and out there with getting all the input and for all y'all to come, to these meetings. It shows a lot of effort. So we appreciate that and the concern and he sees it. I mean, and with the forums that are out there, seeing the actual misunderstanding. So one big part of, filling besides my teaching and my clients is the online forums. You see that, Candy's forum, John's forum, all these forums that are out there, the discussion's happening. If you ever question about the misunderstanding of what's in the forums, go on any one of these number of Facebook groups. It's out there for us to have great data to understand it. But
I'm going to probably overstep, but my thing is this is my third one. I listened to one online and my second one in person, and I really appreciate the passion that everyone shows for this. My thing is that changing a couple words is not going to make agents more competent. Holding brokers responsible for their agents' competency, that's a whole nother level. So you guys are talking about, oh, well, they're not learning. We can't force them. Yeah. I can't force them to come into me. All I can do is look at their contracts or their offers or whatever it is and say, yeah, that's not going to fly. I'm not here to train other agents. I'm not going to do it because I'm not going to step on their broker's toes. So if you give me an offer on my listing and you filled out paragraph 12, you filled out page 10, I'm going to correct it with my seller, say this, we did not agree to this. I'm going to mark this out. they can negotiate paragraph 12 if they wish. But I'm not gonna do it. I'm not gonna sit there and say, well, honey, you shouldn't fill that out. So, but that's,
We need to start going to the Trek Commission meetings, because that's not our, we also get to bitch and say this is education, but this is not our committee.
And it takes
Go to
enforcement,
that.
right, and complaints, and I will tell you, enforcement will take this very seriously.
Will.
And there's
Gotta
no
do it.
qualms about this, that when it goes to enforcement
That's not
and
us.
council, and, you know, I would put it in a little perspective of, we have some of the highest education requirements anywhere in the US. And that doesn't mean, if it's up to me, it'd be much higher, and especially on this contract issue with how important that side of it is. So, any more thoughts, Candy? I know you're on your tongue.
Quiet. I'm over here not rolling my eyes. I teach full time and I'm watching this confusion with, well, you saw it the other day, paragraph 12, bottom of page 10. In my mind, bottom of page 10, get it out of here. If the title needs that information, then we send them a CDA or a form or something, because we're allowing non-practicing people to fill out stuff that they have no clue about. And so most of the students, once they come through this lineup, they know that paragraph 10 or page 10 is not part of the contract. But there are other ones who say, no, I want to get paid that 3. I'm putting it on page 10.
Or some other number.
What's that?
Or some
other number.
Yes. Yeah, or all the other numbers. But why, we keep saying, well, the title needs it, there's this, there are other solutions to it than leaving that paragraph there.
And if you recall, I believe, to go with your point, at our last meeting, we wanted to take it out. And the only reason, and we had a consensus, the only reason we didn't is it would have held up the contracts to gone to the commission and be out in time for January 3rd.
That's correct.
We wanted it gone.
Yeah, we did.
Good point.
Sounds like things are going away.
With that, and I always have empathy for those that must move quick. And, the benefit of this committee, we have the time, we can take measured steps, and the actions of those in other parts of the industry, specifically the trade association, whether that's local, state, or national, despite the disagreements there might be on procedure and how things are done, they have to move much quicker on different things. And I think a lot of the changing of the forms created angst and how to, the ultimate solutions are not part of it, but I do sympathize with how quick they had to move in the job and tasks that they have. And I preface that, and I appreciate Lori being here today and know that y'all are in a much different environment than this committee has the privilege of being in with that time. And so I appreciate y'all's efforts and in the industry and what y'all do. And I know you take a lot of fire on these different topics, and with the nature of how you have to react and respond is a lot different than us. But so I give you the floor for any comments you want to make or anything you're seeing maybe coming down the pipe with the forms or anything that may lighten the discussion.
Yeah, so I don't know where to start now. I've been trying to call on them for quite a while. I do want to say that we start from the beginning. In the settlement agreement that this has all come from, their broker-to-broker compensation is not prohibited. It's prohibited on MLS, but broker-to-broker compensation was, NAR will tell you they fought to protect that when they were at the settlement table. There is still broker-to-broker compensation. There are a number of brokers. I haven't done a poll. We haven't done polls. I don't know percentages, but brokers still think that there is value in agreeing with their seller that the seller will pay that listing broker a certain amount of money, and part of that money will be used to advertise, to bring buyers to that transaction. There is value in that and getting a highest and best offer. There are other brokers and agents that are more than happy now to not have those discussions and have the seller negotiate that directly with the buyer. Now, I'm not advocating for both tracks personally. I would love the simplicity of taking that language off of page 10 and broker to broker going away, but that's just not where the industry is. I'm not saying that you all should follow industry. I'm just letting you know what I know. That's where the industry is. Yeah, make it painful, do it quick. You know, we can educate on whatever direction you all go in. We are getting, I spoke to the title agents the other day, Later was there, and I always get applause when I talk about the CDA or 2406. Remember 2406? I think ABOR has a form like that now. I don't think we're going in that direction right now. We already had a form out there and pulled it down, and it's still confusing. People are still looking for that form.
They're still using it.
I'll tell you on a little sidestepping here, we are in the process of creating a non-representation buyer agreement, written buyer agreement. If and when the governor does not veto 1968, we have until January 1, but we are moving in that direction to have something ready to go. We'll be following what you all do on buyer rep agreements and listing agreements, obviously. I hope this is helpful. I've addressed everything. I'm not seeing broker to broker go away. I know that the DOJ has opined about it publicly, but there's never been a definitive ultimatum from the DOJ on that. We have been responding to requests for information from the Department of Justice on the settlement agreement, as have other local and state associations. I don't know if brokerages are being asked for that information as well, but they're monitoring the settlement. They're seeing it. So we're not hearing anything definitive about that. And NAR will tell you they fought to preserve broker to broker compensation. It is not illegal. It's not against settlement agreement. It's still out there. Do I think we're moving in a direction where it's going away? Yeah. But
And this solution lies in having a voice and raising it, right? For us and TREC in the government, it's with the legislature, right? To change up the rules. And this committee kind of uses what the legislature says we have to do. And then we go with our statutory directive, which also comes from the legislature. With the trade associations, it's involvement with the trade association. If those are out there don't like the policy, don't want to have the form available, then make their voices heard, right? And get more involved. It's not retracting and pulling away, it's getting engaged and changing. The whole industry needs to innovate, whether it's government or trade association. There always will be trade associations, there always will be the government. So get involved and help make those changes. And if the industry goes away from the cooperative compensation, or the voices are loud enough within it, it would help push that along faster, right? And then if that went away, it wouldn't be an issue in our forms to take it out, right? So we're balancing a lot of different things here. And I think we did the topic justice today, talking through, and I think we circled back around to, figure out what we're doing with page 10 today. But I know this took up time, but I think it's definitely worthwhile to get all these thoughts out there. And ultimately, everybody getting involved more is the solution, not stepping back and not doing that. So I would highly encourage everybody to raise their voice on it. Ron, with the thoughts on?
The only thing I would do in terms of fishing before you drop to the comments that might help the comments go faster, if we could make at least a preliminary decision, as all our decisions are subject to change, that we go ahead and, with regard to paragraph 12A1, make the changes as we last proposed. That being our intention, I think that'll make the review of the comments go much more efficiently.
I think so.
Okay, so.
Second.
Okay.
And then do we want to, I kind of heard at the end here a little more of a consensus on removing 10. Remember that we're coming back in July, right? Do we want to?
No, nothing today.
Well, we're not making a decision today. It's just having a for next meeting on what we proposed.
I think you're right. I think there's kind of a consensus.
We had the consensus last time, we just didn't want to put it out there. I think
It's high.
Well, let's see what everybody has thoughts on there.
I think we put it back on the table to remove and. Yes.
And put in there that at next meeting, we'll
Or do you want to, you're not wanting to
Can't
make
we
a
do it?
decision?
Let's do it now. Just take it out now, then at the next meeting, we get the comments in, we'll come right back.
Yeah.
Great.
Go around, kind of general. I know Esther, I can come around back to you, but
Remove paragraph 10, bottom of page 10.
Remove.
You're just talking about the bottom or the whole page?
No, just the
No,
bottom,
just
Bottom.
the compensation thing.
Notice.
you can look that back your title, because I know this is kind of a different, unique turn, any strong opposition. So, Darlene, if you have any thoughts on that?
We've not had any issues with that, so, I'm okay with it coming out for sure. But I've not seen any issues.
I
further
vote no.
comments?
You vote to leave it in? Right now, I'd say leave it in. I may change my mind in 5 minutes.
You need help with that?
Okay, so let's make a formal motion on that, since we don't have a good general consensus. So somebody like to make a motion, take it
I
out?
moved or take it out.
I
Second.
Okay, I'll do a vote, so Lee. Four.
All four.
I gotta go with the burgers.
Keep it.
Fair enough.
Okay.
And we're
All right, so 4 to, oh, do you have that for
No
the?
comment.
You did that, okay.
No, that was my
He
vote.
voted with the
I
brokers.
voted with the brokers.
Okay, and I did too.
He's a
Okay,
broker.
Take it out.
so,
Well, I think for the minutes, right? So the
Title.
motion,
yeah, so it passes.
We can
Okay.
direct that, or I guess we don't even register votes.
Yeah, we don't restrict.
Okay, so that's a good discussion there. We'll move on to the next agenda item. So deferred comments and recommendations from the last meeting. I think we addressed all the deferred comments, except for, I guess there's one on the backup contract addendum, which is also in the comments. So I'll reserve that for the notice of termination of the first contract.
Are we going through these comments or not?
On 12, I think we've done 12 justice, and we've all considered that. So unless somebody has a particular one as we go through these pages from 12.
Some of the 12s have more.
Right, exactly. So we're starting on page 80 of the materials. Ginger Gill's comment was about 12, not in the contract, confusing with the seller's not paying the full amount. Kristen Robinson was about 12 as well. She brought up a little something different of the broker, maybe not just a real estate broker, maybe a mortgage broker or something. I haven't seen that raised a lot, so I'm thinking of 5%er.
Well, you fixed
Oh, I
it
think
anyway
it's
when you added our broker agreement.
It may still go to her comment though, because she's saying a broker could be a mortgage broker. So that agreement could be between the mortgage.
But if you change the word,
Oh.
like you said, where it was buyer broker agreement, wouldn't that clarify it?
I think so. I think it.
Unless she reads it as any kind of
I mean,
brokerage buyer.
Page 10,
No.
bringing up page 10 again, I mean, broker is actually a capitalized defined term. So a mortgage broker is not involved in this contract. I don't even think that,
Yeah, I think it's a 5%er for sure.
I don't think it gets
That.
that.
So the next comment that I have that's not 12, we see the one is Spencer Wheelwright about the survey. And the comment there was there's not an option to check that the survey's already been delivered. The problem that I see immediately with that is the survey under those paragraphs needs to be delivered, at least C1. It delivered to both the buyer and the title company, not just the buyer. So I recognize where they're looking at that, but I think it forgets that element.
Well, my
Well, you
notes to
also need the
myself,
last sentence.
yeah, this didn't the full cut, but I mean, if it's already been done, if it's literally already been done, just say in one day. You know, I mean, but I don't think we rewrite that.
Not either.
Spencer Wheelwright, also one that we've gotten repeatedly on here is about the non-realty item addendum not being a checkbox. We haven't had enough interest to make that change before.
Well, and
That's not exactly right.
No, it's the mortgage guys don't
there's a
want it.
policy against it.
Because
It's a
yeah,
TXR.
because of the
No,
the mortgage.
that's not it.
So what's the?
We've got
let's go
one
back and
now, but
The
revisit
policy
these.
against it is because the mortgage company does not allow any agreements you know, on this contract for a mortgaged loan. So it is a standalone
Well, yes.
contract. It is not part of this agreement.
Yeah, if you put it in there, then it
Then
becomes
it
part of
can't
the
be on the
property,
closing statement.
and the appraiser has to consider it.
It's big, no.
It's what the lenders tell us.
Right, right.
And so the lenders don't want, they ignore it when you do put it on there.
And I'm not disagreeing with any of that, but for full, well, it is an addendum,
Right.
right?
No,
It is an addendum.
Well, that's what
It
it
is an addendum.
The name of the form is.
And so that, I just want to be honest, when we say we're making a policy not to do it, and I understand the reasons why, but we can't say it's a separate contract because we have it phrased as an addendum.
well, it shouldn't
Or,
be.
so,
That's been an error that.
A bill of sale, change the
Well,
name.
If indeed that is incorrect, it's a promulgated form. So license holders are told that there's a promulgated form by TREC, they are to use it. And from my experience, not all lenders are going to turn away the non-realty item addendum.
You don't, not all of them.
20 years ago, they did. That's when this all started. And
Started long.
maybe, and so maybe it was 30 years ago, but it's changed. I've been in the business 45 years, so I can remember back when the change came, and I do see it changing again. So to your point, if it's a TREC form, we need to decide, is it a usable one? Are we not supposed to be using it? Maybe we need to look a little more into this before we make general statements.
John, at one point, there was an issue that I thought got assigned to a subcommittee agreement to a group to actually review this. That whole paragraph 22 of what is attached and what is not.
Yeah, and the
it
difference
went into
between
the
notices and addendums.
That's right.
This
It went into the
conversational law.
ether. And so
Yeah.
that's where this discussion goes. So you might want to.
Think about a work group as
I do,
well.
I do think,
Yeah.
part of that problem is that will require this issue here to be referred to a later time, because I think that's a complete rewrite and
Yes.
reorganization of the whole
Correct.
form.
Right.
So I think it's better to either address this
alone.
question, yes or no,
No.
and then that can always come up at a later time by another.
Right.
So,
And
I mean,
I
I don't
agree
have-
with that.
I don't have a problem adding it. The question would be, I think, really, it was sort of the question. I think the brokers here would tell us whether or not lenders object to it or not, and what do they think? Because it's, as far as the attorneys are concerned, they're not going to care whether it's listed there.
Yeah, and it promotes, it's a voluntary use form, one, so it's not a mandatory use like the others. And we're going to get into what mandatory actually means later in this meeting. But the appraiser has probably a salient comment on this one.
So you guys are throwing around the word lender, and it is the loan officer who says to the agents, don't send me the non-realty items addendum.
Yep.
It is not the lender / underwriter. It's the person who's making money off of that loan. As an appraiser, I will get a call back after the deal is closed and ask me to address the fact that that form was missing when I analyzed the form. And I'm required by federal law to analyze the contract. So.
And what concern I had last week with a client about this issue, there was a significant amount of furniture in an expensive house that was being sold. And the question was, how do we address it in versus, non-realty item addendum or not? And outside the contract, or just bake it in the price, and these different, and included in special provisions that the furniture is being included. And it was one of the things, because it's an addendum, right? It should be listed, I think, properly as part of the contract. In the extent that you hold it back, raises liability concerns of not being full disclosure under all the various different regulations around settlement, right? And having the complete picture. So I think that concern's always been there, right? That we've had, and as we looked at it in different angles, we've as a committee made the choice to keep it the way it is, acknowledging that concern, and just that's I think the truth. So it's something we should look at. I think Ron's point is this is bigger than this question that we can look at today, but we bring that as I'm not sure.
I think you could look at it again in maybe August.
And there was, right, and there's another thing I recall is we have not wanted to queer a deal on the real estate for a refrigerator. or even a $50,000 sound system. And sometimes, as Brian and I were just whispering, sometimes if that's true, that whoever is making the decision, they want to see it or not, is a how large that is. And that's not a us decision. So
They can still free type it in too.
they shouldn't, if they could. My strong suggestion is this is a no for now, and we not waste one more minute on it. Have a really long
Second
day.
that.
Get people, because we're coming back in July. I would like to be here at a good time.
And you don't have that
Yeah, second.
terribly much to go, so.
Ron's typing, when he leaves, we leave. You move, I move.
So so with that, I think the bigger points made, that we would look at this further, if an issue may come back around to be looked at again, because I don't recall that time that we did a deep dive into it.
It was Jacob's
I have one thing for you guys. There's a new form coming out. The appraisal form has not been revamped in 20 years. The new one is coming out in September, and January it will be required. I don't know if there's a blank for non-realty because we've never had a way to address it on our forms.
Whose form?
Interesting.
It's Fannie Mae's form is coming out, but all the lenders adopted.
So maybe that's the perfect, to coincide with that, to do that at the future meeting. That's a good idea. Okay, let's see. Well, I believe Sean is 12. Courtney Ryan is 12. What's full disclosure?
I mean,
Courtney Ryan was
a couple things that really aren't relevant, but I think she got interested.
She had another one up on the bottom of the other page. She does have one on.
The commercial language.
MLS.
But that's still related to the, as well.
Yeah.
Yeah, well, it's still bleeding out.
And let's see, it's just similar to the listing agreements.
Strict enforcement sub-agency.
Who you on?
86.
86, that's TXR.
I know. I'm just saying, I feel that we should acknowledge each comment and say why we are
Blowing past it.
Yeah.
ignoring it or not.
Yeah, and that's why we preface going into this too. We've gone over a lot of all the paragraph 12 stuff. As sub-agency, we will take a deep dive into at the next meeting.
Well,
That's not us, that's enforcement, that's not us.
The upper comment on 86 is about the listing agreement. That's not us.
Devin also wants additional regulations on wholesalers, which is best
Devin
addressed with
April.
the truck commission, or the legislature, I should say, or I guess truck commission. More transparency than what? Okay.
Just more commercial.
Software designers add more space for legal descriptions.
You know, I'm okay with that in principle, looking at it.
And that's not a substantive
that's
thing
not
that staff
us.
can look at to address, but I guess a quick roundabout, that's what you said you're fine with it. Do y'all
Well,
have
if it's
issues with the spacing of the legal descriptions?
Sometimes it's small.
Yeah.
I just use
small, but
appendix
that's
A and
also
move
where
on.
we can go into special provisions and continue that. So there is a place, and that is how Trek teaches.
That was my thought. The informational items, especially with the new definition of that, says to complete a blank in the contract.
That's right.
But
It would give a bigger
Okay.
blank. It's the comment. If the city and the county blanks were made smaller, it would give more room to wrap this blank for the legal around on the corner.
Each paragraph 11.
I don't think it
and I
would-
guess if we can, I guess staff look at that if it formats and looks better. Great.
Software engineers, you mean?
Yeah,
Software
software
engineer, that's
engineer.
it. The things like.
Generously say that's about
Okay, so Kelly Stokes, let's see her her suggested language here, she's concerned that this language suggests that the buyer should pay some expense, or to do something, but the suggestion she has goes against federal law. It's not optional. She wants that only, if buyer only has to do this and, or provide they're not obligated to incur any expense. The problem is they have to do it. Okay, doesn't matter there. Steve Ritchie, Andy Lunsman, she,
Who?
well,
Andy
Lunsman, sorry.
Lunsman, bottom of page
Lunsman.
91.
Sorry. As you know, my pronunciation of names is not good.
Had you
Yeah.
done all these?
No, we don't respond. We will go to.
We're responding
We don't respond to
essentially right
anybody.
now.
I didn't know if they actually got an answer back.
No,
No, we don't, as a
We're-
committee,
we are
as a
not
committee,
the
we don't
legal
get these until the meeting. So nobody on the committee will, unless we receive it and forward it on, we're not having.
and I'm
be
called to make a reminder about open meetings. It would be a violation of the open meetings if someone on this committee or less than all of the committee responded, did committee business without it being in an open meeting and we all be together. So can't do that.
Okay, this has been a request in the past. I'm on Marcelo Perez, about a offer. This is page 92, about an offer expiration clause. And there's a couple different forms that have been suggested in the past, the California one and an Indiana one. Bro, I would see this one out to brokers on, what are any thoughts on?
They do it in commercial too. I mean,
I think it's great. I mean, there's not, you put it in there, but you don't have any agreement. So how enforceable is it? If you don't want your offer to be out there anymore, just rescind it.
Exactly. Stop
I think it's,
You're in the same seat either way. You're saying.
yeah, I mean,
Right on.
Yeah.
So I'm not hearing a big thought there. We can look at the language, both in California was in another earlier packet, I think.
California also has 33 pages of agreement, so let's not go that route.
I think that'd be a great form for EXR.
It never withdraw for.
They have
They
to
do.
withdraw.
There you go.
Well, there you go.
Let's see, so that's the same as the Ronda Lane. Seller. Oh,
Betty Black.
what number are you on?
Whenever.
I was going to 94. I may have missed one, but I'm 94.
Well,
95.
we've already addressed everything, I think, at page 96.
So I have,
Shelley,
another one.
well,
That, I'm on Betty Hack.
again, it's about spacing with lots of things.
Yeah, she's gonna stay.
And you're gonna have to, I mean, if you get more than 2 or 3, you gotta go.
That or special provisions.
And there's room for them to put another signature in there.
So education, talk about special provision.
So I'm on 96 with Lane Marie Brown. And I was trying to recall our prior discussion. I didn't have a chance to go back to the video to see, but 7E versus third-party financing addendum 2 and 2B. We have in 7E of the contract, the statement about lender required repairs. And that either side does not agree to pay for the lender required repairs, the contract will terminate. It goes a little bit further to say if it's more than 5%, it gives the buyer the right to terminate. The repairs are so much, even if the seller agrees to pay for it, the buyer can still terminate. What's raised here in some different ways and is raised in terms of who gets the earnest money, but the third-party financing addendum under 2B, property approval, requires 3-day notice to terminate. That 3-day notice is not tied to paragraph 7E, right? 7E says its own in one way, although there's one tie-in, but I think the tie-in may not be sufficient enough. 7E says you can doesn't give a deadline. So theoretically, you can terminate all the way up to closing because of that. There is a statement in 7E that unless agreed, what's the exact language here? It's
Unless otherwise.
unless otherwise agreed in writing, right? But if you look at what that unless otherwise agreed in writing to is separate. Let's pull up my notes on that one. But it doesn't necessarily tie directly to the termination right or the property approval in 2B. Now 2B has a reference to lender required repairs in a parenthetical. But it doesn't modify the agreement that unless otherwise agreed in writing states. So I do see a concern here with this. And it's amazing this has been in here this long and it hasn't been raised. And I thought we may have talked about it once. I couldn't remember what we did.
5% there.
I was about to say that.
I mean, as long as it's been here and.
But it's a
we've
big
not-
deal, I think, though. This is kind of like the water termination notice. I think when it wasn't taught, it wasn't that big of a deal, but that's one of the most powerful termination rights in the whole contract. right? And just because we didn't do anything about it or wasn't a big deal, once it started being taught, people are paying attention. I think with this is a huge gap potentially. That if a lender says, I'm not approving the property because you need to replace that electrical panel, or you need to do that, or you need to repair whatever item, can the argument be made under our language? And people start finding out about it to say, I'm terminating under 70. And I think my reading of it is there's a gap there that potentially allows that
They've
right.
been deemed because of the passage of time. Is that right? They've been deemed,
There's no
buyers
giving.
deemed to have obtained
Well-
property approval is what Wayne Marie is saying. Not true?
Well, no, so
Agree
property
or
approval,
not?
but it's a separate contractual clause in 7E that doesn't have any of the deeming or time requirements.
So you're stuck.
So you're stuck. The buyer still has an out all the way to closing under the gap argument. Yeah.
But remember, property approvals in the third-party financing condition addendum. And that's addressing a situation where a buyer cannot get a loan.
Right, that's an out to the loan.
But this is something different.
This
This
is
is
an
the
out
five
because they
percent
did-
rule because we got crappy property. The cost to repair it exceeds 5% of the sales price, and it gives the buyer an out. I see it as being two different, although they may somewhat overlap, I see them as two different concepts. And 7E gives the buyer the right to say, man, the repairs that are necessary are very significant. I want out of this contract.
If they're less than 5%, though, it doesn't matter if the seller agrees to pay it or not. And
Right.
so,
Exactly.
Exactly.
And if that's the intent, then that's the intent. I think.
Well, the lender required repairs typically come in immediately before closing. Or just in,
They come in with the
and I don't know if that's
Closing
changed because we've added the 3 days in the financing addendum. I don't know if that's changed or not, if the brokers may know, but it used to be you'd get the lender required repairs notice the day before closing. And then you'd have to extend
You
the
have more of this
closing.
than that. It usually comes in with the appraisal. And it-
Unless there's
and
a
that's
terrible
usually not at
storm
the
the day
end.
before closing.
Now the real.
I'm not saying it has to. That's just how it goes.
The real evil on this, and I'm sort of agreeing, is you're giving buyers 2 bites at the apple. They have the option period where they're supposed to do their inspections, find out how much it's gonna cost, negotiate repairs. But then they have 7E, which can be enforced at any time, even after the option period's over. You've inspected the property, you know what needs to be repaired, whether they're lender required repairs or not.
That's a good.
That's probably why you're not getting the controversy. But I do think that they are 2 different issues. One has to do with the approval from the lender. The other is just the buyer has the right to terminate because he doesn't want to pay for the living required
Yeah.
repair.
You're just finding a problem here, Lane,
Well,
pointing it out. But
It's really a matter of, I do have loan approval. Okay, fine, I got loan approval.
just I don't
Subject
want
to
to
lender required repairs, I don't want to do it, so I'm walking.
So I think that's where we had discussed it briefly before, is where, and this could still be a 5% rule, where there have been cases, we've experienced them, where we've had a agent who is also the loan officer, who they're getting ready to close, and then right before closing, they're already past the number of days on a conventional loan, the 3 days, and all of a sudden they need lender required repairs and they're out of the contract. That has happened, but that may be more of a 5% rule.
I was gonna
And-
say,
think it is.
just, I mean, like a straw poll. Are we seeing this abused?
It's probably minimally.
Yeah, and this is one where I agree.
So it may-
It's
it
not
may
being
be
abused, but
more
it's,
later.
I want to make sure our intent, at the same time, I want the intent not to be forgotten. So if the intent is to have it 2 separate.
Well, your seller has the right to keep the deal together up to the 5% rule.
Right.
So I don't think it's an issue, and it's 2 different issues, actually.
And that's where I was trying to remember what we talked about before, but it hits when you look at it that way, because I know a lot of deals that buyers could use this on that they don't, right? And so if it becomes known, I I want to make sure that that's our true
Well,
intent.
the
going
less
into
we
this, like
talk
I
about
said.
it, the less it'll be.
Well, that's not an excuse not to, not to talk about it,
It's
but
been around
it's-
for a long time.
I don't think everyone's watching
Okay.
Broker Lawyer.
Yeah.
So, okay, so for the trial lawyers out here,
Writing a video.
but I just,
I think if
so
it becomes an issue.
digest that after this. I've just asked that I spent a lot of time pondering this one, and I don't have a strong feeling, so we can move on that, but just think about that true intent behind that provision, and if it was actually utilized and known about, is that what we mean it to mean, to have those two separate rights? Jim, let's see, paragraph 12.
Brenda Venable.
Venable, Fillers love things in
Had to
the
do a
house.
walkthrough. That's what I said. This is an issue of a walkthrough, and we cannot make, our forms are
Not-
clear, and we can't make people behave. If
Not
we
everything
could,
moved out on this.
I'd be happier, but we can't.
Well, that's why you should be.
Give me a form that allows me to make people.
Basically, leave the house broom clean, right? That's what she's wanting a clause to
Yeah, and
demand
is
that
there
in
a
there.
No,
legal
yeah,
definition of?
Right.
That's not a,
I think she's also talking about, what if they just leave a bunch of other
yeah,
crap?
that's, sorry.
It's not just.
Go do a
clean.
walkthrough.
Yeah, then
Yeah,
don't
do a walkthrough.
Exactly. Do a walkthrough.
And why is she doing it? She's not the mover or the buyer.
But she was in her nice skirt.
I know.
Yeah.
Don't.
Not seeing any strong feelings on that one, so we'll go to Rhonda.
We can't form our form any harder
While
about.
we're in that section, if I may, and mentioning walkthroughs brought to mind, there is no place in the contract that talks about walkthroughs. And oftentimes agents will write something into special provisions, or they make a phone call to make the appointment with the listing agent to ask the seller to do the walkthrough. And he said, what do you mean a walkthrough?
No.
They didn't know that.
The buyer has the right to inspect at reasonable times.
Anyway, trying to ask to put on the list.
You okay, Tony?
Things to talk about, maybe, is that something that we should consider having put into the contract so that the agents don't start writing,
I
write
think it's
things.
already there.
And that
Only
kind of,
reason I'm bringing it up for future conversation.
and that kind of leads into the next thing raised by Rhonda Hamilton as well. That's, I think the buyer's walkthrough goes into the access, reasonable access to the property.
Yeah.
And the difficulty in defining what reasonable access is. And it comes up a lot when people say, I want to make sure I have my option money in my hand first, that you paid that in the earnest money before you get access to the property. Right? That's a very common situation. The problem and difficulty I have with it is it's a case by case basis, on a lot of this stuff of what is reasonable, right? Defining what is reasonable is a very difficult thing. This other request we've had about you can't inspect until you pay the earnest option, I think we've talked about many times, but it's hard to look at that from a, and what's her exact.
She's not talking about
Well,
that.
she's saying.
I'm bringing that the whole kind of. the
Yeah,
whole
if she's got a
reasonable access
renter,
into-
there's a renter that won't.
Yep.
But under
Yeah,
a short-term
let her
rental agreement, would
get
you
it
give
in
native
that
form for rentals?
And so that kind of goes to the case by case basis. What's reasonable in one case may not be reasonable in another. And it's not until a judge or a jury of your peers makes that decision on whether that's a reasonable time or not.
Or even better, the people are communicating with each other.
If they wouldn't,
Up front, when they get the contract, they say, hey, by the way.
well, if they wouldn't work it out and negotiate access.
Yeah.
Then here we are in court with the judge going, well, you weren't reasonable.
Yeah.
And you're still within the option and you can terminate. They're saying you're not going to let you in this particular case. I think it was a 10 X day option, and the short-term rental people were in there up until very near the end.
Right.
And so they couldn't get in to do their
They should have
inspections. And,
negotiated a longer time period because
Well,
they
and
knew
the
it was a short
seller
time.
should have told them.
well, they didn't know, I don't think.
but-
I didn't until afterwards, and they tried to get in. And then they said, oh, you can't get in because the short-term rental
I
is.
think the focus would be, what, are we gonna address what's reasonable? Otherwise, we're not really supposed to comment on particular incidents and give them like.
And that's why I kind of,
Right.
yeah.
We don't give advisory opinions.
Yeah, not the days there, but I think, to me, I think we need the flexibility there and not define it further on that.
But
for
wrapping
now.
it back into the comment above, in my opinion, and I believe in Lee's opinion, the right to access and inspection, that covers the walkthrough.
The final walkthrough.
I think so
You
too.
could go
Mhm.
and you could go back and you can go back and you can go back. And it's most certainly
And I agree with that, and I also agree with Diane that it does come up a lot. Of when can I do it or can I do it? And people sometimes refuse and it becomes issues, and it's not something
That sounds like a Houston issue to me.
I wouldn't doubt that most of the ones I've seen have been actually issues, but it is a problem that comes across my desk. I'm not sure 5% rule, but it does come across. So I do see the angle there, and maybe a Houston thing, but.
And you did bring back up
Yeah,
again,
lots of
again,
not
the
having
list of things that hopefully this committee will discuss. But the abuse by some, and it may fall under the 5% of paying the option fee, doing their inspections before the 3 days are up when the earnest money is delivered with the intent just to check it out. And I'll give you $100, but I'm not gonna give you the 5,000. They don't say that, but that's what's happening. And it probably is 5%, but we're seeing more and more of it. So just maybe a topic to, when the time may come, is that something that should be in paragraph 5? Just a thought.
And you're
I think
saying
so,
that
keep on the radar is what she's saying.
Without paying the earnest
So
money.
how did that hurt? How did that
That
hurt?
hurt the seller
How?
because he basically has some property now impending. And it was really a malicious intent. They had no intent.
Turned out the same way, he'd have to give that earnest.
The end
money right
result's
back.
the same.
End result is exactly
And a
the
lot of
same.
times they're not paying option as well.
Yeah.
I mean,
Right.
and so there's.
Yeah, if they don't pay the option,
Gotta pay
that's
the
a
option.
And
You should take it.
so.
So the solution would be in paragraph 7A to say, provide at reasonable times after the earnest money has been paid.
Or the
That's the
option.
request that's come in several.
That doesn't offend.
Well, earnest money.
That was easy.
But that's a new topic for today.
I'm not, and I'm just saying, this is the opportunity while we're talking about it.
No, we have a
Let
full
Diane-
agenda item.
And I do agree with Diane, something to keep on the radar as we address these things, because it is, and it could be Houston and the part, but I do see that quite a bit, so.
All that flag.
Okay, Farm and Ranch, let's see. No, that's the page.
Not to me.
So this is a little different angle for Farm and Ranch. Let me just read, make sure not, this is Loya Cobb, if I'm pronouncing that right, 98. Also on the Farm and Ranch, it says, do not sign if there's additional agreement regarding broker fees. Please clarify this. And so.
So were they using the broker form?
Yeah, yes.
And then they're not wanting to ratify.
Well, they don't want to have conflicts.
Mhm.
She's saying this could be a conflict because we actually say, do not sign this.
Yeah, that's what
And she's asking for an advisory opinion about what do not sign this means.
Yeah, I couldn't quite glean exactly the.
Oh,
Yeah.
the cameras.
Yeah, I think it's up there.
So I don't think there's any.
It's focused squarely on Tony.
I know.
Good, Tony.
Yeah.
Okay, so
Probably not sitting here.
No, it's
I'm sitting here, I've been told my whole life my face tells the story, so I should not be sitting.
okay.
Next meeting,
So
everybody will be here.
backup addendum, page 99, with Lawrence Henry. He's confused on the separate option in earnest fee payments, and whether, if we stick specifically with the option first, his question is, do both option payments need to be made before you can exercise the your termination right during the unrestricted option period, right? So I read through and I can see an argument for his language, because it doesn't state anywhere if you terminate before the amended effective date, you don't have to pay the second one. I didn't think, to me, it's not a big enough issue to make a change. But the argument is, even if you want to terminate before you technically owe the second one, you still need to pay it to then exercise it. That's what he's going to say.
I think what he may be saying is, I didn't pay the first option fee, then I became the primary, and then I paid the additional option fee. Do I have the right to terminate? And I'd say no, because of the word additional.
right.
Well, I think he's contemplating that the first one hadn't been paid. Yeah, and so it's just that second.
So he's in breach-ish.
Well, he's not breach because he's paid the first option. And it hasn't, we don't have an amendment effective date. But he's saying this one, I read different, that he says I did, or not I did, but in his fact scenario, that the first one's been paid, but not the second.
Are we referring all these things that should be education to education? Is education?
Well, there's an argument here. I do recognize his argument. I don't think it's at the end of the day, I don't think it'd be interpreted that way, but it's not just a toss away argument.
Paragraph 5D, I think.
Yeah,
I'm concerned about giving an advisory opinion.
Well, no, it's not about advisory opinion. It's about whether it's clarity is needed, right? Or that we should look at clarifying. And it to me, it's not just again, something to dismiss because it could be read that way. I don't think it'd be interpreted that way by the court, but for clarity purposes, do we do anything? I say no, but I'm raising that issue for others to consider.
I agree, it's no.
I think part of the confusion on this form is the way that it's organized, but I will save that for another time.
He wrote in his comments,
You want to join our work?
Well, here's what happened. We tried to clarify what was already a really good form.
Right.
And now we have this issue.
Right.
But he wrote, real estate agents are interpreting the additional option fee as not being required if the contract is terminated prior to the additional option fee being due. And I think that was our intent,
That's
right?
legit.
I think
Yeah.
that is
But
right.
not giving an advisory opinion.
Right,
We believe that it's clear.
yeah, but
That
the
additional
intent.
option money in earnest is not due until they have an amended effective date.
right, because it's
So
additional
if they've
based on
already
the amendment.
terminated, they're not gonna get
And
the
they
amendment.
may
That's where
not have-
I reside.
They may not have chosen to pay additional option fee
True.
to extend it past the.
Yeah.
And I've heard a lot of good feedback on this form too. A lot of
Most people have
recent classes,
loved the new form.
love that. And it seems to have been used quite a bit. He also brings up a good point about the capitalization of option. And I agree that it should be made lowercase, in my opinion, after looking at this. We don't define earnest money anywhere. And when we have an option fee in the contract as a capital option fee, and then we carry on in the language to back up, but then the capital option fee when referring to the additional option fee. But the problem with that is in the contract, it's defined as a specific amount. So let's say X dollars, we define term. And then also we're saying amended option fee capitalized, and it's a different dollar amount for that. And I don't see a need for the actual definition of option fee to begin with, because earnest money is not defined. So I would suggest making option fee lowercase throughout and not defined.
I think it was a carryover from, we reorganized this, right? And we pulled this over and put.
It's in the
together.
contract itself.
Yeah, but it used to be in its own paragraph.
Mhm.
And we pulled it in 2 years ago, something like that.
Oh, yeah. So you're
And
saying,
it
yeah.
was, I think there was a definition that we got rid of at the time, and that's why it was capitalized, and we just left it.
But it'd be a simple change just to make it lowercase. There's no need to.
But we're not pushing anything through other than the certain forms that need to go through. And this is not one of, I mean, the whole contract forms are waiting, right?
Are you
Till
talking
next-
about lowering the term option fee throughout the contract form or just
That's
in the
what-
addendum?
Both, because I don't see, because like earnest money is not
Sorry.
saying it's operates the same way in the contract and it's not defined or not capitalized.
Can you go back to my, is our plan is not to push through the contract forms this meeting, but to do it next meeting. Is that
The
correct?
formal, yes, recommendation for the
Yes.
forms.
So my suggestion would be, I think we're in agreement about that, but let's do a double check. And I'm happy to do the double check. I'll do that as one of my last acts. I will go through and make sure that there's not any reason to keep the capital O.
Sounds good. But
And then then put it on, but put it on the list of things that gets changed.
yep, I think we put in the minutes and
With an
we'll
addendum.
look at
Yeah.
making that lowercase.
Does that
Okay,
make sense?
So with that, I think we're close to the end. I'll go ahead and bring up the other two items to see if there's enough to get the backup addendum. The notice of termination of the first contract was an outstanding item from last meeting. There was something we said we would come back and look at it. Does anybody have a strong opinion on needing an additional notice to provide from the seller to the buyer that the first contract is terminated? It's required, and where it triggers is the amended effective date isn't triggered by when the first contract terminates.
It's the notice.
It's the actual notice. Now whether the backup terminates or not is absolutely based upon when the first contract terminates. But the amended effective date is based separately on when notice is provided.
And correct to say there is no statutorily required form of notice. It's just notice,
Correct.
which heretofore since 19 whatever has been probably the agent sending notice.
Yes.
Or
I don't
using
think,
the
I don't think we need.
Or using the TX. Yeah.
Yeah.
All that,
Has one for the members.
Diane, do you have a?
It's on.
Yeah, Texas Realtors has a form. Those that are realtors use that one for the communication of the amended effective date.
you can use an email.
Well,
Let's let her get a comment.
whatever. Every brokerage I manage is going to have a different policy, and if they want Texas Realtors forms to be used, email, I don't know, I would want that to be defined by by a brokerage's attorney. Is an email going to be the notice? I can't answer that and won't. As far as do we need to do that, there are other notices that I think we could create. The question is going to be, do we want to start doing that? Paragraph 60 talks about a cure period, and you have to give notice in writing. We don't provide a form for that. So do we start looking at that, and is that a coupling we want to do? If so, then the answer would be yes to providing a written form because it says it needs to be in writing. So if that's what the rule statute provision is, then I suppose it's a short form, we could provide it. Do I think it's essential? We've managed to get away without using it for a long time.
But even if you had a form that was nice and easy to put out, but I still went ahead and sent an email and didn't use the form, whether I was a member of TAR and not. It's still legally, I'm not gonna get the exact Texas Supreme Court definition, but were you aware, or did you have notice of it? Yeah. And so the form really didn't even matter. I sent an email that said pursuant to paragraph 7, we out.
Yeah, and I'm sure you're right, but we're not we're not attorneys, we're not in practice law, and just say, oh, an email's fine.
Right, but you're
I'm not
bringing
gonna
up something, let's say we did, just for argument's sake, get in the business of creating notices willy-nilly. Are they mandatory use or are they permissive use? Now, why would we want to make this, the rule about this is in the contract that our predecessors wrote. Whatever.
And in the contract, using my example.
But it's not statutory.
It's
not anything else. It was our deal that we created.
But I think there's a thirst asking for some of this stuff on what is the nature of the notice that I have to be provided. So it's not just a concept pulled out just to pull out. It was something that our last meeting we discussed when we were drafting the form and looking at the experience and request for the form. That was one of the questions that came up, so it's not just talking about to talk about it. It is something that has been brought up to us, and I think today I'm not hearing a thirst for it, but I do want to geek out on this a little bit to go through every one that's a required notice and see what forms don't we have, just for as comparison to do.
And this committee moving forward, things are changing in our industry. And maybe this is one of them, that we don't leave it for the license holder to try to figure out what that communication is, and then they don't do it. And we'll get to paragraph 21 one day, very soon, I hope. And what happens?
And 21's a big question and how that ties in a lot that people don't really understand. Lee?
So I don't think it hurts to go through and see, all the notices and things that we don't have out there. But I think it's important to remember that the average license holder is already confused by the forms we do have and are not aware of all the forms that we already do have. So
And don't know
making
what-
more forms to throw into the black hole of, I didn't know about that, I think a lot of consideration should go into before you dive into that.
Fully agree. Well, and when I say geek out, and for me, geeking out could be an esoteric thing that nobody even cares about, period, on this committee or otherwise. So, but you know, so looking at from that in our directive to reduce controversy and be efficient transactions really would potentially override, you know, your argument of have all this stuff out there is just more things to get to gum things up or.
Well, I do think it's an important thing to decide. I mean,
Yeah.
if we're going to
Go
go
through the
to court,
practice.
are we going to make it mandatory? I don't really think so.
Oh.
Or is it permissive? But that's an important.
That's huge conversation.
Huge conversation.
And we have to come up to, we'll come up to the end. We're almost to the end of the comments and we have the big thing about mandatory versus voluntary with some case law things. I really would like to, for us to
Wrap it up with that.
wrap it up with
So,
that.
Go there.
So page 100, the HOA addendum, concern allows fire to back out for any reason, doesn't think that's fair. Could be tied in.
You missed David Sheehan on the bottom of page 99.
Is that also?
Residential service contract.
It's just going under
Oh,
other
I thought it was
modifications
just
in
an
the amendment.
education.
Oh, yeah, put another modifications. Have there, so reach.
Want to make sure we hit it.
I think Joel has a point.
So this brings up an issue that I see in a particular market. So it's that the buyer being able to back out for any reason with these HOA docs. And in particular, when an HOA, if you check the box that HOA documents are required and they're not provided in a sufficient manner. Remember, HOA docs is subdivision information, which is a defined term in the Texas Property Code. Subdivision information means the resale certificate and the, I have in front of me, the bylaws and restrictions.
And it's something about the financials too, right?
And that's part of the resale
If there's
cert.
any lawsuits.
But to the resale certificate, if an HOA doesn't provide it, and in the big markets, the cities that have the community associations, it's readily provided all electronically. When one of the cities I operated my old title company in, there was only one or two of all the HOAs out there that would provide proper subdivision information. And so if you had a contract in any of those other subdivisions and you check that box that it's required, there's no possible way for that seller to comply with the contract because the HOAs just simply wouldn't do it. And this is the HOAs that are faxing information handwritten in, not using the forms. And the concern he raises is a little different, but it's the same provision of if you should limit that the ability to back out based upon information in the HOA documents. Right. So he's saying if you don't, let's not let them get out for any reason.
Substantially similar information is good enough.
Yeah, well, no, I don't think we go because it's required to be provided. I don't think we go there. I raised the issue because it's a very powerful termination right that anybody I advised up there could get out of the contract legally, tossing it out. So it raises other concerns, but his concern here, it ties into that of how broad it is. And so you get it and you can terminate because you got out of bed on the left side instead of the right.
Okay, yeah.
And not tied to it.
So he's just saying, okay, I get this HOA information and I review it and I decide I don't want to live in this community because the way they run their business is too close to the line or they have
No. He's saying he's not even looking at those reasons. He's saying I'm fine with the HOA. I have found this other house I like. And so I'm going to use this as an unlimited option.
And they're doing that.
They are doing it.
They're doing that. So if we just added similar, what he suggested down here similarly, where it says about termination, just say, terminate based on information in the HOA.
But they don't have to say, and that's exactly the same thing. You're not defining it.
Well, isn't that the same as the seller's disclosure? You don't have to give a reason why during those 7 days after you've
That's
received
correct.
it.
Sure.
So they're
something I don't like,
unrestricted right
or I
to
change my mind.
And that's statutory. So this is something we may not be able to change.
Yes, it is. But the thing is, HOAs add this huge whether you're a fan or not, and I generally am,
Yeah,
you know, but it adds a huge set of restrictions off of the regular bundle of sticks of property rights. I mean, it takes away lots of your rights, and that's pretty important. So,
yeah, and
But I think it's too hard for us to give options for termination based on it because it's going to be such a subjective test.
Well, and I think
I think you gotta let them do it.
I think the other thing is that a lot of times if the selling side delivered all the documents quicker, then they close that gap quicker.
Right.
And maybe that's on the listing side to close that gap.
legislatively, we have to give them 10 days.
Right.
Right, exactly.
So-
But still, there's still ways to close that gap. There's still a lot of
Hurry up with
people not waiting till the last minute to get all the HOA docs in. So there's a way to tighten that up. But even if we restricted it just to the HOA, they're going to come up with something about the HOA they don't like. And there's just no way, like Leitra said,
Yeah.
to govern that.
We see 3 to 6 days in there all the time, which sometimes is impossible, but
Right.
there's no way that you could look at a bright line review and say, well, this is an acceptable reason, this is not an acceptable reason.
Right.
It's just too open-ended.
It's subjective to each and every
Yeah.
individual human being at where they are, and frankly, what happened on day one of the contract may be different on day two. Maybe all of a sudden my dad died and I've got my mother living with me now, and I'm not allowed to have that.
Yeah, and his point was that they said it wasn't an issue, but then all of a sudden they used it, right? So that he was highlighting a specific type of
That's the
case,
thing.
which is different.
They use it.
That's the thing.
And so, and that's really counsel on the sell side, right? If that's a concern, you should tell them, don't check that box, right? That they don't require it.
Don't require
Yeah,
or
have it ready.
get in advance.
Yeah, have it ready.
Okay.
Okay, so POA addendum does not require insurance to be carried. So I'm looking at Chanel, Chanel.
Racist.
101. This is wanting to add something with townhomes, that the disclosure whether insurance, is carried by the HOA for the townhomes. I thought the townhomes weren't distinguished under the law in terms of it's either within an HOA and would be, part of the thing, or, condo it being separate, but not a townhome specific
Yeah.
HOA.
Can't be HOA or condos.
Right.
I mean,
Yeah.
but they could be a condo scheme or not a condo scheme,
Well,
so. it
I think on the
depends.
resale certificate, right, for the property subject to mandatory membership, it doesn't it have the insurance information?
I don't have my,
Is there a category of townhome that's not in an HOA and that's not a condo? Is that a?
yes,
Yeah.
HOA.
just goes under the plain Jane HOA.
Where's the resale certificate? Oh, here it is, subdivision information. Okay. I thought that was in the,
Well, and the insurance is sometimes weird because we just moved into an HOA about a year and a half
yeah,
ago.
got a certificate.
And my insurance lady said, this is the insurance you need. And the builder came back and said, no, the HOA says this is the kind of insurance you need. And in order to get the loan, we had to get this, but then as soon as we closed, we had to switch our insurance because we didn't have enough coverage.
But
because
that's
it was
not what
all-
they're talking about. They're talking about the HOA's insurance
Mhm.
covering the common areas and or like if it's shared roofs. and
Well, that's
things
what I'm
like
talking
that.
about though. They wanted me to get this specific coverage.
It's not
But
your
I-
coverage, it's the HOA's coverage.
Right, but I got my coverage based on what the HOA was supposed to be covering. And then my insurance lady was like, but you're absolutely not covered because their insurance policy doesn't cover this. And so now you still have a gap.
Interior
Right.
contents.
Which is why
Exactly.
somebody wants that policy, so they can go take it to their person.
Mhm.
Yeah, so
So he's asking. she's
the
asking.
resale certificate does require a COI for that. It doesn't require the policy though. So I think if that's what the issue is, that they're getting a COI but not the policy, that's a,
What's proof?
And there's
Need
no.
proof of the townhome insurance. The proof is the COI.
I know, but that is, when you look at a COI, it doesn't give you the coverage.
Money.
Where she's talking about the specifics of it. No,
Yeah.
it'll give you the general comment of what they cover, but it won't give you the specifics. So what you want to do is look at the coverage pages in the insurance. So,
And this language is our language, or was this mandated? I mean, could we at some point, if this gets looked at, put on the list of
Well-
things to change it to policy as opposed to just a COI.
Yeah. And that Mary-
I don't know how you could word it, but I agree with Melissa for the fact that I have one that is a condo down in San Antonio, and all of a sudden now the HOAs has said it's the owner's responsibility to take care of the roof. Even though I'm in the middle, and they have half the roof and they have half the roof, but because they couldn't afford it. The HOA was running out of money, so now I had to change my insurance to cover this quarter of a roof. And it wasn't in any of the documents, and they said, we're out of money. You're.
Well, I've seen those in condos where they're.
But that's a town, that's a town.
Where they're detached dwellings in a condo. But what I'm talking about here is, if you don't have the declaration page, you may be lacking on a full understanding of the coverage. That may be what the question is. I don't know. We could ask for a declaration page here. That might be the solution. I don't know.
In the form, what form are you?
This is the resale certificate.
Which we follow straight out the statute as well, right?
I don't know if I don't think the attachments are in the statute, are they?
They are.
They are? So it does mention the COI only? Okay.
Maybe this one
Maybe look at
deserves some.
deeper
research.
dive into, because my thought where we ended up, the resale is what it is. And then
Well, I think-
because of the
Yeah.
statutory.
I think it would be good to ask for the declaration page out of the policies. To me, that would be, now, I think most prospective buyers are not going to do much with it. But Tony over here, he'll look carefully.
So let me throw a logistical issue right now, because the resale certificate we have right now follows the statute and is what's provided by all of these associations. If we start adding additional items to it, when it's being pulled by so many that are part of their business, it heightens this requirement in many, many deals, not just the limited use case. So where my mind's going with that, it's not necessarily it's a bad idea, but maybe it does with the time of day we getting deserve to look into and defer till next meeting to.
Frankly, this is a legislative
Yeah.
thing, not a contract.
Yeah,
Right.
could be true.
I haven't heard a big problem with it, but I can understand why I would want.
Living out, vehicle, we don't get it.
Okay, at 102 now, Jose, seller financing, wants to change the order, some of the language in there.
Just in language is cleaner, it makes sense.
Didn't we just remove the term?
We did it more Yoda.
So I think the change, and this is a confusing thing,
Installment payments you will make.
results in a 1 month difference that's put in the blank. Because how he phrases it, I think is how we understand, it's better, in my view, more clear. With the existing language, the question comes up, you already make the first payment and then so many payments thereafter. So if you're doing a 3-year loan, for example, it's a number out there, you make the first payment, are you doing 35 more?
Right.
The true intent is to put 36 there, I think. And the way he does makes sense to put the full 36 months. But that was, I always have to recenter myself when these come in of what's the right number to put in after that first one? 35. And so it's always 35, but I don't think many people look at it that way. And I see a lot that are 36 written that come across the desk.
So you like what Jose suggests too?
I do.
I do too.
Do we want to put that in
Okay,
as something
do
to
it.
change now?
I think
Yeah,
it
so moved.
needs a modification for the balloon payment if we do it, I think, at the end. I think there's a little gap in what he has with the payment due at the end. So maybe this is one to, I don't know if we want to look at that now or look at that next meeting.
Well, if we're going to put it in, we probably need to take a look at it quickly now and see.
John George, an issue came up on the Texas real estate lawyers page on the social
Mhm.
that I saw yesterday, which said, complaining about this very form, and I'm not looking at the whole form, but it said there's nowhere for a late fee, if somebody was late, and then what does that do to the next payment? Shouldn't the late fee be taken out first? And there's a discussion about, well, yeah, generally, but there's a case on it, but it's not allegedly, I didn't look, allegedly it's not in the form about what happens, in what order do payments, do the items come out if a payment was missed, late.
It does say to use the state park forms, right? And so in the state park, I believe it says it will be state park forms unless otherwise agreed. And I had to go back to double check. The state bar form might have that built in.
I mean, but if it's an issue, if we go to change this,
Mhm.
and I'm doing exactly what I complained about, I'm adding an issue that I didn't think about until we got this. New.
Well, let's tackle that language that you're saying.
Okay. So, are you wanting to, look at the form for the other purposes you were mentioning?
Or is that the commercial form I'm glossing? It may be the commercial form. It must be the commercial one I'm thinking of.
That would not be a bad idea at all.
For later.
There is a big question on what forms to use and, whether we only set out so many terms with financing, and then we don't. Some of the other forms, I believe, is the commercial Texas Realtors one. Maybe Lori, do you know if that has a reference to the use of the state bar forms in the?
I thought we had a reference in that. Do we have a reference in?
We have a state bar.
What about in the main contract form? Do we have anything on that?
Look.
I have.
And I'm not dreaming that up. It's somewhere.
I have a piece of information / advice that I think ought to be also maybe documented as a general rule. When we get a one-off comment to a specific form, probably outside of the regular contract forms, even if it's a great idea, before we make a change in the vacuum, it would be a really good idea to look at the whole form. So that again, we don't do this piecemeal stuff and where it becomes a little more confusing like we ran into a minute ago. That seems like it would be a good general policy. Not mandate, but general policy.
And help move things along where we could consider it more. If the whole committee shows an interest in the change, we can look at it at following meeting, let's say.
Well, and we've really made use of subcommittees, working groups, and they seem to have been efficient. So like before we would jump on this, it seems like that would be something.
Well, this is a relatively form. It the seller financing.
So again, I wouldn't want to. When did we do it? It's been a while.
I will say this is the.
Between 1 and 12?
It was
22.
This one does come up a lot, and especially seeing it at drafting as far as title goes. When it goes to the title attorneys that handle it, right? When it goes back and see what number of days to put in there, and they put it in there a lot. Incorrect. And I have to recenter myself every time I go to actually draft one of them.
Yeah.
What the
protection is, whenever you're doing seller financing, one of the attorneys, the seller, the buyer, the title company, these guys.
And another attorney I'm gonna be looking at.
Okay, so this is what I got so far. Are we making other changes in the?
Well, did we?
My concern with the balloon payment after the date of note, continuing until the balance of the note is due in, let's see. Let's go back
You
to
want
my
the
comment.
interest only one?
Until.
If you have that last phrase, then continue until the balance of notice is due. But you don't even need that first line.
Is this a deferred comment?
No, we're in the comment. Yeah.
Okay.
I may have forgotten something out of there. Hold on. Let's see.
John, did you see the state bar form were referenced?
No,
I haven't found it yet.
Texas Realtors Commercial, 1801.
There it is. Okay, I see there, 10F, paragraph 10F of this. form states unless the parties agree otherwise, the closing documents will be as found in the basic forms in the current edition of the State Bar of Texas Real Estate Forms Manual without any additional clauses.
Yeah, I think he wants to include in here, shouldn't he say continuing monthly? Because that's what the existing form says. Continuing monthly thereafter for blank months. Is that what he's taking that out?
I'm not gonna have interest.
Sorry, there's one I get paid for. There's this one. One often distracts the other.
Oh, yeah. I don't know if the word monthly adds anything then in that case.
And actually, the way it is right now
I think it's in the.
is good because it says the last payment when the balance of the note will be due and payable.
Yeah, the until needs to be when. That's, I think, my hang up because it until suggests that, I didn't know until was right.
Monthly thereafter instead of monthly until.
There's nothing saying when it's due and payable. It's said until the balance is due and payable, but there's nothing saying when.
You could say with the balance of
It's
the
due and
note being
paid.
due and payable on the last scheduled monthly payment.
Or what if we just change until to when? Continuing monthly thereafter. When? Oh, never mind. That makes sense.
You know,
I'd say until the
well,
note is due and is paid, payable at the very end.
At which time the balance is, the
Okay.
note is due and payable.
well, look, do you have the form in front of you? Let me pull it up real quick because I think,
You know, the way it works, the way it's written now works.
that's what I'm thinking. Yeah.
Just, so may kick this to the working group now?
Yeah, I could see, if you look at 2 right now,
Is that?
you can say in monthly installments of blank dollars, beginning whatever date it is, and continuing monthly thereafter. And now you might say 3 months when it's amortized over 10 years, and then until it's due and payable. So I think it works
Yeah, I
because
think the current really is.
Let's look at where the mistake I see a lot is where I went to, it's not a bad suggestion, is because let's say a lot of notes are, you're going to do a 1 year note or 2 year note, 3 year note, and people are putting the full 12 instead of 11. Or 24 instead, or 23 instead, 24 instead of 23, or 35 instead of 36, always that 1 month difference. So if we suggested it, that's the.
So when they make that mistake, what happens?
it's just 1 month later, it's due. You got an extra payment.
Well, it's not matching their intents, and we don't see the back end of the notes most of the time.
Well, you wrote what you wrote, so you live with it. So if the seller or the broker wrote a year to mean 13 months, well, okay.
Yeah. I don't have a strong opinion. So if we entertain this, then that would need to be, or that's the impact. Maybe just consider this in light of that and bring.
All right, so we're not going to make any change at this point.
I think we need more consideration than we have time for today. All right. So I wouldn't say we're not, but maybe defer.
Okay.
The next one. Because it is, I think. Liz, this is on that one? With me?
Yeah, Liz is
Okay, Liz.
with the historical district that don't allow alterations to the property. Things to be disclosed, which is a great idea, and she should tell the legislator about it.
Or at least tell Sunset Commission.
Good job.
You're really good. Excellent.
This highlights geographic competency.
Right.
Big issue.
Yeah.
You give disclosure about meth labs and you're.
Oh, yeah. Pop up every day.
Because it doesn't incriminate me if I know where they are.
Penny solar panels that are not legal.
Yeah, so this is where the contract requires, the contract itself, the thing that's not highlighted here, requires the seller to pay off any loans that are out there, liens that are out there, which in the property includes fixtures. So this was something that the seller by the contract's already addressing, and then they want to assume it. I think that's something that'd be hard for us to provide a form for.
Right.
Correct.
I thought that Brian told us that, did you tell us that the lessors for these solar panels have their own assumption form?
But not, this is not the lease. This is if it's owned.
If they're just making payments.
Penny said that we got the lease. Perfect.
Yeah, so the lease is done, and we also have it in the contract. It's just tied in the way.
If it's a purchase.
No, I think it's a purchase. That's what, they're just paying a loan.
Correct.
They're not leasing the seller. They're paying the loan.
Right.
Oh,
It's got a lien against the property and it's got to be paid off at the closing, and that's just like
And we
anything
can't
else.
dictate whether it's assumable or not, right? So if you looked at them, that's going to be a
You don't quit. You
Plus-
just.
But they have a priority too. Your main lender is going to require subordination, right?
But it,
If you're going to keep that other existing fixture mortgage on.
but if you're gonna live up to your requirement to sell with, clear title, you're gonna pay off everything.
And at least when I was still entitled, there was different underwriters treated it differently. And whether it's with the UCCs in particular, but whether it was personal property or real property, there's a distinction.
Okay.
Some of the, which goes to the priority issue, and they're willing to insure.
Right.
They're not over.
Okay.
I see that point. I don't think we need to make any change based on that.
Oh my Lord.
So withdrawal, Amber Brown's coming on, wants a notice of withdrawal. Thinks it takes form of flagging because it doesn't address withdrawal of an amendment.
We actually already talked about a withdrawal of an offer, and that's what she's talking about. It's offers, counter offers, offers to do an amendment.
And
I called the lawyer.
I think we need this form and.
any appeals otherwise? Hey, and we have looked at that before. If you're listening, that is one we dove into in the past, and the California forms are stuff in there. Now we have the supplement, or no? Oh yeah, we go there.
Okay, Dave.
I had that. So was Dave the one that had the?
Talk about 12.
Okay.
My note on Dave was
Page 107.
107.
Give him 5.
There we go. Yeah.
Right.
Well,
Can't do anything for Dave.
Well, he was also
For adoption.
referencing 12A1B and page 10.
Yeah,
Which we
so-
hopefully have.
We all read.
Randy gives proposed language for inspection contingency periods. Yeah. Let's see, application.
Bring that to a property condition. Folks like.
And we have addressed that a lot. Any thoughts in particular considering?
State legal thing about option, and it is not. So we have to. Am I remembering something?
What?
Like a case precedent?
John, where are we?
I'm letting her get that out to.
Well, page 109.
109, 110, or 110, we just finished over Randy.
What were you thinking?
It's fine. I don't need to think.
Well, I do think we need to say out loud that in the residential contract, in our other in all of our contracts,
Mhm.
we have an option period. It's not an inspection contingency period, which it is an inspection contingency
He
period.
came from
We
another
call
state.
it an option period, and you can do whatever you want in that period. And you should inspect and do anything else you want.
Yeah, and
It's
he
an
wants to go further
unrestricted-
by saying that after you get past the option period, then you
get
can't,
more.
well, no, you
Well, you
can't terminate. You're deemed to accept the property in its current condition,
That-
which goes against a lot of other.
That's another agent that came from another state.
Back to California.
Okay, so we're on 111 now, Sydney.
Yeah,
Sydney
Sydney.
Young, doesn't like the practice of sellers penciling in changes to the E47. This is I'm not sure, I don't think there's any change that needs to be down in this, there's a blank that fills in the form for sellers to note the changes and
Yeah,
use, so.
and that's what we do.
I'll give us a.
I like we did took her a full 4 pages.
And Sydney, it's a board certified real estate attorney, so. we put that out
Probably wouldn't be
there.
advertised.
I think if you're gonna go that route, you can go what we call the Jacobus route, which was that you don't allow any old surveys. You have to get a new survey.
Everybody gets.
Yeah.
Right.
Well, and it's
Still, isn't that a TDI thing?
Correct. You would just
People
stop.
should be allowed to contract under
old
one contract.
surveys.
I agree.
Right? Yeah.
But I'm not.
And feel free to stop me, and I'm looking a lot this way. Feel free to stop me if you don't want to jump in on any of the questions. 115, this is from Ronald Aaron, longtime California realtor, a couple of years in Texas, suggests changes based upon the California form. This is a lot of offer expiration clauses.
Learn his audience.
His stay takes a little bit longer before he gets to speak.
This week is a bad week.
He's not from around here.
Multiple offers.
Contract's like 48 pages.
Before the addendum.
Before I just move on to the next one, so I think you talked about a lot of these issues. Any thoughts to discuss any of this?
Well, some of this is not our committee. You know? We don't, our forms don't, mandate you to
Bingo.
inform other people. This is not our committee. The commissioners might look at this if they're so inclined.
All right. So now we're at
124.
We're at we don't know where you are. But we're at one.
Too many forms to this together. Mine jumps to 129.
So 124 is someone wanting us to define hard money. And my question is, where would we publish that definition?
Oh, and this is dealt with in context of the term other financing, right? And then the fitting in there. And that's, we put the other financing, meaning it to cover hard money or a mom or dad loan, and having to disclose the lender's name in there or to let them know. And they should know. It highlights the deal, but I on that one, I didn't think we needed to take any action.
Yeah, I didn't either.
Okay, so then we go to the one with all the markups. And
Use it basically.
You just want that in the contract? Why?
I'm gonna look off you for a sec. 'Cause my one's
By all
up
means.
there. Let's see,
Feel free to use the
definitions, okay. Let's see, plumber has an option. This is the addendum authorizing hydrostatic
But
testing.
he wants it inserted into the contract is the number one thing. Plus he wants more stuff.
And he wants more definitions.
Yep, and
Taco test?
when I looked at that, I think we have a pretty good form for the purpose it serves, and adding this additional stuff is.
Well, the only question I had here is in-camera scope considered to be generally out there? Again, this is more for the brokers, something that's regularly done, and do we need a special permission for that to be done?
I think that it is many times done before they do the actual pressure test.
Well, it's sometimes done just to be done.
Yeah.
But the whole thing, about the permission, the camera scope is not going to.
It's less invasive, right, which is why it's done, because
static theoretically can.
might damage something.
Okay.
Right, so sometimes people will say, you know what, we'll just go in and do the scope
That's an
first.
inspection.
Yeah, and if it seems to be a problem, we may come back and do a pressure test.
Okay.
And there isn't.
That answers that.
And plumbers are parties to the contract that we can shift liability on them.
Exactly.
Yeah.
Well, I sure hope it's a plumber doing it.
It says on the form it has to be, by the way, I think.
It does.
Yeah.
Okay, so
I should
126,
say neutral third.
wants a form for stucco test. Here,
That's an invasive.
and
That's still a saying. EFS, I know. I remember they
I have
found out all
to-
the-
Houston, I mean, maybe South Texas.
Maybe, we don't have any like that.
We have sucker tests done all the time.
Oh, wow.
Okay, so
Yeah.
do we need a?
You get a form?
Is, I mean, is it a
Ask,
problem?
do it.
No, I mean, they will, and when the stucco test is done, the agent is supposed to notify the listing agent because it's intrusive. They're going to put little holes in there. And some sellers will say, I don't want my house to look like it has measles. So it raises a concern.
I would say, yeah, you don't have permission to do it without permission.
Right, exactly.
But they just do it anyway?
No. No, because the seller's gonna come home, they're gonna be upset, and the brokerage is gonna probably end up having to pay for the work and their attorney.
Buyer just purchased without.
I
the
mean, Houston's a
information.
big market. If this is happening a lot, especially South Tech, I mean, do we need a form? Is it more than a 5% thing?
I
The ones I,
believe it's more than 5%.
I don't know if it's more than 5%. The ones I've been involved in, the stucco guys won't do it without the property owner signing. that
That's
it can
right.
be done.
That's exactly right. We had a speaker last week and he said the exact same thing. They had their own paperwork.
So it's covered.
So,
Yeah, it sounds like.
yeah, really not even that's, now, if you want a determination right associated with, that's a whole different question, but I don't think that's a question that's coming up. It's just, hey,
Yeah.
we want to get this done. And you're either going to agree to it or not agree to it.
And they're mostly
So
trying to determine if it's EFS or traditional.
If there's mold behind,
If
you know,
there's
it
mold
may
behind.
not be EFS, it
Maybe
may
it's
be the
traditional
concrete,
mold.
but was it properly put on? That seems to
So
have
it's really
been
a mold
problems in-
test.
Yeah, exactly.
Mhm.
It's a mold test behind. The only way they can get to is to get through the concrete stucco. And so, you know, there could be I don't see as much hydrostatic testing being done, and Memorial area is an older area, but as newer construction's going on, it's less and less. And it may be something that could fit on one page, I don't know. But it does say in the contract, you have to have the hydrostatic test improved in writing, and that's the only one that does, but because stucco it's usually on a costly house, maybe there's some validity to it being other than the stucco inspector's paperwork. That's really for our attorneys to decide.
Yeah, I'd say this is a one request that we've had in multiple years and that's not enough.
We can put it on the radar for sure. And then when I see it, it's normally on the back end, right? There's mold behind stucco already. And so we're not going to the.
And this is just sort of a general issue. If a buyer damages the house during an inspection, are they liable
Yes.
for the cost? And we don't have a provision for that. I've seen it in commercial deals.
I just tell them.
That's
to
the common
but-
law.
You know, I don't know that you need to have it.
And this kind of bleeds into another thing, is ASR, right? With the pools where the concrete cancer is that's becoming a really big issue that's out there. And it kind of falls in the same category. That's a super invasive and expensive test, right? You have to drill cores into the concrete. It takes time to do, but it's the same kind of invasive. What's the other word? Invasive, destructive test that, you know, theoretically could have a form. And I see that concrete cancer becoming really public lately. So something else to keep in that same category.
So any consideration should be just a generic provisions in my mind.
I mean, when we have litigation, and you go test out a house or you go test out on a job site, we have a non-destructive testing general form on what you can do, what you can't do, what you're gonna need approval on. All of the generic, if you think you're gonna break our stuff, explain to us what it is.
Yeah, I can see that. That'd be something to think about on that for future.
Okay.
Let's see. Add a definition. That's the one that was before. We would jump to the comments with the lawsuit attached.
Yes.
Okay, so this was sent in. This is an interesting one. That bleeds into several different items we discussed today. And it's the nature of when we say a form is mandatory, what do we mean by a form is mandatory? In the context of this particular case, not getting into the specifics, but a form was used by an agent. In this particular case, it's a notice of termination form with a lot of other facts attached to it. And one side argued because they sent it by email or some other form, not using the notice of termination, it wasn't an effective termination. That's the core of it. Lots of issues in the case, lots of facts that are very case specific, but I think that's the import I got from what they highlighted there. And if we look at our forms, stepping back, when we send one up to the commission and they vote it through, it can be voluntary or mandatory. And when it's mandatory, an agent has to use that form.
Or a trade association.
Or a lawyer form. So we go back to 53711.
Or what the client tells them to do.
And so in this case, the underlying issue for us to consider, I think, is does an agent's use of some other form invalidate the action that is taken through that
Or
form?
no form, just.
Or no form at all. But it really goes to the fundamental thing of what this committee's forms do and how they're to be used. So outside of this case, we only get fact specific. It's up on appeal. I want to raise this in a different context that I think will highlight it without having to comment on the facts of this. Let's go to the HOA addendum. The HOA addendum is a mandatory form in the rules, but in the contract, it just says if they're concerned about it, if the buyer's concerned about it, it should be used. Sure. Right. And then if you look at any of these other notice forms, if you, in whatever context, if an agent doesn't use it, they can be subject to discipline. But does it invalidate the act of their principal?
So if you gave it on behalf of your buyer, the HOA form, it didn't invalidate the concept. Let's say it's a notice form. The seller still got the notice. That doesn't mean it's all ruined. It just means you might be subject to disciplinary action because you, the agent who were required to do that, did not comply. But the buyer is not required to do anything.
They can use their own form. They can hire an attorney. They can use the trade association form. There's other options. Now, there wouldn't be a trade association form if it was a mandatory one, but they still can use their own. And so I bring it to another context that should be used as a highlight of even our attention described in the contract, and not wanting to comment too much on a court case pending. But I will look back to Abby on any further insights of mandatory versus voluntary on.
No, I think you hit it on the head. I think this is more an issue of what contract do versus what contractual obligations between the parties. So I thought it was just an interesting read.
Yeah, they attach each side's arguments, and it's
Very interesting.
A good read, and how attorneys, even on an issue that some of us may think from black and white, can make an argument and litigate. I don't know how long. Spend a lot of money doing it. So highlights our mission, but that's my interpretation of these forms. If the agents do not use them, they're subject to discipline. But the issue whether it's enforceable or not is not based upon whether it's mandatory or voluntary. It's separate for whatever law that is governing that particular issue.
If there's anything that needed to be fixed, again, that's a legislative fix, a fix of a form. And you know, we've had some recent legislation. The foreign person legislation, for example, says that a foreign person from one of these designated countries may not buy property, but the legislation has a fix in it that says, however, that does not invalidate the conveyance. So, I mean, that's something the legislature can address if somebody felt that there was a need to address.
Don't answer this question, Abby, but the question here would be, did they file a complaint here at TREC while this litigation's pending?
Yep. It'd be interesting. I was surprised that wasn't in the pleading or mentioned, so I assumed it wasn't, but. Okay, so then I think is that the end of the materials there? So we had to supplement, Brian, you sent in email, put on our radar.
Just put on your radar, maybe discuss it next meeting. But the FinCEN, the Department of Treasury's Financial Crime Enforcement, if you know, there are right now geographic targeting orders where title companies are having to report certain transactions. They had so much success with it, they're making it nationwide, and they're going to require far more information to be reported on certain transactions. Basically, it's going to be deals where the buyer is an entity or a trust, so it's not a natural person where you can see who the buyer is. And they are not using a financial institution
For the loan.
for a loan. So they're either paying cash or they're getting some other non-institutional loan, which has the effect of it's flying under the radar of the anti-money laundering regulations that all financial institutions have. And so they're going to have very robust reporting requirements. And this is supposed to come into effect December 1, 2025. However, there are a couple pending lawsuits trying to say that they did not have the authority to go this far. The significance, they estimate that there's going to be about 850,000 of these transactions each year. And the cost of compliance on those files where it does apply is going to be in the $500 to $800 range. I don't think it's going to be that much, but do anticipate the party responsible for reporting is the settlement agent, the title company. And those costs are probably going to be passed on in the transactions that are subject to these reporting requirements. So there are two elements that we may want to consider. And those are, number one, requiring the seller and the buyer to provide the information necessary to do the reporting. Because we'll need detailed information of the ownership of the buyer entity, all the way down, who are the beneficial owners, to make sure it's not a drug cartel, for example, laundering money. So we're going to need to get that information. If we don't get that information, the deal's not going to get closed. And so we probably need to have some agreement of the seller and the buyer to provide the information necessary to comply with these reporting requirements, because otherwise the deal's not going to close. And then secondly, a provision as to the responsibility for the cost. We've been looking at it. We think it's probably a buyer cost because it's the buyer who is the entity that the information needs to be reported about. And so then that's going to be the great bulk of the information that we're going to get. And so I think that's something more than just an escrow fee where we provide it's split 50-50. And since this is very buyer centric, it makes sense to me. It doesn't have to be that way, but it makes sense to me that we would make that a buyer expense. So,
I mean, I get 100% what you're saying. It's all about investigating who the buyer is.
Right.
So you think the cost, but if you author the language such that it's the buyer's expense, then have you allowed them to freely negotiate how they want to work the deal? Because the seller may say, hell, I still want this to close. I'll pay your time.
well, keep in mind.
You can checkbox it, buyer or seller.
You could. We say on earnest money 50-50. So we build it in because that's traditionally the way it is. I've been communicating with the council at ALT, the American Land Title Association, and they're just starting to now look at it. They're getting some wording. But I think the general consensus is that there needs to be reporting requirements, and rather than just generally give it to us, maybe 5 to 10 days before closing so that the title company has it and things won't be slowed down.
Is this something you just want to implement or you're putting on the radar?
I'm putting on the radar. I think we don't know what's going to happen with these lawsuits. It may be that a court's going to say that that's unconstitutional to put that burden on private industry. But December 1 is not far away. And so, if it looks like this is going to happen, we probably need to be prepared with something. So I would suggest at our next July meeting, we have contingent language that if it becomes effective, then it becomes a part of the form.
I look forward to seeing what you author.
Yeah.
Yes.
Yes, I gave somebody my email at the end of the email.
I know, I saw it.
Yeah, and I probably would change it to make them give us the information as opposed to just generic.
Well, Tom, and if we can make sure that's back in the next materials to make sure so that way we'll consider if we can have that there. The next, we just have a few comments in the supplemental one. The first one, David, the first one is paragraph 12 related. Denari? Don't know, I apologize for butchering the name. Wants to change the requirements around filling in the effective date of the contract. And
Do it.
yeah, that's I don't need any action there, but if contract's in late, she wants it to be the next day, and it's already a problem to get people filled in to begin with. And
I still like the idea of positive with expiration.
Like commercial,
Effective date is when it's delivered.
Right.
we received.
When received, yeah. So that takes care of your weekend problem.
you want to get stuff. Well, what if you have one that?
Well, I mean, if you're trying to get it received on a Saturday, that's not.
It'll just be a different problem. The agents are gonna get mad at, you delayed for a day in delivering the contract.
Well, I mean, if you think about it, so it's why, so to some degree, you're asking for a longer option period when
Exactly.
you're on a Saturday or Sunday.
Yeah.
So it may work out to everybody's advantage.
And I'm not sure
Miller.
anything. Are you suggesting a change based on that, or?
So I've always liked the data that's received. It's clear, it's objective.
What? Well, I guess I ask you.
I'll be at the door of the
Do you like the way it is?
I do. I mean,
I don't like leaving it in someone else's hands that when they decide to deliver option in earnest, that's when it gets receipted and that becomes the effective date. That,
yeah, I like it the way it is.
I do too.
Well, that's because y'all are
Agrees with us.
on top of things.
Let's keep that on our radar.
You know, you have the general, it's called the parole evidence rule, that you cannot have outside evidence as to the terms of the contract. You look at the four corners to determine what the date is. There are exceptions to that, and one of the exceptions is the determining the effective date of a contract. So that effective date is put in by the agents, but that's not dispositive of what the effective date is. And the parties always have the right to argue that's not the real effective date. The real effective date is the date that it was actually signed by the seller and the buyer.
Well, how do you?
And it's still in after.
To the other.
And all the terms.
You did
Communicated
Stirred in the pot.
back.
And in this day and age.
It's an old issue. This is an old issue. It's an old issue.
Y'all, Ron is making fun of us.
Well,
That is what's happened here.
It's not signed, it's still in after one party's already signed too, so it'd be outside.
We always
that
check the
contract.
effective date to make sure it's correct, and we have had many calls with other brokers to get that modified to the correct effective date.
They're blank about half the time still.
So we should also do the same with the amendment. I'm gonna leave that one alone.
Yeah. Okay, so we'll go last borderline, William, wants to ask if it's within our purview for the disclosure of the selling price for residential properties. That's outside our purview. The next one from Mindy Alford. This is a problem with HOAs or condos or whatever you want to say about the nature of sort of, he asked about the, whether the move-in fee, charged by an HOA, where it should fall within the contract use obligation. And there's just so many fees now.
Yeah,
Once we address it, they just change the name.
Yeah.
So
Yeah,
it's
exactly.
whack-a-mole.
I think they have to look at how the association defines the fee.
Yeah. I think that's, then we have legal holiday, which we didn't address, which I suggest we bring up next time. And what the consensus, even though we have in our contracts, this legal holiday and defining it to government code, what I gather from everybody, in my own opinion, is not tying it to that. And not tying it to the government code as the default we believe currently is, but instead tying it to the Federal Reserve holidays or national holidays. And if we tie it to Federal Reserve holidays, there's a little thing that we have to keep in mind, that the Federal Reserve holidays can potentially make the banks closed on the Friday before or the Monday after, depending on when those holidays are. So I have some suggested language if we say defined as a day on which the Federal Reserve banks are closed. or something, instead of saying a Federal Reserve holiday, because the actual holiday may be observed a different day.
I'll tell you what, here's what really works, is you take the government code definition of a national holiday, which is New Year's, MLK, President's Day, Memorial Day, Independence Day, Labor Day, Veterans Day, Thanksgiving Day, and Christmas Day, and you add the Friday after Thanksgiving. But the way we have it written up in the proposed draft, we are also going to include Confederates Heroes Day, Texas Independence Day, San Jacinto Day, Emancipation Day, Juneteenth, that's okay, and LBJ Day.
I think what you're saying, we should just list them.
Well,
I like that when the banks are closed thing.
if we just say national holiday, then it may not catch the day they're actually closed.
Just list what he just did. Just list, these are the freaking holidays.
Then somebody will protest.
I think it's
And
a good
that's a
idea.
definite thing. Anybody can Google Federal Reserve holiday and easily find it. Right? It's something that's not hidden. It's out there. The title company's closed.
But you threw me off when you said there's some quirks on some of the days where it closes early or later. And I don't like what they're doing with the interest rates. I don't want to tell you. I don't want to connect with them at all. I don't like them.
But I know everybody's tired and we had some that had to leave.
One comment we can address when we get back, but I didn't want to forget about it, is related to your change in paragraph 12, AB, what you had changed to buyer's broker. We actually use the term other broker.
Thought about that.
So do we want to put in a parenthetical right at the end, buyer's broker, and then parentheses, other broker?
And I thought about that of in the context. I think the thing other broker outside of being listed on there is not readily understood. I mean, outside, if you're looking at it in context.
Or you just change other broker throughout the contract. I don't know if you want to go that route.
You know, I almost, especially with the law change, this is clicking my head, but the law change where no sub-agency, it removed the potential blurring of the lines there. So you're either going to be a seller's broker or a buyer's broker. So I think we can almost remove the other broker without any issue.
Assuming that statute becomes law, we could make that change at the next meeting and just use the term buyer broker instead of other broker.
I think that'd be a huge help.
Yeah.
And I thought about that issue, but not about changing other broker, but that's me.
All right, we'll address that at the next meeting. And then on legal holiday, I think Trek should adopt a rule that defines legal holiday, and we just refer to that.
I like that. Well, I did bring it up at the meeting, was it 2 meetings ago? When I did my presentation, I highlighted it to the commissioners that it was on our radar and asked them to think about it at the time.
What did they say?
I believe Chairman Woodruff and maybe Chance comment. I have to go back and watch. There's some comments of generally what we're thinking now. I don't recall specifically, but I think a couple of them have commented along the same lines. So it's on their radar at least, but I think they're now expecting it from us.
Because there was, I don't remember where I heard it, but there was someone that, they were counting the days and someone called a stupid holiday and tried to get their extra day for earnest money and option money. It was like wildflower.
Right, and I guarantee you.
I mean, it was something really stupid.
If we put in the definition in the contract and we have Confederate Heroes Day, somebody's going to use it.
No, I thought we were taking that one out.
Yeah, well, we should.
He's saying the opposite. If we
On the Federal Reserve, I think the Friday after Thanksgiving, it is not a holiday. Banks are open the Friday after Thanksgiving.
Yeah, and before the
Maybe
day
you're
before
right.
Thanksgiving as well.
They just can't, they can't be closed 2 weekdays in a row.
Is there a federal courthouse holiday set up?
Not that I'm aware of.
I can give you the definition.
Judges are always off.
What's that?
Official federal holiday?
September.
Holy days of obligation.
Opening day.
Yeah, I'm taking.
No, you don't want to take that one?
How many days are included?
It's Texas Independence Day back in.
Okay, so I think that's all the comments. Trying to find the agenda.
I think you just have, the leases, if you want to talk about that again, maybe in the table that, and then, the minutes. No.
So do we want to
We need the agenda.
I'm trying to think of the item.
Well, the leases, I think the leases are what we have proposed, fine, on the lease change. I don't see any problem with that.
We're not sending it up right now, or are we? After July.
It wouldn't be sent until August,
Yeah.
for the August
Yeah,
meeting
to the August
anyway.
meeting.
So then we can look at that when the others that had to leave come back. I'm not sure, we talked about it, but we didn't dive in and show them exactly
Take a
what
look at
we're
what the change.
taking out.
Did we decide on a work group and working on some of those? We didn't really hear people.
The big one is going to be that we need to get a working group on is the buyer representation agreement. So I know Lee supposed to do the last song dance. So who is first ask for volunteers on that? You do or don't?
I have a buyer representation agreement, so I'm good.
Maybe not
Hey, we
long.
do too. We use
Yeah.
our
I would love
more,
to,
but
but I can't make the time between now and July.
Yeah.
If we can do it for post-July, I'm down.
I'll volunteer myself.
I can do it.
I think the brokers should be involved because we know what the other one looks like. Not that we're gonna copy that by any means, but I think that's gonna be a mess.
yeah, I'm open to it. It just between, like Tony said, between now and July, these next 4 weeks are really tight on my schedule. So it just depends on if I can make the meeting when
Can I
you
make an alternative motion?
Sure.
That you come up with a draft of what you think is appropriate, bring it to the committee.
Second.
I don't mind doing that. I mean,
Because we're not gonna do anything immediately with it.
right.
Yeah, I
Well-
think that's a great idea.
John, just do a chat GPT.
It's scary out there. The ChatGPT scares me. And 1 + 1 = 5 in so many cases, especially with our truck. And I'll say this for everybody listening and replay this video everywhere. Google any particular issue that we discuss that we know you're confident in and see what ChatGPT spits out. Because there's such little, I think, contract authority or case law authority out there, or lack of a lot. It is wrong more often than not when you ask a non-obvious question.
Yeah.
And even the obvious questions sometimes are completely wrong, and it doubles down. Unlike some other things, I said, well, you're wrong, please recalculate, and it spits out the right one. I've had it 3, 4, 5 times, still never gave me the right answer on what otherwise would be a pretty basic truck rule problem.
I've played around doing the same thing, and it's like, wow, what if agents are looking at this and taking this as fact?
Yeah.
John, if the law goes, when the law goes into effect, about all license holders have to have a buyer rep agreement. Is there anything written that says you have to, if you're a license holder, you have to use, which one comes first? The Trek one? Because it's a promulgated form? And what happens to the Texas Realtors one?
If it is
Do we know?
promulgated,
I think it had to be
it may not be promulgated.
In my
It
view,
might
it'd
just be optional.
it would be a voluntary form to where it wouldn't be to the exclusion of use by the trade associations is where my mind is right now. Because we can't dictate, I think, the private business dealings between the buyer and the buyer's agent. And I don't really like having this form for all the reasons we discussed before, but I just fear the consumer protection side is trumping a lot of my historical concerns.
Have you read, has anybody read the legislation? You just happen to have it.
I'm doing a class on this in a couple of weeks and we're putting a couple on, but I've dove into the minutia of it and the requirements and the changes when it came back from the House. They threw in another provision that about you can't be exclusive from certain things. And there's been following this as it's gone along. And I will say, if you look at the versions out there, make sure you look at the enrolled version, because there have been changes as they're slight, but if you don't look at the right one, you may miss it in there. So
it leaves it open that a brokerage can decide.
I would argue that it did leave it open so that Trek could promulgate one, but Trek could also, so I still use the word promulgate, you put one out there for voluntary use.
Yeah, so that's not
exactly.
More than one version out there.
Okay, that's good.
It would still be promulgated, just voluntary use.
Well, it's a standard rule. We promulgate a form and you can still go with a trade association, our form, a lawyer wrote. I mean, you still can
So the trade association can't do one for which there's a mandatory use
Correct.
form. So that would be, that's why I was saying it's voluntary, because we don't want to supplant
Right.
what Texas Realtors has. And what I'm envisioning at the end is having it basic. We don't want to dictate business dealings between buyers and buyers agents. And to me, it's having at least a small baseline out there for those that don't use another form that's available through an attorney, that's requested by the client or the trade association. There's something rather than ChatGPT.
And is there another form out there that's part of this legislation that says, kind of like the IABS, that you have to, all license holders before they show a property have to give a form to the consumer and tell them that later on or soon thereafter, or maybe, I don't know, I haven't read anything, that then they have to enter into a buyer representation agreement, that it's a two-step process?
It is a two-step one, and it's a modification to the IBS, it's 588B1 or something that adds another thing that's effectively will add the notice that's required to the IBS.
So will it change the IABS or be a second one?
Change the IBS.
Change the
So
IABS.
it'll all be in one?
For the notice, when you're not representing somebody and opening up the door.
Your dating form will be on the IBS.
As soon as you represent them, meaning any advice or opinions at all,
Yes.
then that triggers the written requirement
Okay.
that then has requirements in there that what has to be in the buyer's rep.
Can I ask for clarification? You're putting a signature line on IBS?
No.
Huh?
No, so the rule says you have to provide it. You don't have to have it doesn't say how to change, right? It said this has to be included in the IABS form. It doesn't say IBS, but and with that, I can tell you the exact thing it says.
The consumer does sign the IABS.
It talks about.
They initial it?
IBS.
They initial it,
Describe
yeah.
the obligation.
We used to sign. If they even
non-represented.
So I think
Now we're in the
Not
mandatory.
So the addition to IBS would be describe the basic obligations broker has to a party to a real estate transaction that the broker does not represent. That's the phrase.
But I think to Diane's question, it's going to be two forms prior to opening the door. IBS, and then even if you're in a non-representation scenario, you're still getting an obligation from this.
And it wouldn't replace if I'm gonna go out and show and I've already got a buyer rep signed. At the same time, wouldn't I still have to give them an IABS?
Well, you gave it to them. They signed the buyer rep.
Yeah, okay.
There shouldn't be any change in your practice. on
And but when he said if it was non-represented, but you're already represented,
There's not the written, I don't think you have to have it signed though, right? So the first one, when you're just going, I think it can be just the IBS. If the trigger says before a broker may show real property under subsection A, right? That's the shown without thing for the party. They must disclose to the party as required by section 558B if the broker represents the owner of real property, or provide the party the written notice described in 558B1, the IBS, if the broker does not represent the owner of the real property. So it doesn't have it's just the notice in my reading of it, not something that has to be separately.
But
Signed.
isn't it linked back to the next section, the written agreement required, because it talks about that 14-week period and it talks to, that's the new.
The new 562, so if you go to the written requirement, a license holder must state, let's see, must include, require before showing or presenting an offer. So that was when, if you perform, I thought, any act of real estate brokerage other than just opening up a door. And that's the trigger point for that. But I opened it to clarification. I didn't read it as my initial reading on it was two separate ones. And as I dove in, then I thought it's maybe just I read it as just the notice and then separate. My big concern is it's practically hard to just open up a door.
It is, and agents would violate that all day long. My question, and you may have answered this and I wasn't listening carefully enough, when it talks about opening a door, does the listing agreement cover all the agents in that particular brokerage for any agent opening that door? Does the listing agreement extend to all the agents under that brokerage, or is it their license holder?
I would think so, since you're all acting on behalf of the broker.
That's what I think too, but I'm just curious if it specifies that.
or is that gonna be an education process? Holy.
A license holder.
We're still recording.
So you don't individually you have to act by and under your broker. And so I think the license holder having to have a written agreement, they wouldn't have a direct one anyways. It'd be through their broker on which they're acting as
So if
on their
the,
behalf.
as the brokerage, any listing agreement we have, all of our agents would be covered if it's our listing to open the door on that without a buyer.
Because it's ultimately the buyers, or the client is the client of the broker, not of the
Right,
individual agent. So I think it would necessarily,
Right.
I can see the low ambiguity, but I think it's pretty, at the end of the day, it's buttoned up
Okay.
on that.
Okay.
Initial thought.
People manipulating that.
Well, if they do the buyer rep agreement from the
John, what-
beginning, we don't even have to work.
Exactly.
We just train them.
Yeah,
to read the
okay, yeah,
buyer
so-
rep
Man, I'm glad
agreement.
I'm glad I booked the second night.
Yeah, so no, well, and this is why I need the July meeting, because this is a big issue, right?
That is.
And we need to dive into it. It's brand new. It's not yet even law, but it's about to be. And so, but yeah, so we'll tee it up. I think with that, the minutes is the last thing that we need to look at from last meeting. It's just this meeting's minutes.
This is today. Is Corey R-E-Y or was it R-I?
Corey, do I have your name spelled correctly? I thought your name tag said something different.
Two R's or one?
Eric,
Hey, one R.
here.
Just like Lori.
Erica was not here?
Yeah,
Erica.
there you go, just like Lori, but with a
Ron,
C.
one R.
What's that?
Where's that? Oh, one R?
And Corey.
Okay, Erica McPhail, E-R-I-C-A. Capital M, P, capital P-H,
You said McPhail, P-H-A?
P-H-A-I-L.
And no K.
No K?
There you go.
What?
Brittany
What
spelled
about,
Brittany spelled? How you spell your name, Brittany?
E-R-I-T-N-I.
That's why weird, not the other way.
You got an extra I.
Have it.
You got an extra eye.
It's
Damn,
not
Ron.
Bettini.
Bettini.
It's.
She's Italiana. Italiana.
I want to know who's gonna teach.
Oh, Holland, not Holman.
We're gonna hire somebody.
That's up to y'all.
I'm sorry, what is it?
Holland.
Holland, okay. He's Dutch. then.
I nominate Watts.
One L or two L's?
Who else?
John, do we know who's taking the places yet?
it'd be at the August meeting that they'll.
The August meeting they'll vote in? Okay. You driving? Yes. I was gonna offer you to go to the airport, but you have a car.
I'm driving. Eventually, whenever John lets us go.
I'm telling you.
I know, we're gonna have a lot of traffic we're gonna be sitting in.
I think if we go past two, it should be mandatory to have margaritas.
Except that you have
I
to,
like
if
that
you gotta
rule.
drive 3 hours after the margaritas,
Stay and just drink all the way through the evening.
I don't
Or
think
just start
the
the margaritas
government
at-
budget is gonna give me a second. I
I'll
mean,
pay for your
I'd
margarita.
pay.
I'm lucky to get the
Yeah.
hotel one
Yeah.
night. I don't.
Everybody good with that?
Yeah.
Yeah.
You didn't even read.
Nobody even.
Lame duck anyway. You do have one more meeting.
It's, so I've been told.
33.
This isn't correct, 7F3, right?
It's the same forms we've been using for like 30 years.
No, he's gonna be coming to the meeting,
The gap is
sitting on the side.
should I go home? It's gonna be a parking lot.
It shows.
I'm gonna walk and get a margarita. I have no idea how to drive home.
No package quicker than 35.
Beaumont.
I got Brian Sledge
Walking
calling
to
me.
get a margarita. I'm not traveling that far.
It says should or should the, or, oh, it should.
If I should,
Did he-
the clerks would not get in the car.
Did we just say should? The park?
6, you might as well just sit down and relax.
Let's see, where are you
Right
trekking?
there, right there.
It's a little bit better now that session's over.
Should or should not, yes.
And you see that.
Should or should not, or just say
If you gotta get out there, it's over. You can just say, Wednesday.
Yeah.
Whether the commission should.
Back to 183.
Oh, there you go.
Okay, I like that. That's a good change, Brian.
You do a great job with this.
Brian is so
Like I
articulate.
said, who's gonna replace him?
I gave a running commentary and you put it on paper. Ron's old fashioned chat GPT.
Back in my day, we had Ron Walker and we were.
You can do it. Absolutely. I'm surprised we don't do AI transcript this whole meeting.
That may-
I think that is
We might be getting AI trick.
I agree.
there are things you say that we don't want AI to put in the report, I think.
You don't think so?
You just
I don't
point them
think so.
out.
We can edit out.
Teams has a feature that does automatic transcript if you record it.
Yeah.
And it is transcribed in the version you
scary.
get online.
That is scary.
There's things that I don't think we want in writing.
Meeting.
Oh, I'm sure it is. Yeah.
They're we're on all my Zooms now,
Uh,
right there.
On all my NAR meetings, we have to make sure they're turned off.
Next page.
Good.
And it's now
Is the
3:40.
committee set for that biorepresentation agreement?
I think
Yeah. If
John is.
John is the
Oh,
committee.
that's
anybody
right.
wants to help or
No, I get
input,
it.
feel free
That's
to.
right.
I'm afraid to say anything.
He feels very strongly that it's needed as a voluntary forms, so we've made him his own committee.
I'm good.
Geeking out committee.
Yeah, the geeking out committee. So, well, I do feel, I am torn on that one. I won't take any more
Yeah.
time on this. I think that the minutes look good. Motion to approve.
Motion
Motion.
approved.
Second.
Favor?
All
Aye. Aye.
Done.
Okay, so
Thanks,
we'll
John.
officially adjourn at 3:50 p.m.
Thank you.
I think we'll be writing that. Start.